Good morning, everybody. Hope that your Wednesday, February 22nd, has started off well as we go into day 22 of the Murdaugh trial. According to some, it's day 20. Depends on whether you're on, lunar or solar calendar, I guess. Okay, I guess it depends really more on whether you believe in counting days of jury selection. So, anyway, yesterday we saw Buster Murdaugh come in and testify and really present himself with the panel, at least, including myself, thought was a great deal of credibility as he was explaining the background of his whole life, what Paul was like, what Alex was like, and they never asked him the question point blank, do you think your father killed him? Never asked him that. But he portrays a very loving family, and some of the things that the testimony he provided seemed less focused on like what his thoughts and feelings were, rather than testifying about specific points that seem essential for Alex's defense. For example, that he was with Alex from the night of the murders, after he was called and drove a couple hours when he learned of the murders and called by his dad, that he came running back and found and basically spent the next week with him. It leads a lot of people to question, seeing as how there were mere minutes for Alex to hide guns and if he is the killer, that he would have had mere minutes to hide the weapons and clothing, that he would have had only a temporary place. He probably would have had to get rid of them at another time. When did that happen? We also heard from the defense's expert testimony, and today we're going to day 2 of defense's case in chief. We heard from him saying, basically, the shooter has to be someone a maximum of 5'4" tall. He said somewhere between 5'2" and 5'4", which and he spent a couple hours on cross-examination from a lawyer from the prosecution that I personally was not very impressed with. I thought that he was pushing, trying to get his point in ways that seemed more argumentative than actually deflating anything. Anyway, that's where we're at. That's what's been going on. Today, we're picking up with day 2 of the trial, and the court is not in session as of yet. I'm keeping my eye on that over here. I'm expecting to be joined by Andrew Branca, as well as potential criminal Sean, legal vices. We'll see when they pop in here. Obviously, I'll bring them up to you. The one thing I wanted to tell you is with respect to my personal schedule. So tomorrow is the bris. Tomorrow morning, I'm going to have my grandson's bris, which means that tomorrow morning I'm going to start a little late, probably. I want to estimate 11 o'clock. I'm probably going to set the stream up for 10 a.m. tomorrow morning. I do plan on continuing streaming while Nick is unavailable to stream, Nick Ricada. So, but I'm not going to be able to stream until around 11 a.m. So I wanted to give you all that heads up about that. So that you can, if you don't want to miss anything, I plan that the way I'm going to do it is, when I join, I'm probably going to start behind and run through and catch up. I think that's the best way to do it. I might take a poll on that. Should I just jump in from 11 o'clock? Or should I try to play catch up? Anyway, we'll see. But now, it is get out your popcorn, get ready, because trial is about to get underway. If you can just confirm that my volume levels are good, I'd really appreciate that. I know you don't hear anything yet.
Morning. Ready for the jury?
Mr. Griffin has a matter he wishes to address with the court.
Yes, sir.
Good morning, Your Honor. We are discussing with Mr. Murdaugh his right to testify or not testify. And one of the issues that has come up is the scope of cross-examination that the state would be permitted to go into should he testify. And the the basic rule is when the defendant takes a stand, he waives his Fifth Amendment privilege as to matters to which he testifies on direct and relevant matters subject to cross-examination. Your Honor has let in, over our objection, evidence under 404B of financial misconduct.
I discussed this 2 weeks ago.
What we're asking is for an order excluding the state from being able to question Mr. Murdaugh on cross-examination matters related to the financial crimes that's been
what
put
does he
before
do?
the court under
What
Rule
does he do with the
404B,
financial crimes if he gets up there?
if we don't testify about those on direct examination. And we need a ruling from the court at some point in time today before tomorrow. We're not putting them up today, but we're asking that we be able to advise him of what the state will be permitted to go into on cross-examination should he choose to testify.
Important question. Very important question.
Adequately advise him and for him to adequately waive his right and his Fifth Amendment privilege and testify or not.
It seems very prejudicial to allow them to ask him.
Review with him at this time his right to testify or not testify?
Not at this point in time, Your Honor. We have to, we're trying to get an understanding from the court as to the parameters of the waiver of the privilege. Is he waiving, if he testifies about the murders, is he then subject to cross-examination about the financial crimes? That's what we're asking.
All right. Mr. Waters.
Thank you, Your Honor. May it please the court. First of all, obviously the general rule is that cross is generally wide open, and that goes for a defendant who testifies. Your Honor, Rule 611B on the scope of cross-examination expressly says that a witness may be cross-examined on any matter relevant to any issue in the case. And of course, Your Honor has ruled through 404 and 403 the financial matters independently relevant. But the rule goes on to further say, including credibility. So even if that had not happened, these matters, which go right to the heart of the credibility and, frankly, the extensive dishonesty of this defendant, would be relevant if he took the stand anyway, regardless of the 404.
It's
so independently, under that rule of the credibility aspect, it would be admissible under Rule 611B. But again, Your Honor has ruled these matters as relevant in the case, and so that clearly within the scope of cross. Your Honor, citing State v. Gilbert and Gleaton, 273 SC 690, they said right there, as I think the defense recognized, when the accused takes the stand on his own behalf, he waives his privilege against compulsory self-incrimination and must answer all proper questions. Your Honor, Taylor v. State, which I believe may have been ruled on other grounds, but 258 SC 369. When the appellant elected to testify, he waived his right against self-incrimination and became subject to cross-examination like any other witness.
This requires discussion.
And then finally, citing the U.S. Supreme Court, Brown v. U.S. 356 U.S. 148, it says, it's talking about a defendant in a criminal case. It says if he takes the stand and testifies in his own defense, his credibility may be impeached and his testimony assailed like any other witness, and the breadth of his waiver is determined by the
He researched this. He knew this was going to come up. He researched
set forth to the jury all the facts which tend in his favor without lying himself open.
You're correct.
To a
they do not want to
cross-examination on those
testify.
facts.
Those
are the general and well-established rules, Your Honor, and they're particularly relevant in this case. And so we believe that those financial matters would be well within the scope of this particular matter and authorized by the rules in the case law.
Mr. Griffin.
Yeah, just briefly, Your Honor, with regard to credibility, the rules are pretty strict as to what evidence of criminal conduct can be used to impeach a witness's credibility, and there are limited to convictions, and that's Rule 609. Your Honor has let the financial evidence in under theory of motive, and you've done a 403 weighing test. And Your Honor, I think when you get to cross-examination of a defendant, I think Your Honor has discretion under Rule 403 to prohibit the state from further inquiry in this case on the.
You there, Joe?
Yeah, that's not me.
Okay, just checking. Wasn't sure if it was me.
It's not you. It's law and crime. Trying to. Oh, come on.
So are they planning to call Alec as a witness
they were
right
saying
now?
that before, while the question that they're asking him. Oh, come on! We need to hear this. While they're trying to, I'm going to try to see if I can find another feed while we're doing this. What Griffin moved to get a ruling from the court as to what he can do, what the state will be allowed to cross-examine him about if he decides to waive his Fifth Amendment right, given
aspects of truthfulness and untruthfulness, which this clearly goes to, as well as 608C, which talks about bias, prejudice, and any motive to misrepresent. And again, we're not just talking about purely dishonesty and credibility, which I think is alone more than enough. We're also talking about examination on issues that are specifically relevant to this particular case based on the 404 ruling.
Rule 607, Rule 608, particularly the portion of 608C, evidence of bias, prejudice, or any motive to misrepresent may be shown to impeach the witness, either by examination of the witness or by evidence otherwise adduced. Rule 611 and 609 also addresses the issue. I am not going to issue an order in advance limiting the scope of cross-examination.
Of course not.
Any objectionable matter must be addressed as the evidence is presented and not based on any advance ruling by the court.
Lord. Basically, hang yourself is what he said.
Your Honor, the request for the ruling is not an evidentiary ruling. It's the scope of his privilege. And so would he be permitted to assert the Fifth, for example, if they're permitted to ask questions such as they intend to on cross? And that's...
I can't give you any advisory opinions about the evidence and the scope of cross-examination, the scope of his privilege.
This is why in limine exists, folks.
That's
for this purpose.
I'm willing to
He's supposed to be given
review with him the scope of his privilege against self-incrimination, if that's what you're referring to.
We will certainly need to have that colloquy at some point at the end of the day, perhaps. But
for the court to issue some blanket order limiting
Why not?
the scope of cross-examination, that's unheard of to me.
What are you talking about?
again, Your Honor, I'm not. The question is the scope of the waiver of his privilege when he gets on that witness stand. That's
Yes,
what we're asking for.
the
not
consequences
not
of that
evidentiary
action.
ruling.
Mr. Waters has some cases there that I assume he'd like for me to look at, and if you do, I'd be happy to look at what you have as well.
Okay.
Anything else?
We need to walk you through what is happening, the arguments that are being made, because there are
Bring the
fair
jury.
arguments on both sides. While they're bringing the jury in, so that was just a motion that was brought by Jim Griffin, counsel for the defense, to have a limiting, an order that would limit the state from cross-examining Alex about his alleged financial crimes if he decides to get up and take the stand and waive his Fifth Amendment right. Now, here's the key thing, which I think I discussed with you, Alex, a couple of weeks. Andrew, I called you Alex. I discussed with you and Nick a couple of weeks ago when I was talking about now that the judge has let these financial crimes come in, how does that impact his ability to testify? Obviously, you're all aware of the fact that everyone always has a Fifth Amendment privilege. The question is, are they going? You normally cannot just ask about crimes that there's no conviction, and it would be improper for them to cross on that issue. The question is, would they be allowed to cross on this? And if he gets up and takes the stand on his defense of a murder trial, can he all of a sudden end up being forced to be deemed to have waived his Fifth Amendment privileges with respect to pending fraud claims? And that if he can't take the stand because he's worried that if I take the stand, I'm going to lose on the fraud case, you're sort of really hurting his rights to defend himself here. And At the same time, the state is allowed to ask about any acts which show you're a dishonest person. So it's really not that black and white. It is a complex issue. It's a very complex issue, which I've only begun to just scratch the surface of. There's like several issues that we can discuss that are laced in there.
Mark Ball, B-A-L-L.
Mr. Ball, will you tell the jury a little bit about yourself? Where are you from? What do you do?
I'm a lawyer in Hampton. I practice with the Parker Law Group now. I've lived in Hampton for 20-plus years. I now live in Rome Gully here in Colleton County. Have for about 8 years, 9 years. I practice mostly
How
civil
long
law.
have you been a lawyer?
33 years.
Okay. And where were you born and raised?
In Ballantyne, South Carolina, up above Columbia, about 20 miles.
And when did you move down to this part of the state?
I started with the law firm 34 years ago. I moved down. I was a law clerk at first and have never left since 1988.
Do you know the defendant, Alec Murdaugh?
I do,
How long have you known him?
34 years.
And did you practice law together?
We did, about 20-something.
Did you become personal friends of his?
Yes, I mean,
And were your family friends with his family?
yes, our children grew up together, as did everybody in the firm.
And your wife, Lisa, would she become good friends with Maggie?
Yes, sir.
Okay. On the, do you remember the evening of June the 7th,
I do very well.
2021?
Yes, sir.
How did you learn about the tragic murders of Maggie and Paul?
It was about 10:30, and one of my partners, Ronnie Crosby, tried to call my phone, and before I could get to it, he called my wife's phone, and she handed it. He said, hand mark the phone, and he said Maggie and Paul had been shot and get over there. And so I scrambled and got over there. I live about 8 or 10 miles from there. I live over in Rum Gully, and that's Moselle.
And why did you go over there?
To find out what was going on, to see what I mean, we're out in the middle of nowhere, and somebody calls you and says your law partner's wife and child have been shot. You go. I mean,
And who did you go with?
I went with my wife Lisa.
And when you got there, who was on the scene? Do you recall?
Yeah, I came in by the cabin, what's referred to as the cabin side of it, and there was a ambulance was pulled up next to what I would call the hangar building. It was pulled up there, and then Barry McRoy's vehicle, he drives a SUV of some type, and then there was a police car pulled off to the right-hand side, probably 50 yards before you get to them, and I pulled in right behind them on the left-hand, or the right-hand side of the driveway coming in, and then walked over.
Will you remind the jury who Barry McCoy is?
Barry McRoy is the chief of the fire and rescue here in Colleton County.
So when you arrived, I think so Barry McCoy was present?
He was there. He was standing there speaking with a deputy, and there were 2 EMT paramedics standing over near their ambulance.
And when you pulled into the, I guess the lower driveway by the cabin, had any roadblocks or barriers been put up to stop cars from coming in there?
None. I got there about 10:50, 10:52, something like that.
Did you have a conversation with any law enforcement officers about the need to block the entrance?
I did eventually. I was talking to Barry about, I had found out just before I got there, somebody had called me, and they work with sort of the maintenance side of fire and rescue, and they had come across the radio that there were 2 dead. So I suspected that Paul and Maggie had passed away. So when I got there, I was talking to Barry and asking him some questions. I could see Randy kind of through the alleyway between the dog kennel and the sort of wing shed that comes off of the hangar. And then Buddy Hill, the sheriff, came over, and then I spoke with him.
And did you talk about the need to block the entrance into the Moselle property off Moselle Road?
We did just briefly. He said, I need to get this blocked off. And I think he took a phone call or something. And I walked back to tell my wife what was going on. And I saw another deputy coming in, so I walked out to the head of the road there, and I said, I think the sheriff wants this blocked off. And then I walked back to where Barry McRoy was. And then...
Did that entrance get blocked off?
No.
What happened?
People just kept piling in. I mean, it was just more and more people kept showing up.
Roughly how many cars do you think piled in?
I don't know, because shortly thereafter I walked around to the other side, but there were a good many. When I walked back over there an hour and a half later, there were a good many cars over there.
And when you say you walked around the other side, I don't think we need a diagram, but just tell the jury what you're talking about.
Well, there's a dog pen. From where I was standing, the dog pen would be to the left. The aircraft hangar with two wing sheds coming off of it would be directly in front of me. There's a skinning shed that would be to the far right, and then directly across from the hangar shed, probably 50 or 60, 75 yards, would be another storage shed, equipment shed. And so I walked down almost to where the skinning shed was, and then back around in front of the far shed, the equipment shed.
So you did not walk directly between the shed and the kennels?
No, sir.
You walked around the shed?
Correct.
Before you walked around the shed, did you stand and observe what was happening within the taped-off area?
I did. I mean, people were walking between the dog pen and the law enforcement, and responders had walked between the two areas, the wing shed and the dog kennel, and I could see where Paul was, but he was covered up. Barry had covered him up.
And what was the weather?
It was misty. It wasn't really raining, but it was one of those kind of foggy days or nights that it's more than just a fog. You get wet. And eventually it got where it would drizzle off and on, and later on it didn't rain hard, but it would intermittently sprinkle in that kind of floating heavy fog.
Did you make any observations about water coming off the roof of the kennel?
I did later on when I got around to that side.
Okay, what observations did you make?
Eventually the water was running off. That dog kennel is built with a small cantilever on the front of it, and then a longer part off the back, and water was dripping off of the front of the shed where Paul was.
Was water landing on Paul?
It was.
And could you see where the water would then accumulate after it landed on Paul?
It would drain off. There's a cement apron right there in the front of that feed room. And there was water there. There was water in the gravel to some
Carolina
degree.
way of saying that.
The grass was wet. I mean, it wasn't raining so hard that, you couldn't just stand there without an umbrella, but it was drizzling enough that you were getting wet.
It was insurance.
The fact
grass
that
was
you
wet.
observed water dripping off the roof onto Paul's body, did that concern you?
It did. It did.
Why?
Well, one, I didn't think that, it's a crime scene. You don't want just water dripping all over the place, but more importantly, I thought it was pretty disrespectful. I mean,
He's dead.
Paul was a good young man, and I, quite frankly, it just pissed me off.
I understand. Did you have a conversation with anyone about trying to prevent that?
I don't think I did about that aspect of it, but it was, I just thought that they should have put a tarp or something. I mean, just out of respect.
Right.
They eventually did with Maggie put what I would call a tailgating tent, very similar to the media tents that are out front, those little lightweight, and they put that over Maggie.
Right.
To my knowledge, they never did over Paul, at least while I was there.
When you walked around the shed to get on the other side, who was on the other side?
Well, I could see through the alleyway between the dog kennels and that wing shed coming off of, if you were standing in front of the aircraft hangar, it'd be the right-hand side where Maggie was. I could see Randy over there and Alec. Alec much more infrequently, but Randy was on the phone walking and I could see him. And I think he and I got there about the same time. He had come through the main gate.
When you got up, what did you get up to greet Alec?
I did. When I walked around, Alec met me about halfway where that equipment shed is. Alec came, as soon as he saw me coming up through there, he met me about halfway in front of that shed and just went to pieces. He's Alec's 6'4", 6'5", whatever he is, and
Nice.
I'm 5'9". He pretty well smothers you when he hugs you. And he
What was his demeanor?
he was devastated. I mean, he was crying. He was, I mean, just beside himself.
Yeah, it was nice
I
little
told
throw
him
in there that
we'd get through it. And
Did
he, go ahead.
eventually did SLED arrived on the scene?
He did, but while Alec was
Oh, I'm sorry. Go ahead.
kind of, you know, I'm trying to console him and patting him on the back, and, you know, he said, look at what they did, look at what they did to them. I mean, just right off the bat.
So during that initial encounter with Alec, he referred to they with what they did. Is that correct?
Yeah, they, which I didn't really think about at the time until I was
Also consistent
taking
with
my
my
wife
theory
home.
that he saw the
I just thought it was
murders.
an odd comment.
The SLED arrived sometime later.
They did.
Do you remember about how long after your initial arrival SLED got on the scene?
I think they came kind of in, you know, because I'm sure they were coming from various locations, but they were there probably within an hour and a half of me being there.
And
Maybe he
by
was
the
being
time
politically correct.
SLED arrived,
like
were there
not
other
he or
members
she,
from your law
but
firm
they.
and family members out on the property where you were standing?
There were, by the time SLED got there, pretty much all the lawyers in the firm, with the exception of maybe 2 or 3, one of them had small children, and one got forgotten, and pretty much everybody that was a lawyer was there. And family members, all of Alec's family was there.
Were you directed to leave the area
Tragedy, the village comes together.
when SLED started processing the crime scene?
Eventually we were. The coroner came over, Rich Harvey, came over and said SLED was there, they were ready to start processing the scene. He said, y'all need to, you know, go over to the house, and I said, are you sure about that? And he said, yeah. And I said, are you sure it's okay for us to go to the house? And he walked back over and asked somebody and came back and said, yeah. And I said,
Did you have any concerns going to the house?
I did.
What were your concerns?
Well, it's twofold. One, you know, this is a pretty big farm, and I don't know who's over there. 2 people have been gunned down, and, you know, is it safe? You know, so safety's one concern, and the other is that part of what went on here? And so, where's the crime scene start and stop?
And when you got to the house, did it appear that the house had been searched and cleared in any form or fashion?
I didn't see any signs of that, but I'm not a criminologist, I'm not a prosecutor, I'm not a defense lawyer, but, I mean, it looked like just a regular house.
Okay. But before you go to the house, did you have any conversations with law enforcement about your knowledge of Paul receiving threats.
Yeah, I had asked, when I was standing where I had driven up, Buddy Hill had come over there, and he asked me if I knew, because I know Sheriff Hill, and he asked if I had any idea of who might want to do this, and I said, not really. And he said, do you know of any threats? And I said, I know Paul had gotten, since the boat wreck, that he had gotten several, threats and just people cranking off from all over the place, not necessarily local, but from everywhere. And I would hear it from, Alec from time to time and different stuff. And so I told him that.
Did, when you had that conversation with Sheriff Hill, had you spoken to Alec?
I had not at that point. I hadn't gotten over to him.
When you had that conversation with Sheriff Hill, had you listened to the 911 call?
No, sir.
That thought of threats, was that an independent thought of yours?
Well, it was response to a question
Right.
from Sheriff Hill.
And your thought process was about the boating accident?
Well, that was the only threat that I knew of that Paul had ever encountered.
I don't know if we
When,
had sympathetic lawyer on our bingo card for today.
do you remember who went to the house when you went into the Moselle residence?
Yeah.
Who was with you?
Well, I mean, I probably can't name them all. I'll probably leave somebody off, but it was myself, Ronnie Crosby, Lee Cope, Austin Crosby, Neil, Alger, Randy Murdaugh, Alec.
Had Buster gotten there yet?
Buster had gotten there, I believe, but I'm not sure. He and Brooklyn, I remember when they came up, but I can't tell you whether it was over before we left over there. It seems to me that they drove up at the house, but I can't tell you for certain. And then there was Corey Fleming and Chris Wilson showed up, Lynn, John Marvin, just a host of people. Greg Alexander, Chief of Police in Yemassee, who's a friend of theirs, showed up. There were
A lot of people in that house.
a lot of people.
What did you observe of the condition of the house?
When we came in the door, we obviously went to the den, and we're standing around. The den and the kitchen in that house are connected, and there were pots on the stove, so Lee Cope and myself and I think Austin
Explains
got
the pots.
I think I set something in the sink, and they stuck some in the refrigerator.
But when you entered the house, it looked like there was food out that had been prepared for dinner?
There was food on the stove, yeah. I don't recall seeing any plates, but somebody else could have picked them up. I wouldn't.
But were folks cleaning up?
Sure.
And what time of day was this?
It was probably 1:30 or 2 in the morning.
Do you remember what time you left the Moselle residence on that night, early morning?
I probably left at 3:30 or 4. I left when Alec was leaving.
When did you go back to the property?
I had a deposition the next morning, and I ended up having to take it, and then I got out there about 11, I guess.
And was Alec there when you got there?
I went over to the dog pen over that way. I had gotten a call that morning about 8 o'clock from Randy, 8 or 8:15, and John had gone over there trying to clean up and just couldn't do it. I mean, emotionally, and Randy had asked me if I could see about finding somebody to come clean it up, or did I know anybody. And I called the coroner's office to find out if they had people that did that type of work or knew of people that did that type of work. And ultimately, the coroner called me back and gave me the names of 2 companies, and I gave those to Lee, and he started trying to run them down.
It seems like they
Power
tried to
Wash
set the whole
Limited.
flank.
Inadvertently skipped over something on my outline.
You're really quiet, Joe.
When you were at the house before you left, so you left about 3:30 in the morning or so, were you there when SLED agents came up and took custody of Alec's clothes that he was wearing?
I was. They knocked on the door. Somebody answered the door. For some reason, I got up and walked over there, and they said they needed his clothes and to, I think, swab his hands. I walked back over. Alec had been sitting next to me on the couch. There's 2 couches in the den that sort of face each other, and then 2 chairs that are headed towards the kitchen. He was sitting on the far couch, and I walked back over and I said, Alec, they need your clothes. Can you step back here with these folks? And it was a male and a female.
Okay. Well, before we go any further, let me ask you, were your clothes wet or dry when you were sitting on the couch?
They were pretty wet. They weren't soaked, but they were uncomfortably damp.
And do you recall whether Alec's clothes were damp as well?
I would assume they are. I didn't reach over
And did you see how the clothes were, I guess, collected? Were they put on a hanger, wrapped up carefully, or what happened?
The male went into what Alec's bedroom, at least I'm assuming that's Alec's bedroom, and he came back out, and then I saw Alec just kind of, the female agent or officer was holding the bag, and Alec dropped him in.
There was one bag, multiple bags?
I thought it was one, but I couldn't tell you whether it was 1 or 2 or 3.
All right. We went down, now I'm jumping back to where we were on the morning of June the 8th. After you got out of your deposition, did you go to the property?
I did.
And you went down to the kennels?
I did. I drove over there.
Had the crime scene been released?
It had been released, and because I asked Randy that morning, he said, yeah, they've released it when John was down there.
And what'd you do?
Well, I just
trying to adjust
wandered around.
levels.
There was a sled agent there. I think at some point Duffy Stone and Sean, his deputy, Thornton, was there, and I think one of their investigators, they were over inside the hangar, and there was a sled agent. At least I'm presuming he was a sled agent, and I don't know who he was. It wasn't any of the ones that were working the case that I came to find out that were working the case later on that I can remember. And I looked around at different things.
Did you look in the feed room?
I did.
What did you see in the feed room?
Well, by that time, I think Ronnie had either come up or was over there,
Ronnie,
Crosby,
your law partner.
and I think Lee Cope was there as well, but I'm not sure about that. I'm pretty sure. And I was looking in the feed room, and you could see, obviously there was still a pretty raw scene, and there were.
Were there still remains of Paul in the feed room that had not been collected?
At first, I didn't see it. I saw shot, on the floor, steel shot on the floor, number 2. Steel
shot, you mean pellets from a,
Yeah, like bird shot, except it was number 2, steel.
okay, and you saw that in the feed room?
It was all over everything. It was on the floor, it was on the shelves, it was various places.
Okay.
And then I got to looking around, and there was you could see where a piece of buckshot had gone through, and you could see where it knocked out, or shot through twice where the window was, or is. 2 had gone through that. There was some plastic crates or something, and you could see where one of the shot had gone through and had embedded in the window frame right there, the molding. And then there was a piece of buckshot laying on the ledge of the windowsill.
What did you do when you observed the shots?
I walked back out and asked what I thought was the agent, and
What was the agent?
he said, we've got all we need. And so I walked back over there and looked around, and then looking around around the floor and all that, there was a piece of Paul's skull about the size of a baseball laying there.
Did that upset you?
It did, very much. I mean, it just really infuriated me. And I don't know who I was supposed to be mad at, but it just infuriated me that this young man had been murdered and there were still his remains there. and there was a large blood spot and tissue out right off of the apron of that area right outside the feed room that was there, and it's kind of like walking across a grave. It's one of those things you just don't do.
Right.
He seems like such a respectful guy.
After you spent time down at the
Super prepared by the defense.
kennel area, what'd you do next?
I ended up going back to the house,
Getting all the bullet points.
and I remember Terry Brandstetter, Maggie's daddy, was there, and several other people, and I spoke to them and went in the house, and eventually went towards where the gun room was that afternoon.
Did SLED agents come up to search the house while you were present?
They did. They,
And I think the jury's seen a video of it. We don't need to play it, but were you present in the gun room?
I was. I think they, probably 2:30 or 3 o'clock, something like that, they showed up. And I had a discussion with that same agent. And I'm assuming it's a SLED agent. It could have been a sheriff's deputy, but I made the assumption that it was a SLED agent over at the kennels and the hangar about, I asked if they'd figured out what kind of gun it was. And at that time, I assumed it was a .223 based on the night before. Barry McRoy had said that he thought it was some type of assault rifle, and I just immediately kind of went there, and that agent had said that it was a three something, and I said a 300 blackout, and he said, yeah. And I said, well, there's one over there in the gun rack, and he said, no, there's not. And apparently SLED had been there sometime that morning or whatever. He said, they already checked, there's not one over there. And I said, yes, there is. And so later on, when they got there, there was one there.
So, and you located it for SLED?
Yeah.
The night, early morning hours, 2 or 3 o'clock before you left, had you seen the gun room?
I had.
Were there guns on the pool table and whatnot?
I walked in there, the door was shut, I think the door was shut between it and the sort of a transition hall. You go through there, and then there was a bathroom, and then where the freezers were, and then it exits out onto the porch. And then straight ahead would be, I guess in the original house plans, would have been a garage, but it was kind of a den game room that Alec had turned into a recreation/gun room, and a large room. And I walked in there, and there were 3 shotguns on the table, pool table.
Right.
And some other stuff, some shells and stuff. And
And when you went back the next day, the 8th, in daylight hours, early afternoon, it looked like things had been put up?
they had been put up. There were no guns on the table. There were no shells, no nothing there. And so I asked what happened to that. And I was told that the maid had put them up. And so I went and asked her.
Was it Blanca?
And yeah, I went to Blanca, and she said, yeah, I was told to clean up the room. And so I put them up and put them in the rack.
And did you point out to the SLED agents the guns that were on the table that you thought you'd seen the night before?
I didn't point out the guns. I told them that there had been guns there.
When you're on the property, on the, I guess, the morning, on the 8th, at some point in time, did you observe an employee that had been working on the property for an individual by the name of C.B. Rowe?
I did.
And did you take pictures of his vehicle for some reason?
I took pictures of a vehicle. I didn't know whose vehicle it was. There was a vehicle that had pulled up underneath of the, again, if you were standing in front of the hangar where the big door is, it would have been to the right. And there was a truck that had pulled up in there and it didn't have a license tag on it. And when I walked by it, there was a jug of Clorox, and I can't remember what else was in there, but it was a jug of Clorox, and I just thought that was
Where
odd. So
where
I
was the Clorox?
was in the bed of the truck,
Okay.
and I took a couple of pictures of it and turned them over to SLED.
And why did you take pictures?
It just looked odd. You know, two people had gotten killed, and, you know, there's Clorox around.
Okay. There's been, I won't make a statement. Did you see any coolers on the property down there?
I did. There
Where
was
did you see a cooler?
when I walked around the bottom part between the skin and shed and the hangar and the other shed, there was a open cooler there, or looked like a Yeti style cooler, and I can't tell you whether it was a Yeti or not, but it was one of those thicker coolers, and there was probably a dozen beer cans around it that night, and the next day when I walked by it was still there.
Okay.
I just thought it, with all the people and the hoopla that had gone on, that it didn't look very good.
Okay. Did you, I mean, was that the only thing that stood out about the cooler, the beer cans around?
The beer cans, yeah. Looked like somebody had unloaded a boat or something, and just kind of thrown them
I
out
don't know
of
if
the
you want to
boat.
talk about beer and boats.
Forgot
on this
about them and
trial.
left it.
Did, what kind of law do you practice?
Civil,
Okay. Plaintiffs, defense?
mostly plaintiffs. Occasionally I'll defend a, small business or a farmer or something like that, but
Right.
for the most part, it's all
during the-
plaintiffs.
Mostly
Of course,
sue
in your
insurance
practice, have
companies.
you had experience with getting cell phone records of, parties to find out information?
I have. It's pretty regular now. I mean, just about every defense lawyer asked and every plaintiff's lawyer asked, because so many people are texting and talking on the phone when they rear end somebody or crash into somebody or whatever, and you want to know if you ask them, were you on the phone, and they say no, and, it shows up on the bill, then they probably were on the phone.
And as, part of your, I guess, concern about Maggie and Paul and Alec, did you pull his cell phone records?
Well, I was asked to pull them, and yeah, we provided them to both SLED and to your office, I believe,
Right.
for Alec's cell phone records.
And if you're
This is a really
trying to get information from an opposing party or something about cell phone records, are the records
Curious
more reliable than the actual
witness.
handheld phone device? In your experience?
402.
I
Did you hear the objection?
I-
Since the lawyer, then you don't respond until the court rules. Response to the objection.
There's been testimony about deleted call logs, Your Honor, and this addresses that issue.
Anything further? Objection's overruled.
I don't know that aspect of it. That's a technical. I get the records because they're more accessible than getting a download and going through the. There are cases that you may want to get a download, but the run-of-the-mill cases, with truck wrecks and stuff, the records of the cell phone call records tend to answer the question that I'm asking.
You've known Alec for 30-plus years?
Yes, sir.
You recognize his voice?
Yes, sir.
And I think at one point in time, were you asked to identify his voice on a video of down at the kennel?
Yes, sir.
And did you do so?
Yes, sir.
And you determined it was Alec's voice?
Alec and Maggie and Paul.
And you told that to SLED?
Yes, sir.
So the defense is admitting this
Have
position
you,
that he was there.
Listen to a tape that's been played in this courtroom about whether Alec said, I did him so bad or they did him so bad.
Objection. 401, 402, and beyond the scope of this witness's knowledge.
Objection's overruled.
I was sent a snippet and asked the question what it was, and
Hang on, I'm not getting your response, so let's, Your Honor, we'd like to play the snippet from State's Exhibit 153 for this witness.
Your witness.
Thank you, Your Honor.
And Your Honor, I would object. I believe that this witness was not present for this conversation, and again, would object under 401 and 402 in relevance to his commentary on that particular exhibit.
This is overruled.
And sit there talking today is tough. It's just so bad. It's so bad.
Sounds like they to me.
Right.
I played the snippet multiple times, and
And is it consistent with what he told you the night of the murders?
it is.
You remember in, I think, February 2019, that Paul Murdaugh was involved in a boating accident?
I do.
And you're aware that he was criminally charged?
I am.
And then Alec, and I believe Buster, were civilly sued.
Yes, sir.
And did you work on the case formally?
Not formally, no. I was about to get in after the murders, along with several other partners.
Did, leading up to the murders, did you have conversations with Alec about civil case and the criminal case?
I did about the civil case to begin with, and then when the charges came out, I talked with he and Randolph.
What was Alec's, if you know, what he expressed to you his priority between the two matters was?
Well, obviously, the criminal matter was much more pressing for him.
And in your conversations with him, did you gain an understanding of his concern about the civil case?
Yeah, somewhat.
But how concerning was the civil case?
Well, I mean, obviously, anytime you get sued, you've got to be concerned about it. And, it was the whole boating accident as a whole was very negative towards him, towards Paul, and the entire family, or his entire family. And so, it was obviously it wasn't a nothing, but at the same time, I read the complaint, several partners and my lawyers in my firm read the complaint, and at the time that he was sued, the causes of action against Alec were drafted probably to try to get as much insurance coverage as they could, which is what you do as a plaintiff's lawyer. You're looking for coverage. You don't want to make allegations that get you out of coverage, and it was very vanilla against him, and the allegations against Alec were that I sort of referred to him, and others did as well, as sort of bad parenting. You had an adult child that the allegation was that you allowed him to go out and drink, and when you're 18, you pretty much get to do what you want, and you've reached your majority. And so I didn't really,
Legal
I
age
thought
of
it was very
drinking
defensible
is
as to that,
18?
those causes of action at that time.
I don't
or
think
that
that's
cause of
right.
action.
Pretty
And I
sure
think
it's
he did
21 in
too,
every state in the
but I
country.
don't know what he thought.
Right.
It means Alec would no longer be responsible.
Did it,
At 18.
some point in time, Alec, was he forced to resign from the firm?
He was. September
And,
the 3rd.
What day was it?
September the 3rd.
And after that, did you have an opportunity to look in his office?
I did. He resigned on the 3rd. Then there was the incident on the 4th. And I left the scene over there on Old Salkehatchie and went by the office. And I'd also been in his office on Friday after he resigned.
When you were in his office, did you find any paperwork that looked like he had been working on for the boating case?
Not until the 5th.
Okay, and what paperwork did you find on the 5th?
The 5th, I went in and started really, because we have an obligation to those clients that he was representing, and I didn't want files just laying around. This was Labor Day weekend, all this hoopla and promotion of, you know, the murders, the issues with Alec leaving the firm, and then that Saturday. And so that Sunday, I went in to the office and went to his office and started going through to make sure that any client files were put over in stack, you know, over there. And as I was going through, I found checks that he had deposited with his telephone that were some of the funds that sort of started all this mess with the Ferris case. They were laying, one was on his top of his desk, one was in a drawer. I pulled out one of the drawers and there was a tablet, a legal tablet, that had numbers written down on it as far as debts and assets and, you know, just kind of the scribblings of kind of what you owe and what you've got.
Would it be something that you would normally see on a net worth statement?
It would be the same information. When I think of a net worth statement, I think of the form that a bank sends you.
Right.
But yeah, it obviously, he was listing what he had and what he owed.
Is it something, the type of format you've seen in civil litigation where a defendant's required to produce net worth?
Not in the same form, but the same information.
I skipped another topic. After Maggie and Paul's death, did you collect her jewelry?
I did. I got a call on the Wednesday, I believe, after the murders on Monday from the coroner. His wife and my wife had worked as surgical nurses at Hampton Hospital together, and then my wife ended up being the supervisor over that area. And so I knew them very well, and I'd known Rich for 30 years. He called and said that Lori had cleaned up the jewelry and, you know, whenever Alec wanted it. And I said, well, I'll come get it. And so I met him. Ronnie Crosby and I came over to his office and picked it up, signed for it, and I carried it back to the house.
And within the jewelry, do you remember the wedding ring and wedding bands and other jewelry?
There were rings, I can't tell you. There was a thing that sticks out to me was she had a diamond bracelet on, and it was in pieces. And he said he tried to find all the pieces, but there was still some missing. But I wasn't paying attention so much to, it just didn't feel right looking and snooping around in somebody else's stuff.
Knowing Alec for 30 years, do you
This sounds like a witness
develop an
who's very
assessment of
involved,
his
but has
relationship
nothing
with
really important
his
to tell
family,
us?
Maggie, Paul, and Buster?
You know what I'm saying? Like, it's just like,
Well, I'll tell you this.
what do we
the
get
person
from him
I thought
so far?
I
'Cause
knew
I'm not feeling much. I'm not going to
Loved
catch
his
it.
family, or appeared to love his family very much. He'd take their calls, he'd do all of those things. After, you know, September the 3rd, I'm not sure I know that person. And so, but he always seemed to be devoted to everything. Their ball games, he would aggravate the hell out of me when you'd be in a deposition and they would call and he'd answer it, and, you know, you'd be in a meeting or whatever, and he always took their calls. Whereas my wife and my children never called me unless it was a true emergency, and Alec took their calls, whether it was they needed, you know, a gallon of milk, or, you know, they had something important to tell him. I mean, he always took their calls.
And did you see them together frequently?
I did. They went places. You'd see pictures of them. I think Maggie was a pretty prolific Facebook, text, whatever. I'm not on any social media, but my daughter or my wife would show me pictures of where they had been, or ball games, different things like that. I never saw anything that indicated to me that there was any thing out of the way with any of the relationships, including the drug stuff. I had no,
Yeah, let me ask you, were you aware that he had an opioid addiction?
none,
And were any of the partners aware that he had opioid?
none to my knowledge. I mean, that was not a subject matter that ever came up. I mean, it was, and, you know, Paul,
Did
I
you
think,
know,
has
Alex?
been sort of
This is what we're gonna
demonized
get.
by this whole affair, and it's not fair. I mean, Paul, it's like a lot of young people I know, you know, they kind of are trying to find where the fence is. Sometimes they get, you know, going a little fast and, you know, blow through some things, but Paul was a good kid. He was always polite to me. I never had one single solitary issue with him at all. And I knew he had done some things, you know, that most kids, you know, are mischievous do. And on at least one occasion, I went to Alec and told him that I thought Paul needed to be throttled back a little bit, that I saw some videos of him driving fast. And I don't know what Alec did, but that was, our firm was very much of a family. I mean, if you were a member of our firm, and it didn't matter whether you were a lawyer or one of our folks. I mean, our staff is family as well, and if they have a problem, we all have a problem. And so we look out for each other, and we did. Unfortunately, Alec betrayed that when he stole the money. But you know, the outward things that I saw of Alec with his kids and his wife were just that. I mean, they were what I observed. Nobody knows what goes on behind closed doors, but they seemed to enjoy each other's company.
All right. Thank you. Court's indulged. I have no further questions.
I mean, we got about some sloppiness of sled. I get that. The skull thing was particularly bad. That was really bad.
Mr. Waters, could I steal one of your waters there?
Absolutely. He was pretty good at hiding who he really was, wasn't he?
Obviously.
You known him for 34 years?
I knew him for 34 years, or I have known him for 34 years.
Thought y'all were pretty good friends?
Thought so.
Interacted many times a week?
We had his son Buster and my daughter were in school all the way from kindergarten on, and I would see him at work early on. He didn't work for us immediately when he came out of law school. He worked for Jim Moss and Moss and Kuhn. And then he came to us about 5 or 6 years after that.
But you shared a business with him for how long?
Probably 20 some odd years.
He was your partner?
He was a partner.
You trusted him?
You have to. And I did.
And outwardly, to your appearance, he was a good lawyer, he was a partner to you, he was someone you could trust and rely on, wasn't he?
I'm sorry, I didn't hear the first part.
Outwardly, from what you observed.
Yes, sir.
He was a good partner, he was a good lawyer, he was someone in part of your business, somebody that you could trust and rely on. Is that true?
Yes, he was.
And outwardly, you thought that he had a good relationship with his family? Is that correct?
That is correct.
But you have just testified that you didn't really know this man, did you?
Obviously, I did not. I mean, had we known the things he was doing, we wouldn't have been law partners.
You were asked about the kennel video.
Yes, sir.
And you've had a chance to review that kennel video.
A couple of times.
And you and I have talked quite a few times, is that correct?
We have. I didn't see the kennel video until probably a month or two ago.
But you've reviewed it here recently, is that correct?
I have several times.
All right. And any doubt in your mind that Alec Murdaugh, Maggie, and Paul were on that kennel video at 8:44 p.m. on June 7th, 2021?
None.
No doubt in your mind?
No doubt.
Do I need to play it for you again, or no doubt in your mind?
I played it all. I want to hear it.
Well, let's talk about that just a little bit. And we'll talk more in some detail, but I want to go ahead and cover this. You saw Alec the night of the murders.
I did.
And you knew Maggie very well, you knew Paul very well.
I did.
And you went to the scene where Alec was, is that right?
I did.
And did you even ride with Alec or take Alec back over to the
I'm
house?
pretty sure he rode back over to the house. I think he and Randy, because their vehicles were impounded over there.
And did you eventually, as things started to move forward, sit down on the couch with him back at the house?
I did.
Fix yourself a liquor drink?
Probably a heavy one.
I get it. And did you talk to Alec about what he did that night?
I don't know whether it was, I know on the couch we talked, but I talked to him several times, including before the masses got there, as to trying to figure out, do you know anything? Do you have any idea who did this?
Because you were very concerned. You want to get to the bottom of this, right?
Well, for a lot of reasons.
For a lot of reasons. For the family, for what happened to Maggie and Paul, for the law firm, for all the people involved?
All of it, and safety of, if it was something to do with him and the law practice, we didn't want somebody to show back up at the front door and harm our folks. We didn't want them to harm any of the other lawyers' families. If it was some person that was deranged, we just didn't know. I mean,
Like me at the firm,
this
not
isn't
the
an ordinary
Murdaughs.
occurrence in your practice of law.
It's logical.
You thought you were his buddy, been partners for 34 years, y'all are sitting on the couch, is that right?
Like family.
And you start talking to him, is he responding to your questions appropriately?
He was. But
Answering the correct subject matter?
He was. He was very upset, obviously.
Sure,
I mean,
but he was answering your questions, he wasn't unable to make sentences.
he
and that
was.
sort of-
Yeah.
And did you talk to him about what he did that night?
Yeah.
And did he deny ever going down to those kennels to his buddy and law partner of 34 years?
He said that he ate dinner, laid down on the couch, took a nap, and then left to check on him.
And now you know that's not true from seeing the kennel video, right?
Do.
And that wasn't the only time he told you that, is it?
No, at least 3 times.
At least 3 times. And this would be over the subsequent days,
Yes, sir.
subsequent conversations that you had with him?
Yes, sir.
And he was always clear that he never went down to those kennels after they ate dinner?
It was the same version of it, but it wasn't always just me.
Okay, and we'll talk about that. Who else was present at some of those conversations?
Well, I mean, there were other law partners, and I can't tell you exactly who all was there, but, I mean, I know on that Thursday following this, I heard him say it then.
Okay, and there were other law partners there?
Yes.
Were their family there?
I don't know whether they were in the room at the time or not. I just know there were law partners there.
Was Jim Griffin there?
I can't speak as to what, he was present on the property, but I don't know whether he was there.
And did Alec tell the same version of events, that he never went down to those kennels?
This is the key
Yeah, he
sticking
did,
point.
but I don't know whether Mr. Griffin
the
was
state wants
there.
just pound and
We were
pound.
there before Mr. Griffin was there.
That's all they have.
Yeah. Alex really needs an expert
Did-
witness about shock and memory and how shock
In his
affects memory.
conversations with you,
That
did
would
he
help
ever
him a
change
lot.
his story about
Indeed.
who he checked first at the scene, supposedly?
I've heard it both ways, and I don't know whether it's just I don't know whether it's just because of the trauma of the situation, but
I mean, as
one time it was.
to my mind, again, it
he
doesn't
checked-
seem
the
like a
first time I
material
remember,
lie.
He
It's-
checked Maggie
it's,
first and then went to Paul.
easily a misstatement.
And then I
There's
heard
no,
him
you don't benefit by making up
say
that
at one
story.
point that it was Paul and then it was Maggie. It didn't really
To a
matter to
layperson,
me.
they might think he's trying to.
It wasn't something I
push
really
guilt
was
away.
picking up on because it was horrendous either way. I mean, I can't imagine seeing my wife dead and my son dead in such a brutal
You're
manner.
obviously correct,
So
but the target audience is
never
not
put
you.
any
You know what I'm saying?
real stock in that.
I'm never the
But
target
it-
audience,
it did,
Joe.
it also-
You're
Never.
not.
It did oscillate from what he was saying.
From the first time I heard it,
The
but,
story changed.
well, yeah, as to which was which.
Oh, okay. This could be helpful. I'm not sure who Donna
Over the
Maddox is.
days
She's an
following this
expert.
event, this law firm, as you've said, was like
Thank you,
like
Rick.
a family, right?
Was.
You thought you were very close to this man, just like you feel close to your other law partners and their families and the staff and everybody else.
It wasn't just the lawyers that felt that way. It was, I mean,
The
the funeral, the
paralegals.
paralegals were there. The law firm shut down. They were also on, we had to go on a heightened alert. I contacted SLED about what we should be doing because there was a statement that came out about there was no, they didn't know of any danger to the public, and we're left with trying to make sure that the 60 or 75 people that work with us are all safe and they go home to their families, and SLED responded. I called the lieutenant over here, and he called me back that evening, and, you know, was very helpful as far as trying to tell us, you know, he said, I don't know of any specific threats, but, you know, here's some precautions, and I think what y'all are doing is the right thing, and they were helpful. But there was still that undertow of, you know, who did this, and are they going to, and it just, people were just on edge all the time.
And you're not a criminal lawyer or prosecutor, I think you said.
I'm not.
But still a lawyer, and so you and your partners, including his brother Randy, were very focused on trying to figure out what happened here, what is wrong here, correct? What happened on June 7th, 2021,
Sure.
right? Very focused on that, were you not?
We were. I mean, it was taking a lot of time off.
But he was not, was he? You've said that before, have you not?
I have said that, but I don't know, Mr. Waters, how I would respond if I'd lost, and I've told you the same thing. I don't know how you're supposed to react when you lose your wife and your child in such a brutal manner. But no, to answer your question,
there is one way to
I didn't
react.
see him on the phone like I was trying to call clients and did you hear anything? Did you see anything? Those kinds of things. So, I mean, the answer is no, I didn't see him doing that. I wasn't around him all the time, but no, I did not.
And you've already testified that you and other law partners and family and staff were very concerned about potential threats because of what happened on June 7th, is that right?
Very concerned.
And you thought it odd, though, that he was not concerned about any threats even to Buster, correct?
Well, I wouldn't put it that way. The night that this happened, I asked Alec where Buster was, and he said, we've gotten a hold of him, Brooklyn's bringing him. And I said, are you sure he's all right? And he said, yeah, he's riding with Brooklyn. And I said, you think he needs any protection or something along those lines? I don't know that it was exactly those words. And he said, they'll be here in a little while, he'll be fine. But he was so addled, I didn't hang anything on anything Alec was saying.
But after that, in the days that followed, you continued to interact with him. He never asked for any protection or expressed any concern about protection for Buster, did he? And you
Not
said-
to me, he did not.
to you.
And, you know, the only thing I can tell you is the 4th of July, he came to Ronnie Crosby's house, and he had a pistol in his bag, which was, to me, was unusual. And of course, in classic Alec, Buster, and Paul style, he ended up leaving the bag there when they left.
That's my theory.
This law firm's been in existence how long?
1910
1910.
was.
And-
We're no longer.
Really?
I'm sorry?
We're no longer. We're now
It
the Parker
was.
Law Group.
It wasn't until he came along, right? Until all this happened, right?
Oh, they had to get the
Until
Murdaugh name off
September
of
of
it.
2021.
September 2021. And
That's pretty
was
funny.
a relative of Alex, his great-grandfather was part of that initial law firm, is that right?
His great-grandfather was the beginning of that law firm.
And was he also the solicitor for the 14th Circuit for this area of the state?
He was from, I believe, 1920 until 1940 when he was killed in a train accident.
And then did the defendant's grandfather become solicitor?
Buster
The
started.
chief prosecutor for this area?
Buster took over in 1940 and was the solicitor until 1946. And then Randolph was appointed by the governor and then was until He was 72.
And his father became solicitor, is what you just said, is that right?
Randolph.
Until about when?
Randolph was 82 when he passed away, so 10 years ago maybe, around there. And Buster left the solicitor's office in 86 when he became 72. At the end of 86, beginning of 87, I think Randolph took over, and Buster became the assistant solicitor
All right. And how long was Randolph solicitor?
until about 10 years ago.
A family legacy for a
And was still an
century.
assistant when he passed, I believe.
Do what?
I believe he was still an assistant solicitor.
Mr. Randolph was?
He was.
And so was the defendant, too, wasn't he?
He was in some form or fashion.
He had a badge. Did you ever see a badge that he had?
I did.
Where did he keep that badge that you saw?
Usually it was on the corner of his dashboard.
Driving around with it in front of his dashboard?
A lot of times, yeah.
This family is very, very powerful, were they not? Very influential in this community?
I mean, they had a very good name. They had, they were, they were known
Old
to
money.
help you with your problems.
How important was that family legacy to the defendant?
It seemed to be very important.
I think you've said that it was more important to him than anybody else that you observed.
It seemed that way. I mean, whenever there would be discussions of name changes or anything, he would be very involved in that, much more involved in that than he would be in other business matters.
And he even talked to you about wanting, that being the defendant, wanting to be solicitor as well.
At one time, yeah.
You talked a little bit about the scene. And there were, when you arrived, there were other law partners there as well, is that right?
Not when I arrived. Randy was there.
Randy was there, other law partners showed up?
They showed up over the next hour and a half or so.
Okay.
From Jasper County, from Beaufort, from all over.
And there were a lot of powerful attorneys at that scene as it was being processed, including the defendant, is that right?
Well, obviously, Alec was there and the rest of us, and then I don't know of any other lawyers at the scene other than us being our firm members.
And was law enforcement always polite and respectful during this entire process?
Absolutely.
And when they came to the house that day, the video where the Jeff Croft came in and searched for those guns, were they polite and respectful?
They were very polite.
Did they have a long conversation because they knew family was in the house about trying to do this as delicately as they can without upsetting everybody and doing some big search and running everybody out of the house and all that stuff?
Katie, and I apologize, I can't remember her last name. She offered to take off all of her identification, her gun and all of that, and we told her that wasn't necessary. Okay, I can.
Speak a little louder.
Okay, sure. That's
You
usually
scoot
not
up a little
problem,
bit,
yeah.
might help, so you
Well,
don't have to
it's-
lean forward.
Yeah, I mean, Katie offered to really, be very behind the scenes, so to speak, and everybody, I've not had, the vast majority of them have been extremely polite and very, very responsive to anything that we ask.
Because of all the family there and the tragedy that happened, they were very delicate and respectful of that when they came to the house that day, is that correct?
In looking back, they probably were too much.
But they were.
They were very.
You said that Alec would always ride in his Suburban with that badge up in the front dashboard, to your observation, right?
I don't know that he always did, but a
A lot of the time.
lot of the time.
He also
Why not? I would
generally
too.
carried a pistol in the car too, didn't he?
I didn't know that. I can't
But you've
testify.
heard that now, haven't you?
I've heard that, but I didn't know that.
Okay.
What was Alec like with the cell phone? He was on it all the time, wasn't he?
He was on the cell phone all the time.
He would constantly be using it, constantly responding to calls in the middle of conversations, always had it with him, to your observation, being his law partner for 30-some-odd years. Is that correct?
He was
Line
an
is so
obnoxious
stupid by the
user of the
state.
cell phone.
Nobody is on the phone all the time.
And
We
would it have
sleep,
been
we
unusual
eat.
for him to go down to those kennels without his cell phone with him?
I mean,
You've
I
said
don't,
that, haven't you?
I don't know whether I've said it or not said it, but I would think it would be unusual for Alec to go anywhere without his phone.
I'm the same way. I don't shower that
What
way.
was he like as a lawyer? Was he a very academic or type lawyer, or were his skills elsewhere?
Well, I mean, Alec was a very good lawyer. I mean, he got good results for his clients. He got,
He's a rainmaker.
he could look at a set of facts and really do well with them, figuring out where to go with the issues, where to push and where to not push and pull. And he was very good tactically. I wouldn't say that I'm a great academic lawyer. I think I'm pretty good at figuring out where the seams are to figure out the solution. And I think Alec was much more like I am in that respect as far as looking at facts and talking with people. Alec never met anybody that he couldn't talk to. He could talk to a fence post.
Talk to a fence post. I think you've said that people were his trade,
They were.
and he understood the emotions of cases very well, did he not?
He did.
And he could be very convincing with people, as you've come to find out from all that you've uncovered. Is that correct?
Absolutely. He convinced us since 2006.
Effortlessly and easily lied to you for years, and you didn't know it.
Didn't
Is that
know it.
correct?
Didn't know it and didn't catch it. In fact, it just, the way he was doing it was very, very cunning.
Cunning.
This is really, that's not a good word for it. I mean, that's a good word for creating waters.
Who is that? Remind the jury who Jeannie's second juror is. It's been a long trial, but remind them who she is.
She is our in-house accountant, CFO. She's the money person, but she goes beyond that. She did management stuff. She would be the person that at one time she was kind of managing the non-lawyer staff, but she could still rein in the lawyers as well.
And in the wake of all
So
this
not true.
financial stuff that came up on September 4th, she was one of the ones tasked with going through and figuring out the extent of what he had done. Is that correct?
She and I worked a lot.
And you worked on that as well. Is that correct?
Correct. One of the things that has come up, and there was this issue that happened back in 2017 where we had, at the beginning of the year, the law firm depletes all the money, and then you have to start off the year. Well, money's coming in, and you may not have enough to cover your bills in January and February. So we do a loan, and generally the partners, ones that wanted to participate, would put money in, and then they'd get paid back as soon as we got on a cash positive in the new year. And there was an issue in 2017 where Alec was paid. He didn't put the money in, but the check was written to him by mistake. And I've gone back and looked at it and made sure, but his name and Randy's name appeared at one over the other, and it was just a fat finger or just a missed thing with the mouse. And the check was generated to Alec. And then there was a second check generated, one in March, one in April. The one check was negotiated in May, I think. The other check stayed on his desk, and was negotiated the next October. Well, what that did was that threw out our, and this is in our operating account, it wasn't client money. So it threw our operating account out of balance. And when we started looking at it, then we realized that he wasn't the one that was supposed to have gotten paid. We had basically a powwow. Our president, Danny Henderson, went to him, talked to him about it, and Alec swore that it was just a mistake, and he paid back the money with interest because Randy had been out of his money.
Paid it back with stolen money, correct?
Well, I didn't know that, but I mean, he paid it back, and I think there had been testimony that somehow that got swept under the rug. It did not get swept under the rug at all. It was investigated, but everything seemed to make sense because the check was written to him. He cashed a check that was written to him, and well, I might know whether or not I had an extra $123,000 or whatever it was, or 21. Alec always seemed just sort of disheveled with his own funds, so it made enough sense, and there wasn't enough there to get in a brouhaha and terminate somebody or create more of a fuss than it was, but it wasn't swept under the rug.
And a rainmaker like him.
Everything seemed to fall into place at the time. Now, obviously,
A
had we
rainmaker
known
is the one who
any of
generates
the other stuff at the time
money
we
by
found out in
bringing
September,
clients.
then it would have been a different story.
And to most big
But bottom
firms,
line is, he got
the most significant
he got
person.
discovered.
'Cause he's bringing the
Oops, it was a big
clients.
mistake, he says.
You don't
He
survive
pays
without
it back,
clients.
and people move on, right?
And that was in 2018.
That was in 2018. And we're talking about the check written that was supposed to go to his brother that went to him instead.
Right.
And he was never one to loan money for those operating expenses generally, is that right?
I think he had loaned once or twice, but
Once or
not,
twice.
it wasn't regular.
Right, and not around this time period, correct?
I didn't go back and look at that part of it. I
It was
more
$125,000 roughly, something like that?
121, 125.
All right.
I was more concerned about how it happened to begin with. Randy's initials are RM, and Alec's initials in our system are RAM. So that was,
And what he did was he gets that check, and instead of saying, this isn't $120,000 for me, he actually goes to staff a couple days later and says, I lost that check, cut me another one, right?
yes, sir.
And then he cashes that one, right?
He eventually cashes.
He cashes the
first
second one
Yeah,
in pretty short order, correct?
He cashes the first one in October the next year.
And
He
then
cashes-
sits on the other one for an extended period of time and then cashes that one, right?
He did,
He's a
Steals the
thief.
same money twice, right?
yes, sir.
That's pretty funny.
What was the word you used before, cunning?
Very cunning.
He's slimy.
And you mentioned that it wasn't swept under the rug, but he said, oh, it was a big mistake, and he pays the money back, and then people move on, even though because, okay, it's just Alec, that sort of thing, correct?
Correct.
But there are other instances like that, too, over the years. For example, using private planes
Are you
for
testifying
personal
now?
use and billing that to the firm.
What is
that
this?
right?
Seriously.
Or to,
Objection
Well-
assumes facts, not
or
evidence.
explain
Some,
that.
some of that, but the biggest thing was the credit cards using, he just wasn't a very good rule follower at all. But he,
With other people's money, right?
well, yeah, I mean, anytime you're in a law firm or you're working for somebody and you've got a card or a check that's got their name on it, then you owe them a responsibility to spend it properly. And
It's other people's money, right?
it's other people's money.
And he would spend personal use on the credit cards, and y'all have to talk to him about that, right?
Yes, sir.
And that was going on repeatedly, correct?
Up until the end,
Put tuition on a firm credit card for one of his children, correct?
he did.
I had to talk to him about that, right?
Yes, sir.
And he'd pay it back, and then people would move on, right? And that had been going on for years, had it not?
It had, but there were other people that would
But not like him, right?
not to that degree.
Not like him.
Not to that degree.
Now, you talked a little bit about the boat case, but back in May of 2021, Jeannie came to you and told you about what Annette had discovered about them receiving the expense check in the Ferris case, but not the fee check, right?
Sometime in that time frame, yes.
And your initial concern was, and you were concerned that he was going to try to hide assets because
Easy.
of the boat case.
Easy,
That was
fella.
part of your concern, and the firm was not going to participate in that if that was what was going on.
That's correct, that he was either going to structure them or leave them in somebody else's trust account until it had passed. I mean, we weren't going to fudge our books for that benefit.
And you were aware that
Not for that benefit.
in the boat case, they were seeking a personal recovery against Ellen, correct?
Yes, sir.
We do the loans, the start of year loans. That's how we
Yeah.
fund
And
this.
that caused you
loan
concern
sharking.
because this firm was not going to participate in helping him hide assets because
paid
of this boat
60%
case, right?
interest.
That was your concern.
He or anybody else.
Yeah, or anybody else. And you had continued conversations with Jeannie over the next few weeks about this because she couldn't get a straight answer as to what he had done with those fees, correct?
Myself and Jeannie and at least two other partners.
Cope?
Lee Cope and
Another partner?
Ronnie Crosby.
And Ronnie Crosby. And couldn't get a straight answer, could you?
Well, we weren't getting a straight answer,
Weren't
so
getting a straight
we continued, but we didn't want to make it a big deal if it wasn't a big deal, but because we didn't have the information, we couldn't make a decision.
And then on June 7th, 2021, Jeannie went in there to demand that straight answer, correct?
Yes, sir, I didn't know that until June the 8th.
But you knew it was coming to a head, didn't you?
Yeah, I mean, Jeannie's tenacious. I mean, she's going to get to the answer. She's not going to let go until, and it wouldn't just be this, it would be anything.
I don't think this was
Unlike
a good
the other
witness for the
times, Alan
defense.
didn't have the money to pay it back and make it all go away, did he, this time?
I didn't know that.
But you know that now, don't you?
Well, yeah, obviously, the whole world does.
Like, I don't think this was a wise call. 'Cause you knew he's trying to turn the tide back into like, here are all the reasons you, the jury, should hate him because he's obviously
Maggie
a
was your
thief.
friend?
Who?
Maggie was your friend?
She was all of our friends, yes. Paul
Paul was
was,
your friend?
sure. He was dear friends with particularly my youngest daughter.
He was a good kid?
He was a good kid. I mean, he had his issues like everybody else. I mean, I don't know anybody that's raised children. If they say they're perfect, then they need to write a book. But, I mean,
I don't think any of us want to be judged by what we did when we were 18 or 19, do we?
I don't want to be judged with what I did, or I really don't want to be judged with how I raised my children. But, those are individual decisions. But, Paul was a good kid. He was always polite. I could have picked up the phone and called Paul and said, hey, I need some help over here on my farm. That kid would have come in a heartbeat.
All of this
he
is
was
completely immaterial
just
to
a
murder.
Good kid. Now, did he
This
do
is a
some
waste-
devilish things? Absolutely. I hear about them,
But-
and occasionally,
When you're
if I
bringing a
saw him, I'd
witness,
say something to him about
there's
it.
the
But
pro and the
he
con.
was a good kid. I mean,
And how much pro is there
great
for Alex
outdoorsman. He grew a garden.
by besmirching
I mean,
Sled compared to reminding
Randolph,
the
who
jury
they
why
call
they should
handsome.
hate him?
I mean,
Cross.
he'd do anything in the world, and
That's the legal
after the
strategy
boat wreck,
you
the
need
two
to
of them
consider when you put this
were
guy up
almost
here.
glued together.
Well, the Sled stuff's relevant to murder.
And I mean,
Yeah, but
it's just a total waste of
yes,
a kid that had never found his potential yet, but would have, I'm quite confident.
And after this tragedy happened to the family that was this law firm, everybody was focused solely on that, coming to support one another and coming to support Alec Murdaugh. Is that right?
Absolutely.
And the last thing on anyone's mind at that time was those dadgum Ferris fees when this happened. Isn't that right? And you've said that.
We actually, at least myself and one or two others said, well, we'll have to put that on hold. I mean, it was a conscious, it wasn't just we're not going to subconsciously, but we consciously said we're going to, a man just lost his wife and child. There's no way we're going to be cruel. We'll get back to it later. And we did.
Got back to it later. A couple months later, right? Or a month later.
A month later.
You're advised that, oh, wait a minute, Chris Wilson says he has those fees all along, right?
It's what I was told.
Because in the wake of those murders, he had managed to borrow some money from Johnny Parker, right?
Well, he
Found
didn't say
that
he
out
had the money
later.
all along.
He
He
had
said he had
managed
the money
to-
in his account.
Have Palmetto State Bank through Russell Lafitte give him $350,000 in undocumented funds, correct?
I found that out later as well.
Just like
after he'd been
before,
terminated.
you get an email saying, yeah, I'm Chris Wilson, I got the fees, and that kind of put the matter to bed at that point in time, right?
That was in July, yes.
Paid it back again, or at least you think, and just like before, people move on because you're still dealing with the tragedy of this terrible set of murders, correct?
By July, we were dealing with that and still this idea of the boat wreck, and what he was going through. I mean, you rally around your family and your friends.
You rally around him, right?
Yeah.
And you also would have rallied around him if his dad died, right? That's what you do with family. Your dad, the famous
And that's
Randall
not to any way
Murdaugh.
All this is
throw
true,
cold
even
water on
if he is innocent of
any
murdering
of the
Maggie and
claims
Paul.
of
Yeah.
the people in the boat wreck, but everybody deserves a defense, and you defend your friends and your family, but you do it morally and honestly.
It's what people who think they're friends do, right?
You hope they do.
September 3rd, or thereabouts, Annette finds this Chris Wilson check in Alex's office, right?
September the 2nd, I believe.
September 2nd,
Yeah.
States 313.
I
I'll show it to you.
I can't see that fully.
Sorry.
Ladies and gentlemen, I think we'll take a recess at this time. Please go to the jury room. Please do not discuss the case.
Jury room.
Yeah. So, look, I understand what you're saying with respect to, that he's coming in there to talk about the murders as opposed to talking about this other side stuff about how he's a thief and all that other stuff. I get that, but you knew this was going to come, and the question is, okay, they showed some sloppiness, some sled. We'll call it serious sloppiness, some sled. Is that do you think the jury is going to say, well, because of sloppiness, some sled, I'm now not going to convict him? That's more likely than them saying, wow, I really hate this guy, and we know he's a thief. Like, I think that downside that is coming from this witness.
Well, of course, juries can do whatever they want, right? So if they want to unjustly convict Alex of murder because he committed financial crimes, they're free to do that. I don't have anything to say about whether a jury is going to go off the rails.
Right.
But if it's going to be a just conviction, this is immaterial.
Okay. Fair enough. I just feel like in the wake of yesterday's testimony, where we have, Buster come up there and start getting a little bit of a warmer side to Alex, and then we have this, the forensic evidence saying, look, the killer had to be much shorter than Alex. In the wake of that, to rekindle the jury's animus toward him, presumed animus based on him being a pretty filthy thief. I mean, just a gross thief, and just reminding him, walking us through all the ways that he steals the same money twice from his, friends. It's just, I don't know how much is worth it. Or at least if you're going to do it, I would have put him before the sentimental testimony. I don't know. That's just my thought. But I wanted to just talk with you about what they opened this morning. If you came late this morning, at the start, before the jury came in, there was a question that Jim Griffin painted to the judge. He said, look, we're obligated to advise our client as to our perspectives as to whether or not he should waive his Fifth Amendment privilege and take the stand. And part of our calculus for this is we need to know what the court is going to do when the prosecution predictably asks him about his financial crimes. Now, we understand that the court allowed the financial crimes to come in here for the purpose of establishing motive, but we'd like to have a limiting order from the court that the court will not allow the state to ask questions about the financial crimes if, in fact, Alex takes the stand. And the judge asked Creighton Waters to respond, and he was very clearly prepared for this. He was citing statutes, case law, on and on, as to all the different bases as to why it is that the state should be permitted to cross-examine him specifically about these financial crimes if, in fact, he takes the stand. And there's a myriad of reasons as to why Creighton Waters really wants to win this argument. I mean, if you think about it, A, it chills Alex from deciding to take the stand. And if he takes the stand, he might look more sympathetic, so they don't want him to take the stand and be able to explain things away.
Or if he takes it, make him pay a price.
And B, precisely, if he takes the stand, great. Now we'll be able to basically get him confessed to his financial crimes or look like a complete and total liar, get him on perjury. It's like you're putting him in a lose-lose situation. I talked with you and Nick about this a couple of weeks ago when the judge first started allowing this in, and the impact that this may have on his ability to take the stand in this case, because by taking the stand in this case, he's almost forced to implicate himself on these pending crimes of fraud. Now, there are, and the judge basically seemed at first to be leaning towards Creighton Waters and saying he'll allow it. He was sort of dodgy, saying I'm not going to weigh in in advance.
Well, that's the contemptible part of all this. I don't blame the prosecution for arguing that everything should be open if he takes the stand. I don't blame the defense for arguing that the questioning should be constrained. Perhaps their client should be able to plead the fifth to things not related to murder. I think those can both be good faith arguments made by both sides. What's contemptible is that the judge is not making effectively an in limine ruling ahead of time and obliging the defense to take the risk. It's like if there was a box you could stick your hand into. You don't know what's inside the box. So, I'd really like to know if there's a rattlesnake in that box. And the judge says, well, stick your hand in, find out.
Yeah.
As opposed to opening the top of the box and knowing whether or not there's a rattlesnake in there. Right. Maybe the judge can say there's no snake, or the judge could say there is a rattlesnake, but then you're making an informed decision. Right. For the judge to say, well, just try it and see what happens. That's contemptible.
Yeah. I wholly agree with you on that. I don't see what would stop him from pleading the fifth if he is asked about the financial crimes.
The truth is the facts and the law in this case have become so convoluted, I don't actually know what the answer is. I'd actually have to do legal research because I can see legitimate arguments on both sides. Mm-hmm. So I'd be looking at case law to see if this has come up before in South Carolina, what the courts have said, because it's odd for someone to be able to testify to what's in favor of them and then plead the fifth on things that are damaging to them. Really, if you take the stand, you should be opening yourself up.
Right.
Especially things that go to credibility, and theft of everybody's money goes to credibility, right?
If we could just pause for a moment and explain what areas, when crimes in general are allowed and when they're not. And the general rule is if there's a conviction and it's related in some sort of way, that would be something that's admissible.
Or at least recent in time.
Right. And if there are there are crimes that show a propensity for dishonesty, like fraud, like these types of crimes, that too, even if he was now being charged, even if there was no ruling from the judge that fraud had anything to do with this case, even if the state never alleged that had anything to do with this case, if he had been convicted 20 years ago of fraud and he takes the stand now, the prosecution would have the right to raise that in order to point out to the jury, this guy has been convicted for lying, for having, for committing crimes that show a propensity for lying. Therefore, you should not trust him. But if it was just charges that were brought against him, he was never convicted, they would be precluded from bringing that in. Even if there's been such a lot of testimony and all this other stuff, unless he had been found to be guilty of those crimes, even if he had been civilly guilty, he probably would not be. They would not be able to bring it up if he had not been found criminally liable. Although I think that's a little bit more. That's a little bit. It's a little bit dicier. The point is that there are circumstances that this sort of thing, when you have a conviction, can be brought in. And what Jim Griffin said is it's only if there's a conviction. Since there's been no conviction on it, they should not be allowed to bring it in. On the other hand, we've seen this judge has allowed a lot to come in on this, and you could see him saying, well, it's highly relevant to this whole situation. It's not a simple legal question philosophically. It's not a simple question at all. There are a lot of different factors, and like Andrew's correct, neither of us are equipped right now to weigh in on what South Carolina law would indicate should be the way the judge should rule on this.
I mean, it's really a subtle legal issue, especially given the complexity of this case, how complex the judge has allowed it to get with all these issues being brought in. I mean, at the end of the day, I'm not sure it matters for the defense substantively. I mean, effectively, Alex has confessed to everything. He took a judgment on the Ferris money. He has taped recordings with the police after the roadside incident where he's confessing to stealing other people's money. I mean, other than the murders, what's really left unconfessed to? I think you take the risk on the money stuff to get out of the murder conviction when effectively they already have the money stuff.
Yeah, I would agree with you, and I would try to plead the fifth on those questions. If in fact, he is asked those questions, I would plead the fifth. And the judge. I mean,
what's the judge going to do? Hold him in contempt?
Yeah, I mean, say no. You must answer. I'm going to hold you in contempt. That's the judge is putting himself in a precarious position if he like says you're obligated to answer these self-incriminating questions about an unrelated case. I mean, presumably unrelated is, something that forced him to confess to crimes. That would seem to be almost ridiculous. So in that sense,
I guess the judge could say that, well, if you're not going to answer, I'm going to let the state bring in additional witnesses to testify about your financial crimes.
Big deal. Big deal. Like that's better than him confessing. But
I mean, I think the play for Alex is to come in and do the sympathy play. Say, yes, I stole all the money. I stole all the money. I was a drug addict. I stole all the money. I did what drug addicts do. It was terrible. I was a traitor to my friends, to everyone who trusted me. I did the things that a drug addict does, and I feel terrible about it. And I'm going to be held
and I'm embarrassed.
Accountable for that.
You admit you're embarrassed by it, and that because you show that like now you're recognizing the wrongness of it when you say that you're embarrassed by it.
But I've never physically hurt another human being in my life, and I certainly didn't murder my wife and son.
Yeah, the last people I would ever do that to would be them. If I could ever find it in the strength to do that to anyone, it would never be able to be against them. And he'll be questioned about his lie about the kennel, and he has to basically explain. And that's why you have the shock witness.
Right.
You need a shock expert to basically come in there and explain why it is that he just.
And he can. I mean, of course, he's not going to say I lied about the kennel. He's going to say I thought I was telling the truth.
Yeah, yeah. That's at this juncture, that seems to be his best route to just plead mea culpa on everything. And
I mean, it would be interesting. So, say he takes the stand and he pleads the fifth, and the judge threatens him with contempt if he doesn't answer. So now he's being compelled to answer after having pled his fifth. I wonder to what extent those facts would then be. You could argue those facts should be excluded from the financial trial.
That's exactly yeah. That's what in theory that actually could happen.
That would be a clever play. It's beginning to look like a movie trial now. He gets acquitted on the murder, and he gets all the evidence for the financial crimes taken off the books.
Out, yeah. Although they probably would just strike his testimony, if anything, from being admissible as as being tainted, but all the other tertiary stuff would still be admissible in theory. Let me get to some of the super chats here. C Mills says, can he just plead the fifth if he asked about the financial stuff since there's still a pending cases? That's what we were just discussing. Yeah. Frank, I really think the reason the state made such a thing of the financial stuff was to keep him off the stand. Makes sense. For the love of law, where we go one, we go all. Love it. Rested Sound, credibility is relevant because even someone with good credibility is going to deny a murder they did. Good or bad cred result in the same behavior here. Okay. BMX Jedi, shooter height is because barrel has to be 3 feet away. A sawed-off with no stock could change that. Is that true? As far as the stippling and all that other stuff? That you would.
I mean, a little
stippling
bit. You don't have a buttstock, so you're saving what, 10 inches of length on the weapon. So
the state says the Camo Benelli could have done better. Where's Joe hiding? When I was away for like 10 minutes, I was actually watching the trial with my camera and mic off while eating breakfast. So there you go. Play catch up tomorrow is what I'm doing now. DCV Titan says, wow, said they got all they needed, left a chunk of skull behind. How can anyone question this investigation and trial? And like I said, I mean, was there anything else? Was there anything beyond that? Because he was up there on the stand for a long time. It just felt like, he mentioned that he searched phone records, but I don't know what we got from his search of phone records. It was just like a lot of like almost like tease that we're going to get something.
No, that wasn't productive by the defense. They were trying to get him to say that the paper records were more comprehensive than the downloads from the phones, I presume, so they could explain away the missing records from Alex's phone. Right? There's a call to her from Maggie that's on Maggie's phone, but not on Alex's phone. Did he deliberately delete it? By the way, folks, in terms of these deletions from his phones, he may have been a habitual deleter of his phone log because of all the drug activity.
That's true. That's a good point. Or mob ties. Tyler M says, so you're telling me the SLED team was done collecting evidence in barely 24 hours and left a chunk of Paul's skull on the floor? Speaks highly of the level of professionalism. Absolutely pitiful. Yeah, a chunk of skull seems like a pretty glaring omission from the cleanup crew there. Alyssa Ramirez says, any Southerners think guilty? Culture clash? Mama Bear, especially if they were aware SLED would take 2 hours to get there. I'm not sure what she's referring to with that. Mama Bear says, beyond SLED doing sloppy things, I agree with that. Why, when his friends, who are all lawyers, would be trampling all over the crime scene? Wouldn't they want to preserve it to catch a good friend's wife, child killer?
I don't think they were.
Yeah, I'm not sure that they were tracking down by the kennels. It sounds more like they were converging on him or by the house. So, Q says, the FUQ is he going to do, Joe? Take away his allowance? Oh, this is when I said that he's not the age of majority. It's a pet peeve of mine that the guy was talking about drinking and then saying, well, he's 18, he's reached majority. It's a pet peeve only because I think it's wrong that the states were all forced to up the age majority on drinking to 21. I think that the federal government really put such pressure on them. And it's a story. It's a story from when I was taking Barbary. That's what got me to raise that, because I remember that in con law that they were talking about how the federal government has no right to tell you each state what minimum drinking age is. So instead, what did they do? They say, we're not going to give you any highway funding unless you raise minimum drinking age to 21. So it's like, yeah, okay, you're under local governance, but it's local governance that has no choice because they need money. He said right away, overnight, like 49 states signed up and raised their minimum drinking age to 21, except for Louisiana, because of Mardi Gras. They were like, we don't want to raise minimum drinking age to 18. And the result was that Louisiana basically had crappy roads and a lot of drunk teenagers trying to navigate them. Welcome aboard, Jeffrey. How are you?
Oh, good. I love when my 90-minute streams go 3.5 hours.
Well, I'm glad you're able to pop in here.
What'd I miss? By the look on Andrew's face, I missed a whole bunch of excitement.
Okay, well, the morning started basically with a discussion as to that Jim Griffin is like, we want to give advice to our client as to whether or not he should take the stand. And one of the factors which we want an answer to, we're hoping to get an answer from the court, is the prosecution be allowed to cross-examine him about his financial crimes? And the judge basically said, well, we'll cross that bridge when we come to it. And he's like, but what am I supposed to tell my client? like what am I supposed to do? At least tell me he's going to come in so I can tell him don't or whatever. But at least we know this. And the judge is like, well, as Andrew analogized, it's like basically saying, put your hand in the box and we'll find out if there's a rattlesnake in there afterwards. So, which I thought was a perfect analogy. And then we've had this morning a friend of Alex Murdaugh came in here, another attorney, who came to the scene afterwards and was testifying about how sloppy SLED was and how he found bits of skull 24 hours after they finished cleaning things up. And on cross-examination, Creighton Waters is crushing him about how he never really knew Alex and that he was doing drugs and that he's basically
A bad man.
A bad thief, stole from the firm, and basically
A drug addict thief of his friends and money.
And we're on break in the middle of that cross. So that's
all right. Well, listen, I'm not able to stay the whole day today. I got some stuff I got to take care of, so I'm going to take off now.
No. First, tell people who you are, what you're about.
Oh, sure. Let me see. Let me pull. Good call, Joe. I got distracted by.
Yeah. What the heck's going on here? You better hurry because I don't know when we're coming back from out of break. So hurry up. Let's do this.
What am I trying to do here?
He's law of self-defense. He doesn't always remember this. He's law of self-defense. He's got a course that's coming up on April 15th.
Here we go. I got it up.
He's got a book.
I got it up.
All right, go.
Talk about Get Hard in a minute. Law of Self-Defense, advanced live online class, full day course, taught live by me, streamed to you at your computer. Saturday, April 15th. Learn how to be hard to convict if you're ever compelled to defend yourself, your family, your property against criminal predation. And if you sign up for that April 15th class this month of February, so just a few days left, folks, you get 25% off your registration. You can learn more about that. And register at lawofselfdefense.com/advanced. Also, you can get this book, Law of Self-Defense Principles. Check it out on Amazon. Check out the reviews, 1,200 plus reviews, 5-star rated, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. I only ask that you cover the shipping and handling. Again, learn how to be hard to convict. Get this book for free at lawofselfdefense.com/Joe. And if you'd like the beautiful, very handsome hardcover edition, lawofselfdefense.com/gethard.
Thank you for joining, my brother.
Pow. I may be able to join later in the day. I'll have to see how things go.
Are you going to be able to be here tomorrow? You're going to be in Vegas tomorrow.
I will not be here tomorrow.
All right. Well, thank you for joining, brother. Take care.
Bye-bye.
He just got that Grifton right under the wire.
Yeah, you must have something really super important to do if you forgot to grift.
Seriously.
I love you, Andrew. Wow. So this is his drugged out loser thieving partner.
Sure, thank you.
No, this guy seems like the most sincere, nicest guy in the world. But he's like not holding back from giving him
I
up.
think when we left off,
He seems
I'll
very
show you
straightforward.
states, what is that, 313, I believe?
He really seems like a teddy bear.
313.
That's the fairest check that was found in the defendant's office that he had lied to everyone and told that he never received.
This is the first one.
One of them at least, correct?
One of them, the first one that we knew of.
And then we're around September 2nd or something like that, and around that same time, Jeannie starts or researching in y'all's system forge, and then finds all the fake forge checks. Is that right?
She used the query forge to see whether anything had been put into an annuity, any fees had been moved or put under an annuity, and a list came out of, I don't know, 10 or 12 different cases.
Soft-spoken man.
And y'all called the real forge and said, y'all have any of these clients? And they said no. Y'all ever banked to Bank of America? They said no.
We did, but in that list, like the fourth or fifth one was a client that I was representing, and the money was to be held in trust. And when we pulled up the documents, supporting documents, it had a notation on it that it was invested for 3 years, which I knew couldn't be, so I went and called the client. The client verified that he hadn't authorized anything, hadn't done anything, and I immediately told him that his funds would be put back in there, and I walked back across the street to Jeannie's office and told him we had a big problem.
And that was Thomas Moore, correct?
That was Tommy Moore. Yeah.
That was a highway patrolman who had been injured, correct?
Correct.
And Alex stole his money?
He did.
And they had been friends, to your knowledge?
As far as acquaintances, friends, I'm not sure what their relationship.
And I'm not going to go through in great detail because it's already been done, but generally you and Jeannie were probably the main drivers of the investigation into all of this theft in States 314, this spreadsheet.
All of us were involved, but I was with Jeannie a vast amount of the time.
I'm sorry.
I was with her a vast amount of the time, going through and auditing them and checking to see.
And ultimately you had to reach out and talk to a lot of these clients of Alec Murdaugh's, right?
I did.
And you had to tell them what had happened?
I did, including 2 weeks ago or 3 weeks ago, another one.
I went
You had
to a
to tell them
financial
that Alec had
investigation
lied.
and a murder trial broke
I
out.
did.
And they said, Alec lied to me. He never told me that, correct?
Response?
I'll move on. You had conversations with all those clients, the clients that you dealt with, right?
I dealt with the majority of them, yes.
I'm going to show you what's been marked as Exhibit 314. Just real quick. Go through and just, don't have to go into anything more, but just list the names of people that you had to deal with personally over what he had done.
Well, I was involved with the one for Barrett Bowler with Ronnie.
All right, let's talk about Barrett for a second. That was one of his close friends, right?
He was.
And can you describe the money that he stole from Barrett?
Barrett had a fire on a piece of property that he had, and it burned down the house. And there were proceeds for cleaning up, and then there were proceeds for various and sundry things that were associated, as well as the structure. And we started looking at it and figured out that the $75,000 had been stolen, and then later on that there was an additional amount that never went through there.
How much was that additional amount?
$279,000 according to this exhibit number.
That was a close friend of his, correct?
I
To
would
your
say,
understanding?
I would say that was one of his closest friends.
One of his closest friends.
That's who he ended up getting Moselle from.
And when he stole that $75,000 from Barrett Boulware, Barrett was sick and needed that money to put his wife up in a hotel near the hospital he was at, didn't he?
Barrett was dying of colon cancer, yes.
And needed that money, and Alex stole it anyway, right?
I assume he needed the money.
All right, keep going. Just, again,
The next one down is the estate of Jacob Hirschberger. And at first,
again, we don't need to give me each one, but that's one of them that you had to deal with?
that's one that I just dealt with 2 weeks ago, and we're still straightening it out.
But the firm had to straighten it out and deal with the money because he took it, correct?
We are now. We're in the process of it.
After talking with the clients and everybody else involved, right?
Correct.
All right, go on to the next one, please.
You want me to give the names, or?
Yeah, just give me
Mr.
that.
Anderson I dealt with, Dion Martin, his family I dealt with.
All right, let me slow you down. So Christopher Anderson, you said, was somebody you had to talk to yourself?
Yes, sir.
And y'all the firm had to pay money for what he did, correct?
Yes, sir.
Dion Martin was somebody you talked to yourself?
I did, and along with
Those of
him,
you who are
And
talking about how
injured
this
in
is
an
beyond the
accident?
scope.
he had a brain injury, correct?
And had a brain injury.
Yes, sir.
You had to talk to him about the defendant lying to him with his brain injury.
To some degree, this
And his
witness was a
parents.
And his
character
parents
witness.
had taken his money, correct?
As a
Correct.
character witness, he can be crossed to show the negative character of the
Elise
defendants.
Mallory,
Elise Mallory, and she had a relative who died, correct?
she did, and I had
So-
Very
represented.
sweet old lady. Have you met her?
It's like, you're telling us what great
Well,
character he
Elise-
is. Let's talk about what a terrible character
That's what I
he is.
mean.
She's not real.
Oh, I'm sorry. The person that you dealt with, the personal representative.
This is
And
why I
then-
said I don't like this witness being called by the defense. I don't think this was a good thing.
Is she a very sweet, nice lady? The PR?
Yeah,
in that case?
I haven't had a single one of these clients that weren't nice people,
Very nice people.
super nice people,
And he
and
took advantage of each one of them and lied to them, correct?
This is terrible for the defense. That's why I
Tell me
said
some
it's
the
nice
Richard
that he got in
case,
bad stuff
wasn't
out sled. I don't
involved
think
in
it's
it.
worth it
Johnny
at all.
Bush, I dealt with him. I talked with
What
J.J. Jinks.
good did they get out of him?
To your knowledge,
The
Johnny
defense.
To
Bush
me, it was very limited.
considered
Yeah,
himself a friend of Alec Murdaugh's?
he walked around and basically
I
saw
don't know
how
whether they
sloppy
were friends,
sled
but they were
was.
good acquaintances. Johnny was a little bit different. He overcharged him or gave him the impression that it was
Andrew's position is, well, this is a murder trial. That's relevant. The sled
So
stuff
he
is
lied and
relevant.
told
This
him
stuff
that
is
there were
not.
expenses that had to be paid, and instead Alec Murdaugh stole that money
Here's what I
from
think
his good
Andrew and
acquaintance,
people who are
Johnny
taking
Bush,
that
correct?
position
That's correct.
are kind of ignoring. If you're fixated on this being a murder trial, you already
J.J.
think
Jinks,
he's not guilty.
He
So
I
you're not
talked with
pitching to
J.J.,
those
but
people
I didn't
anymore
deal with
because the state hasn't done enough
him back part
to
of
your
it.
mind. The only
Well,
people
the
you're
firm still had
pitching
to
to
pay
are the emotional
him back.
ones.
for the lies that Alec Murdaugh told, correct? And for the theft.
Correct.
All right, keep going if you would, please.
The Christiani matter is still ongoing.
All right, keep going if you would, please.
And then Randy Drawdy, that matter's over. Tommy Moore, I've dealt with him. His money's back in trust, where it's supposed to be.
All right. Tommy Moore was a highway patrolman that got injured in the line of duty, correct?
He was.
Maybe
And
some
Alec
people think of
lied
it
to
that
him and took
way.
his money, correct?
I don't know.
This is not all of them either.
So that's the ones for now, correct? That's the ones that are on that list that's been admitted to evidence here, correct?
Correct, but there's a good many more than this.
Are you aware in your conversations with the defendant that back around the time of the recession that he had gotten into some land deals that had gotten him some financial issues?
I think it was squeezing him, yes.
And then, not long after that, he had some big cases, such as the Arthur Badger case and the Pinckney UPS case and the Plyler case, in which he got a large amount of fees from very large recoveries, correct?
Badger was the UPS, Pinckney was the tire case.
Okay.
But yeah, he got very big fees.
All right. And you thought that with all those fees that you knew who he got because he's your partner and you get to see the books, you're the treasurer of the firm or have been for an extended period, is that correct?
For the old firm, yes.
And you thought that the money that he legitimately got from those cases had solved those problems because it was a lot, wasn't it?
I think I, along with everybody else, thought that he was totally out of any debt.
But on
to speak
top,
of.
but you've come to find out on top of the fees that he got, he also stole millions from those clients, correct?
Yes, sir.
It wasn't enough for him, was it?
Clearly not.
I'm almost done.
I want to point this out to you, Radioactive, and everyone else.
Going back to that scene.
You can fixate about what the jury should
went
be
to.
doing. That's nice. As a lawyer, you should be fixating on what they are doing, not what they should be doing. This is not a matter of principle. This is a matter of succeeding at winning a trial.
You didn't see any blood on Alec Murdaugh that night, did you?
No, sir.
And when you went back the next day, you went back because y'all had attempted to call, y'all had called the coroner to get the names, and he had given you the names of some companies that their job is to come out and help clean up scenes like this, correct?
That's correct.
And y'all had called them, but nobody had called back, and you just felt like you had to do something, so you went to the scene. Is that right?
Well, we were trying to also see what we could find out, if there was anything that we could do to lend assistance. I mean, this was something that was, I mean, everything stopped.
Everything stopped.
The whole world did.
And being a friend like people would be and just trying to do whatever you could, correct?
Friend and, we're lawyers. We try to figure out what happened to things.
And you went in that feed room and observed the things that you saw.
Maid's son, I think, is.
And you also ended up getting blood on your sleeves, correct?
I did. I didn't know.
Up high, correct?
On my shoulder
Everyone who was
areas
near there got
and on
blood,
my pants.
except for Alex.
I asked you a little bit about the defendant's cell phone use. Was it like him to have very short phone calls, or was he one to talk for a while?
I mean, he would cut you off with one phone call coming in on top of another. He'd call you about something and say, "Oh, I'll call you back." And click it off, and
But he'd start talking about something, right?
Yeah, but I mean, he would. It was regular.
It was regular. He would typically talk for more than a minute, though.
I mean,
said that,
I would
correct?
assume so. I mean, most people, a minute is not much of a conversation.
It's not much of a conversation just for a minute, is it?
No.
The night of the murders, did you see a golf cart up at the Moselle residence?
I saw one in front of their house.
I get the feeling the
Yeah,
cross-examination has gone
driveway
on
was
longer
over
than
to
the
the
direct.
It was parked in front of the house.
It was parked
It's been
off
a
to the
while.
left side of
both
the house.
both have been too long. It's been all morning with this one witness. I mean, and like, how much information is he covering already?
Going back to September, and y'all find out about the Ferris fees, and y'all find out about fake forge, and y'all have a meeting of partners without Alec there and without Randy there, correct?
Well, first of all, on the 2nd, which was Thursday,
Right.
when the stuff with Forge came up and you started looking down, when I made the phone call to Tommy Moore, and first thing Jeannie did was
Come on, Lauren Cuck. You can do it. You can do it. You can do it.
Come on.
And by the way, I want to be clear to those of you who are still confused by my position. I'm not saying I know what the jury is thinking. I don't know what the jury is thinking. I'm saying you're covering your bases.
our check.
If the
All we
jury's
could see
thinking
was
like
our end of
most
it.
of the
So if
people in
a
my
check was
chat here,
written off of our
then you don't
trust
need to
account
worry. You
or
already
our
you already won
operating account
with that
because we lost
juror
the trust check.
because the state
If it
has
was written
failed
off
miserably.
trust account, we could get a copy.
the
of
And
our
this is the
check.
this is the
Potential
only
jurors
stream that
were
thinks
already
that.
gone from
That's the
there,
problem.
and
This
we
is the
could see
only
Right.
stream that
disbursement
thinks
sheets,
that.
and
Exactly. So it's
we
the
could
other
tell
jurors who you're worried
where
about.
they were deposited
The ones
by
who are not
looking at the
thinking
back of
like
the
you
check,
about what, well, hey, we
which
live
you
in
don't
America.
normally
It's
do.
got to
I
be,
mean, it's just not-
you're all
and
right.
when you started seeing
But you have to work in the reality
commonality
of
to
where
it.
you're in as to
And
whether or not
then
that's
the-
actually
the
being
Moore
applied.
thing was concrete.
If
and
it is
there's
being
just no
applied,
way
you already won. So you're only still fighting
that
for
money
the people
couldn't
who are
have
not
been
actually
written out
applying
because
that.
It was being held. He
you
had
have
an
to think of the
ongoing
smartest
workers'
way to
comp
approach that.
claim that
And I know he's
that
babbling
was
about
a
some other crime that he did now. He's been
statutory
doing this for
lien.
another hour.
You couldn't give him the money. And
Bottom line is, without rehashing the whole story for the jury again, y'all knew he had been stealing at that point.
that's when we found out, and then
Bottom line is
met-
you've been
Didn't
basically
know how
bringing up
much. In fact, you found out a whole
one
lot
theft
later,
after
correct?
another for the last
we had
hour.
about 6 at that time. I met with our president that night and Ronnie Crosby and set up a meeting for the next morning, and we met, and then Randy was tied up and they came, and at that point it was unanimous, and then Randy and Danny went and talked to him.
And then when confronted
He
with
admitted
that,
it.
and he was forced to resign, is that correct? Or y'all terminated him?
Well, he could either resign or be terminated, but it was a 30-second decision.
And what day was that when that happened?
That was Friday.
What day? Do you remember?
That would have been September the 3rd.
Third?
And we immediately started into all the things you have to do when you find out that a lawyer's been stealing in your firm, which has been absolute teetotal pure hell since then.
So everything was
Teetotal
coming
pure
home
hell.
to roost. The storm was arriving again for Alec on September 3rd when y'all confronted him. Is that correct?
That's- Yes, sir, and it was over.
And then on September 4th, what happened? What did you hear about?
I had spoken to Mr. Griffin just to let him know that we had terminated him. He already knew, and about 11:30, 12 o'clock, whatever time it was, I was on a tractor, and he called me and said, "You're not going to believe what happened." And I thought, my first response was, "Don't tell me that jackass killed himself." And he said, "No, somebody shot him." And I just said, "I don't believe that."
You don't believe that? A lot of people thought right away that, oh my gosh, the real killers are back. Correct? The chickens were home to roost again for Alec, and all of a sudden he's a victim again, correct?
Does the state
What
believe?
shit was that?
This is
Judge
ridiculous.
overruled.
What the hell are we even talking about? Now
went
is he
to
being
the scene.
charged
I
on the
went straight to the
fraud,
scene.
the insurance fraud
But
moment?
I didn't
This
believe
is
it.
so stupid.
You didn't believe it? Because you have training as a lawyer, right?
I don't know whether it was intuition, training, whatever, I just didn't believe it.
And what did you see at the scene that confirmed that this time?
I got
when
out.
It didn't work.
Danny and Ronnie were there and standing there, and I said, I don't buy it. And we walked up towards the car, and I think I said it's got run flat tires, and the tire's not flat. Before we got to it, Ronnie said, it doesn't even have a spare.
I would
And then
hit
when
on
we got up
this
to
on
it,
redirect.
You could see it at 9 o'clock where somebody had
Yeah, that one you saw
stabbed the
through.
tire.
But this one, you don't think he did these? You don't think he did these double murders, do you?
When Sled showed up, I think it was actually.
You have the ability to see through
David
things, and you
Owens
don't think
showed
he
up,
did these double
Ryan
murders.
Kelly showed up, one of them, and that's when we told him we had fired him the day before.
Why not? Why don't you
And
think he did it?
what had happened. We were
You could try to fix this mess.
in consultation with the lawyer we had to hire on Friday to figure out what to do and how to do it. And when this happened, we thought they needed to know.
And you were told that Alex claimed at the scene that he was shot by some unknown assailant, correct?
That was the story.
But
I
you
just-
knew this scene had been manufactured by Alex, correct, when you arrived there?
I didn't know that. I suspected. It just didn't look like, I mean, it was a shiny Mercedes black car with no holes in it, a single shot. There's the back hatch isn't open. There's no nothing. I mean, it just doesn't look right.
And just when accountability is arriving again, the defendant manufactures himself being a victim, correct?
That's what it turned out to be.
Thank you, Mr. Ball.
Redirect.
Briefly, Your Honor. Mr. Ball, to your knowledge, has the law firm, PMPED, repaid all the money to the clients that's owed, as well as insurance
That's not
companies
fixing anything.
that were pitched in?
To this point, we're holding some money as of 2 weeks ago, and in one of the matters, we're
That's
trying
really
to get
not
that money
fixing
returned.
anything.
We're having to go through a PI.
And the list of names that you read off, those folks, if they were entitled to the money now, they've received it? Is that right?
The people on that list have, yes, and there's plenty, a bunch more that have as well.
And the law firm is currently out a lot of money. Is that correct?
We are.
As a
No, the
result of-
partners are out a lot of
The law
money,
firm
not the
and
law firm.
Partners in the law firm.
Yeah.
We've had to pony it out of our pocket.
You personally have had to pony up.
Yes, sir, along with my partners.
And when Alec was resigned or terminated in September, he had some cash flow coming into the firm that the firm was able to keep and use that to pay some of the claims.
Well, no, sir. All of our funds, doesn't matter what I earn until it's declared at the end of the year, it's law firm money.
No, I understand that. So law firm money.
Where are the pineapples?
Earned.
I didn't do that. You're muted.
I just called you a liar. Does it sound better with, with the microphone on? Let me
Alex
repeat in case
cases.
you missed it. Liar.
Was the firm money when he left?
Well-
we're talking a couple $1 million.
First of all the cases are owned by the law firm. They're not Mark's cases, they're not Alec's cases. They're law firm cases. Cases that Alec was working on generated monies, and we internally decided how we were, the formula that we were going to use, because people had to complete those cases. And we've allocated much, much more than ordinarily. Our expenses are taken out in a different way, but we allocated a bunch of money to paying those, yes.
I understand. But the income from those cases, north of $2 million, perhaps?
Yes, sir.
And your firm and Jeannie Seconder and others have cooperated with SLED and the Attorney General's office in their investigation of Alec's misdeeds in relation to those client matters, have they not?
We have.
And as a result of, I mean, you're aware that Alex has 90-plus pending charges against him for financial, the stuff you just testified about, right?
Yes, sir.
And you've been subpoenaed here today to testify in the murder case, correct?
I've been subpoenaed since this trial started.
Just waiting for the
And
murder
you know
trial to
this is
start.
The murder case.
Yes, sir.
Now, immediately after the murder of Maggie and Paul, and you talked about Alec's demeanor, did he come to work and was able to work on cases?
No, sir. He was out for a while. I think he went to his in-laws and stayed. He didn't, after the funeral was either Friday or Saturday, I can't remember, and then Randolph died on Thursday after this. And then Randolph's was on Sunday, and Alec he was staying between Randy, John Marvin, and whoever else, his mother's house. I think he went to his in-laws. I know he went down to visit with his brother-in-law and sister-in-law.
Sure. And,
But no, he was not. There was a period of time he wasn't doing it. He might come by and he would be in his office generally looking at sympathy notes.
and from your observation, was he in any frame of mind to do any productive legal work the month of June?
No.
The month of July?
We sat down and talked about it as partners and not with Alec about what we were going to do.
This guy's going to
because
retire and
there's
invent a
deadlines
board
and
game
things
called
that
Jump
have
to
be done.
Conclusions.
And so we were going to try to figure out how we were going to delicately kind of start stepping in on some of his cases and making sure everything was being done according to what needed to be.
And I think you testified about how the firm, partners in the firm, lawyers in the firms were reaching out and using your resources to try to find out perhaps who played a role in killing Maggie and Paul.
We absolutely were.
But were you careful not to go out and do the investigation yourself and just relay the information back to SLED?
Right. I mean, we weren't trying to be private eyes or any of that. We were just trying to see, and I relayed numerous things to the various officers, and I would preface it by, I don't know whether this means anything, but you never know. I mean.
And to your knowledge, was information being relayed through Alec's attorneys to pass on to SLED?
Well, I know I dealt with you on various things up until the stealing.
Sure. And to your knowledge, was Alec consenting and cooperating with SLED in their investigation?
As far as I knew, yes. I mean, I wasn't with him during those interviews or anything else, but as far as I knew, he was. And I would ask him, where we stand, have you heard anything?
Right. And were you aware that Alec Buster put up a reward?
I was.
Ask me if he thinks he killed him.
You're also aware that
Do it.
when Paul was criminally charged in the voting case, Alec came under criticism for interfering in the investigation. You remember that?
I was.
And in fact, there's been some pretty public allegations about that, about Alec, that had surfaced before Maggie and Paul had been murdered.
Absolutely. I mean, they were criticizing him for advising people of stuff, but I'm a lawyer, I'm a parent, daddy. One of my kids has some problem or gets accused of something, or one of my friends' kids, I'm going to put my lawyer hat on and advise them to be
As
quiet
a
until
lawyer,
their parents get there.
do you
and
think he killed him?
get counsel if I think it's a serious matter.
Sure. You were asked about Alec's cell phone use and about whether he would take the phone down to the kennel. Have you ever been down to the kennels with Alec?
Yeah,
You asked about that and you never
Have
followed
you
up.
been
on it.
riding the property with Moselle with Alex?
I have, not a whole lot. I mean, as time went on, our families got older, and you just, when you don't have children, you're doing a lot more things together on the weekends and stuff, and as your children get older and they're in college, and he was going to Walford and different places where Buster was, and,
Great.
your interests are different as well. But yeah, I would occasionally, or if he was building something, he might ask me what I thought about it or show me something. I mean, I saw his duck pond and, rode around the property several times.
Was cell phone coverage spotty down at the shed in the kennels?
It can be, it varies. I mean, It can be. I don't remember specifically where and what. You know, out where I live, if I go in my house with a metal roof, this morning somebody was trying to talk to me and I had to walk out on the porch. Other days I can talk just fine in my house. I live 8 miles, 9 miles from where this place is, and I don't know whether it's a metal roof or whether I'm just at the end of wherever a cell tower is, but out in my area, which is Rum Gully, it can be spotty.
And you mentioned about spending time at Moselle and when the kids were younger, before Alec got Moselle,
Yep.
you had a farm.
I do.
And would Alec bring the boys over to hunt on your property?
Mostly Paul.
Mostly Paul?
Yeah, I mean, Buster would come some, but Buster was older, and then obviously when Buster started college, he wasn't around as much, but Paul.
Brief stint in
was
college.
Very avid hunter and was over at either my place or Ronnie's place a lot.
And he and Alec were together a lot doing that?
Paul?
Or he and Alec, he and Paul, Alec and Paul together a lot?
Yeah, yeah.
And,
And Paul was with his grandfather a lot.
And I think you mentioned that Paul would leave stuff over there?
All three of them, but, you know, they would just, they'd leave a gun, they'd leave a coat, they'd leave a flashlight, maybe all three. And it was just sort of a running joke that you had to kind of go around and gather up their stuff after they left. And that was just them.
And did you remember one time Paul left a gun over there for a couple of months?
He did, and Alec left one time, I believe, and I cleaned it and put it up, and he started asking around where his gun was, and, you know, we just sort of played with him a little bit and then gave it back to him.
Right. I think you testified moving September the 4th.
You're not doing this
You had,
one well, Jim.
Gotten
Whenever I talk, that's what happens. That's weird. It's really, really weird.
word about a shooting involving Alec, and I think your words were that jackass had killed himself.
That was what I thought immediately.
And why did you think that?
Because of all that had gone on. We had terminated him, or he had resigned the day before. This financial stuff was starting to come out. And, you know, I thought, you know, he'd lost 2 family members, and now he's got no job. And, you know, it seemed feasible. I mean, I had been concerned about him, his mental health, from the time of the murders up until then. In fact, I had suggested that he go see somebody for grief counseling, I mean, we were all grieving their loss, and you know, it's one of those deals that you can tell when somebody's not hitting on all cylinders, and he obviously was. I would come by his office and he would be crying. I mean, or I would ask him something. I remember him asking me one time when he was going through he had a stack of sympathy cards, and he said, should I send them all back a note? And I said, Alec, people don't send you sympathy cards to, you know, get a note back from you. There's no way in the world you can do that. And he said he missed
he was terminated from the firm, and you were concerned about perhaps what he might do, did you ever think maybe he'll go kill a family member?
Finally, we get to this question.
Across your mind?
No, you talking about when we terminated him?
Yes, sir.
By then, Maggie and Paul had been killed.
Oh, he was out of family
Well, he had
members.
family out there.
He did. I never
Family members.
thought of any of that.
Buster's like, did you, Dad? Did you?
When September the 2nd hit, it changed everything that I knew about Alec. I would have never believed that a guy that, you know,
So right now, do you think he
was
killed
like
him?
family, would have ever stolen from me, would have stolen from his family, would have stolen from his clients, or any of that. And so immediately, you've got this rage this emotion that you've got. And then on the third, we go through this whole ordeal of determination, and then the fourth it hits, and you're like, you know, did the jackass kill himself because of anything else? And then as time progressed on and you see the scope of it, I mean, I don't know the guy that after September the 3rd and leading out, I don't know who that guy is.
Oh my God.
I mean, that's not Alec that I knew.
Right.
And Alec that I
Why
loved,
did the
and
defense
Alec
put
that
this guy up here?
all of us loved.
I don't know.
You know, did he have imperfections? You bet. Did he do things that aggravated the hell out of me? You bet. But you don't kick your brother out the door because, you know, they snore at night or you know,
Why are
they've
you
done
sleeping
things
with your
that
brother?
aggravate you. You get past it. But when they do things that are criminal and they do things that affect not only him, but he's torn down an entire legacy, a law firm. I've spent 34 years, or 33 years, I guess, in this one place. It's the only law firm that I've ever worked at. I put everything in it. It's all my children have known, my family's known, and it's gone. We had to change the name. We've had to do all these things because of his acts on this financial stuff. And when it comes to that,
What
I'm
about
mad as
killing
hell.
people?
I mean, you just don't know how mad I am. But on the other hand,
He should know that
I'm not saying
he should confidently
that
know
because he
that
did
he's going to
that-
say he did not kill him.
he's done what he's accused of. And so
Do
that's...
you think he did? And they should
you
know that he's
that's-
going to say
that's
absolutely
sort of the
not.
bottom line of it. His actions that, I mean, he was doing that way back, but we never knew it.
Sure.
And when we found out about it, it makes you doubt everything, and it's just human nature. But I don't have one shred of anything. All I can do is just point to what I saw.
And you pointed to the roadside shooting and what you saw, you thought that jackass tried to kill himself.
Absolutely, and I may not have said jackass, but it's
Probably
about
much harsher than that.
And
non-church
logically,
as I want
to
to get
you, it made sense why he would want to kill himself in that moment.
Sure. I mean, he lost, as far as I was concerned, he'd lost everything. He'd lost his job, and he'd lost, forget the job, forget the money,
His
forget
legacy,
what's going to
his
happen
family,
to him.
everything.
He lost his wife and his child.
Mm-hmm.
And
Are you aware that he had $12 million of life insurance?
I didn't know what he had. I assumed he had some life insurance, but no, I mean, I never had that conversation with him, and quite frankly, I'd have to see it to really believe it.
Thank you, that's all the question.
That was terrible. That was terrible. I don't understand what's happening here. I do focus on legal strategy more than law. Because what am I? I'll explain to you the law so you understand the law.
Now about this man.
But the function I'm giving you is giving you healthy legal strategy as to what a lawyer should be doing in a trial.
Question everything you thought you knew about him. Isn't that right?
It does.
You were asked about all those clients that had to be repaid money, and none of that money came from him, did it?
No, sir.
Y'all had to pay that money, right?
We did.
How much?
I would say, at this point, probably north of $10 or $11 million. Now, insurance
Now-
paid for some of that, but, I mean, there's been a substantial chunk of that.
So you had a motive to
came out of
kill,
our
didn't
pocket.
you?
You were asked about Alec having some cases that were coming in, but you explained, though, that this is June, and that disbursement's not going to come to him until December. He's not going to be able to get that money until December, correct? Any of what he's entitled to, which isn't all of it, correct? Because it belongs to the firm.
Right, everything belongs to the firm until the end of the year when you meet, and then you divide up money and
And that's
We
why
have
he
a
stole the
formulation.
Ferris fees in March, because he needed the money right then.
I would assume so. I mean, the money was gone, and it was paid in 3 checks.
You said that in the month after the murders, he wasn't really working on cases, but he sure managed to arrange to cover those Ferris fees to pay him back so that everyone would forget about it, didn't he? Or not all of it. He managed to do that, didn't he?
Yeah, well, part of it. I mean, I think there was $192,000 that didn't.
That he can.
Not me. My hand's down here, but I'm in a different window. I was responding to chat in Rumble of all places.
Convince Chris Wilson to cover for him.
Convinced, or Chris had to cover it, one of the two.
You were asked about him cooperating with law enforcement in the murders. But he never told law enforcement that he was down at the kennels just minutes with the victims before they died. He never told law enforcement that, did he?
Please mute myself when I type. Fine, corn pop. My question is, why put this guy on the stand in the first place? If you don't know
I'm not getting anything out of it. He's just got two prosecutors going at him, it sounds like.
I don't know what he told law enforcement other than what's been out there in the public.
Well, let me ask you this. He denied to you 3 times that he ever went to those kennels, did he not?
He did.
His buddy, his friend, and his law partner, 34 years, told you 3 times, I was never there.
That's correct.
And you know now that's a lie.
When I saw the video a month or so ago.
Thank you, Mr. Barr.
Wow.
I mean, I could sit here explaining to you how that's still not proof beyond a reasonable doubt. That's still not proof beyond a reasonable doubt. I can do that. That's what, and Andrew does
Call your
that
next witness.
But
very,
he denied
very
it
effectively.
3 times, just like Peter denied Jesus 3 times. That's a little
very
Christian joke there.
effectively. I think that most of you who know anything about American law know he has to be proven guilty beyond a reasonable doubt. What I can offer you that you probably don't know if you're not a practicing attorney is perspective on strategy for how to handle a trial and what's effective counseling and what's not. And my point is, they should have known before they put him on the stand that if they ask him the question, do you think, sitting here today, do you think he killed them? Be positive that he's going to say no. There's no way he
yes,
could have
I
done
think
it.
you did it. You don't put him on the stand. I
Yes.
don't know. You don't put him on the stand.
Unless you're getting like really vital information out of him that you have to put him up there, why would you do it?
You'll state your name and spell your last name.
It's Morris Dawes Cook Jr., and Cook is C-O-O-K-E.
Okay.
Will you please tell the jury a little bit about yourself?
I'm a lawyer, practice in Charleston, South Carolina with firm Barnwell, Whaley, Patterson, and Helms. I've been doing it since graduated from law school in 1979, clerked for a judge for a year, and I've been with the same law firm since 1980.
I drink my breakfast.
Mainly civil litigation.
And do you primarily represent plaintiffs or defendants?
I don't mind representing plaintiffs, but most of the time I'm representing defendants.
All right. And do you know Alex Murdaugh?
I do.
How do you know him?
He's a defendant.
Through practice of law. I've had cases against him over the years.
Okay. And have you represented him before?
No. Well, I mean, now I do, but I did not previously
Right.
to this, right?
Right. What was the scope of your representation?
Hey, we get the
defending
super
him in
hot
the
lawyer
boat accident
today. Cool.
case.
Okay. And when were you asked to join his team?
In December of 2020, I got a call from Danny Henderson and asked me if I would become involved. The case had already been going on for a year and a half or so at that time.
Okay. And did he have other attorneys representing him at that time?
Yes, yeah, the Hainsworth firm, John Tiller in particular, was representing him.
Okay. And what, if any, understanding do you have as to why you were asked to join the defense team?
Well, John was sick, as I think everybody knows now, and would be undergoing treatment from time to time, and he was unsure as to whether he'd be able to cover everything by himself. And so I was asked, one, to help him, sort of be a second chair for him, and also be a backup for times when he would not be able to participate.
Okay. And would you please describe for the jury your assessment of the merits of the claim against Alex in June of 2021?
Well, I think I was the one that coined the phrase negligent parenting that Mark mentioned during his testimony. The claim at that time was that Alec was responsible for the boat accident because he knew that Paul was using his brother's ID. And I didn't think that there was a claim in South Carolina law for that, so I sort of facetiously called it negligent parenting. So we felt that it was a defensible claim. I always sort of felt that lurking out there was going to be what's now negligent entrustment, that eventually they would allege negligence for having let him use the boat, which is the substance of the claim now. But even that, we always felt like it was a defensible claim. That I think the big picture that occurred to me was to hold him liable for that would be to hold him to a higher standard than any of the other parents of the other folks that were in the boat, which
Okay.
anybody who's raised kids knows that that can be difficult.
Okay. And what was your assessment as to Alex's financial exposure as a result of this case?
It's not my sirens.
Well, it was unknown, and I'll have to say
Can you
that
mute
was-
your sirens?
I didn't even really pay attention to that issue at the time. I think there was
suburban
still
town.
a
There's no
declaratory
sirens here.
judgment action pending that was going to decide whether there was some additional insurance. I knew that the one policy was relatively limited. So I wouldn't have said that he had no personal exposure, but that was certainly not the focus of our attention at that time.
Right. And were there motions pending when you joined the case?
Yes, several motions pending. For some time, there had been a motion by Parkers to change venue. They wanted it out of Hampton and into Beaufort County. And there was also, they had made a motion to amend their answer to plead admiralty law, which would have some benefits over South Carolina law for the defense. And then there was this, there may have been some motions to compel discovery with Parkers. I don't really remember specifically. And I think in October of 2020, there had been a motion to compel the answers to interrogatories and request to produce to Alec.
And have you reviewed that motion to compel?
Yes.
Okay. I'm gonna, I'll note on. Yeah, it's, plaintiff's exhibit, not plaintiff, I'm sorry, State's Exhibit 402.
Hey.
All right, can you
He's
see
my
that?
people.
Yes.
Okay, great.
Yeah, your moment to shine.
And do you, this is just the first page, but do you recognize this as the motion?
That's the motion. And then I
Okay.
think attached to that were 2 sets of interrogatories and a set of requests to produce.
All right, so I'm gonna, these are the interrogatories. Would you just briefly explain to the jury what interrogatories and requests for production are?
Right, well, we call it discovery. The rules of civil procedure provide various means of obtaining information from the other side. So interrogatories is questions that you can ask, and then requests to produce are documents and other materials that you can require be provided.
And the supplemental ones that we're looking at right here, were those seeking financial information, Mr. Murdaugh?
Yes.
Okay. And the objections, if you'll, well, the answers right here to the interrogatories, and then the objection right here. Have you reviewed those?
Yes.
Okay. In your practice, are those common objections?
Right, that's, this was done before I was involved in the case, but those are the exact objections that I would have made. These financial discovery, it's sort of the plaintiff's lawyer's way of saying I'm really serious, and I'll call it intimidation, not in a pejorative way, but it's meant to really worry the defendants, and it's very common. And the typical response from the defendant would be just like this, and that is, We object, it's not relevant, you haven't gotten a judgment against us, you don't need to know how much money we have unless and until you do get a judgment. The comeback to that is, well, your net worth could be relevant on punitive damages. If it goes to the jury, a jury could consider your wealth as a factor in awarding punitive damages. And so 95% of the time, you work out some agreement to provide a financial statement, but I would never have produced all of these details at this stage of litigation as a defense lawyer.
After joining the defense team, did you have meetings or communications with other members of the defense team?
Yes, regularly. And I have to admit, there's a lot I didn't remember, so I've gone back and I've looked at my emails, my time records. And we defense lawyers, we measure our lives in tenth of an hour increments, and we have to write everything down. So it was helpful for me to go back and
So did maritime lawyers.
time records as well as emails to see who all was included. But yes.
Okay, and was Alex often CC'd on the emails?
Oh, yeah.
Okay. All right, did you ever participate in any Zoom meetings with the defense team?
Yes. The one there's more than one. The first one I remember was April 15 of 2021. I was just sort of getting involved. I don't think I'd made a formal appearance in the case yet, but there was a Zoom conference. And I remember Alec was included on the Zoom invitation, but I honestly can't recall whether he was in the meeting itself. I remember others who were in the meeting.
Okay, and what was the purpose of that Zoom?
It was really to kind of orient me, and also there were some motions scheduled in May.
What is the purpose of
so
this
it was
testimony?
just To get me
I think
oriented.
the agenda here
talk
is to make
about
us
what
feel
the
that
important issues in the
wasn't
case
under
were and
pressure in the
things that
boat
we'd be
case.
focusing on.
This is no motive
And
as they're
having
claiming.
attended that meeting,
Okay.
what, if any, understanding did you have as to the biggest issues facing Alex at the upcoming motions hearing?
Right, and I had to go back and look at my notes to refresh my memory on that, but it was the outcome, as far as I was concerned, it was the venue issue, whether the case was going to be transferred back to Beaufort, because we didn't want it transferred back. We wanted it to stay in Hampton. We thought that the plaintiff wanted it to stay there too, but he was wavering, and there was some thought that he might consent, and we didn't want him to consent. So that was a big issue. And then we spent a lot of time talking about admiralty. You know, was it beneficial to have admiralty as opposed to state common law? So that was, as far as the hearing, that was the important part of the conversation. That was about a 2-hour meeting, and we talked a lot about experts, depositions that needed to be taken, and so forth as well.
And after that meeting, based on those conversations, what, if any, understanding did you have as to the level of concern the defense team had regarding the motion to compel the financial information?
Really none. I wasn't dealing with Mark directly on that. John Tiller was doing it, and as far as we were concerned, that was something that they were going to work out, but the focus on the hearings was going to be on these other substantive issues.
Did you ever have a concern that the motion to compel would be granted in total?
What's the question?
If he personally had expected the motion to compel to be granted?
Also 401 and 402.
I sustain the objection.
No, the point is to reflect back as to what his counsel thought about
when
whether
was
he
the
had
motion
reasons-
to compel
Why-
originally scheduled to be heard?
That was
whole
stupid.
The whole
It was
point
in
is to
May,
get into his mind,
I'm going to
which
say
you understand based on what
May
his
10th,
lawyers are
sometime
thinking.
in that area.
And did that go forward?
As to like,
No,
is
I
he
think
freaked
John,
out about this lawsuit
some of
on
his
June
treatment had to
7th?
be rescheduled, and so they agreed to continue the hearing.
And when was it rescheduled for?
June.
I can't explain either. I don't
I
understand
don't recall the
vices.
exact date, but maybe the 10th or so.
Okay. And at any point prior to the motion to compel hearing that was scheduled, did anything change in terms of your understanding that would make you think the defense team was concerned about the motion to compel?
No, I filed my formal notice of appearance so that I could be at the hearing. I think I actually did that in May before the first hearing. And so I was prepared to be there to argue whatever needed to be argued, but as I go back and I look at my notes and my preparation, it was on the venue issue and the...
Honestly, law and crime. Every time this happens, people lose faith in my ability to pay my internet bill.
Well, I guess I can answer the question. Admiralty law, maritime law, same thing. It's a body of law that deals with
Admiralty issue.
navigation on waterways, nautical issues,
what-
maritime issues,
Oceans.
ship collisions,
Ocean
things like
stuff.
that. Yeah.
Because you have to realize an ocean is not in a
Any
state.
factors did you consider?
Well, even a lake, or a river, they're navigable waterways.
All right.
made an
Which is why
assessment
sovereign
about
citizens
Alex's
think it applies to them,
personal
because a
financial
boat-
exposure?
Fine,
You know,
you're
is-
smart.
A car is just a ship
I
on
never
the
take
land.
the case
Very,
lightly.
very
I mean, Mark certainly is
Your mother and I
a
are very proud.
very good lawyer, and obviously a very emotional case. So I won't say that we weren't concerned about it, but we knew that there had already been some other settlements.
This has been a frustrating morning with the circle of death here. Not gonna kid you. Anyway, so yeah, the purpose of this witness is to let us know that there's no reason for the state to be making any sort
Which
of
we would have gotten credit for that.
claim that there was a unique pressure.
There were just
that
a
was
number of
developing
factors
at
that
this
made us
juncture on
feel
June
like
7th.
this was a defensible case and that it was not an existential threat to Alex.
Okay.
Thank you, Stephen Cooper. It's a snow and cold, man. Also good seeing you twos.
Are
That's
you
the circle of
aware
death, I guess.
as to whether or not
Welcome
an order
back,
was
8-month
eventually
follower.
issued regarding the motion to compel?
He's actually a disciple.
Yes, what we call a
Not just a
Form
follower,
4
he's a
order was
disciple.
issued around
That's a higher
October
level.
7th or 8th of 2021.
Okay.
Disciple.
What is your understanding of that order?
I've got it right here. I mean, it said that John Tiller had not been able to get the information and that, well, it says right here, the court at a hearing on plaintiff's motion to compel filed October 16, 2020, was informed that defendant's attorney Tiller, because of circumstances beyond his control, is unable to gather and provide the necessary information to answer the requested interrogatories at this time. Once this information is made available to attorney Tiller, the court will schedule a hearing on this motion to compel if necessary, which means that John Tiller was going to get the information, and then if he couldn't work it out with Mark, then they would have a hearing on the motion to compel.
So was it your understanding the court was ordering Alex to produce all of the financial information
No,
requested?
no, that's not what it said.
Me.
His mom says Tins is looking real defeated by this guy. He actually looks like he knows what he's doing. I know when we saw him get up there, we thought that he was going to start with marriage. Marriage is what brings us here today. Wav. True, Wav. Rose, RNC. Welcome to Following.
The witness isn't dead. He's just mostly
One or
dead.
two more. Did you expect any cataclysmic event on June 10th regarding
Jeez.
Alex having to give over
Oh my God. You're killing me.
How you doing, Sean? How you doing, Steve?
Sean, Steve. Everybody loves Steve.
Hey, Steve. Got something.
financial documents?
No.
Okay. And
Wow. So.
You're
all
muted,
Earnings
Steve.
today, right? So far,
What was that?
Lunch.
I know there was an attorney
do
earlier.
you recognize Mr.
Are these his
Kinsey? Do you know
partners?
him?
Yeah.
Okay.
Rumble wants Steve to tell me to talk to them.
Yep.
Should I try something else?
Do you see
think?
him here?
Yes.
Different stream? Because I'm getting tired of long crime.
Mr. Kinsey, can you
I'm
see
going
him
to see if
up?
I can find a better stream.
Okay. Did you ever speak with him during the case?
Yes.
You did?
A number of
Okay.
times, yeah.
At all about the motion to compel?
No, not that I remember. If he says I did, I couldn't deny it, but I don't remember it.
Okay, all right. Thank you.
Thank you.
By the state.
Like you said, the motion is meant to really worry the defendants, right?
He
That was
comes
your
out
exact words,
swinging.
wasn't it?
Could you repeat that?
You just testified that the motion to get those financial information is meant to really worry the defendants. Those are
Right.
your exact words, correct?
Guy's so arrogant.
Always, yeah.
Okay. All right, and were you present at the trial lawyers conference when Alec Murdaugh came up and towered over Mark Tinsley and said, "What's up, Bo? What are you doing?"
No,
Were
I
you
don't
present
get,
at that?
I don't
Were
get
you?
invited to that
How
one.
do you know he did that?
You did. But you weren't there when that happened, were you?
No.
You were present for when he said that to that man right there about the boat case. "What you doing, Bo? What's up?"
I was not there.
Basis for the objection.
Foundation.
The objection is overruled.
And you did not.
Said he wasn't here.
Okay, thank you, Your Honor. All right. And you didn't file your notice of appearance into this case until May of 2021, is that right?
I think that's about right, yeah.
Because you were actually representing other parties, and that had to be resolved before you could get involved with that.
Oh,
Is that correct?
That's part of the reason our firm was, yeah.
Right, so you couldn't have been, with the conflict, heavily involved in any discussions that were going on between Mark Tinsley and John Tiller and Amy Bauer prior to moving into May, is that right?
That wasn't exactly the reason. The conflict had been waived, but I just wasn't involved in that. That was something John and Mark were handling.
Right, and when John, in May of 2021, asked for continuance of that hearing on which the motion to compel the financial information was part of, he didn't offer you as any sort of backup because you weren't fully on the defense team at that point, is that correct?
I think I had planned to notice my appearance before that hearing, and I can't recall whether I didn't do it because the case was continued, but I would have appeared at the hearing.
You were asked about insurance coverage, and you're talking about the Philadelphia policy, right? That there was a declaratory judgment?
Right.
Right. And the defense team knew that they weren't going to have any obligation to cover Alec in this, correct? I mean, it was very unlikely. And in fact, it ultimately, Judge Sherry Lydon in the federal district court denied that Philadelphia had to cover Alec one penny, correct?
Yeah, I'll have to say, I wasn't following that, but that's pretty much my understanding. It was a long shot that there would be coverage.
And when you were at this point in time in June of 2021, just getting on the defense team, you certainly didn't know anything about his true financial condition, did you?
No,
You didn't know he'd been stealing money for years and years, did you?
no,
You didn't know that he was broke, did you?
no,
You didn't know he had misappropriated funds and was scrambling to try to replace those before people found out, did you?
no.
No.
You were asked about the hearing on June 10th that ultimately was continued because of these terrible murders, correct?
Correct.
That's your understanding. The
That was
murders
my-
happened, and that hearing got continued, because, of course, who's going to have a hearing in the wake of these terrible events, correct?
Yeah, I think Mark agreed to continue the hearing. Right.
Yeah. That got continued, right?
Right.
And even as a civil defense attorney, even if you believe that a claim down the line may be defensible, that still doesn't change the discovery process in a civil case that goes on, correct?
That's not true.
That's true.
I mean, discovery still
just said
can
it was
happen and is
negotiated.
going to happen,
Right.
regardless of whether or not the case settles or goes to trial or whatever happens, correct?
Yeah, it's still going on.
And that's how civil cases, typically how cases work in court, is that both parties have to share a lot of information, and if one party doesn't want to share it, the other party can ask the judge to order it, correct?
That's right.
All right, and that goes on regardless of whether or not the claim is ultimately going to be successful. That's part of the initial process.
What the hell does this have to do with anything?
That was on the table for June 10th.
He wanted sympathy,
That was one of the
apparently.
things that was on the
So
table.
he killed
correct?
2 of his family members for
The
sympathy.
financial, yeah. And then
He
there
wanted
was a-
sympathy,
Golden
though, so we need a
There
lecture
was a
on
number of
discovery?
options as well.
Right.
And
it's the
if
stupidest
that hearing had gone
argument in the world.
forward, there could have been an order issued compelling that process, correct?
Could have been.
Could have been.
Yeah.
Calls for speculation.
And so once that happened, once that order gets issued, that's going to set in motion a train that's going to have to come to a conclusion in a court of law, correct?
If that happened, right. Ultimately, the judge is going to decide what has to be produced and what doesn't.
That's right. Thank you, Mr. Cook.
Thanks.
Mr. Cuck. Dang, she's tall.
She didn't kill Paul or Maggie.
Yeah, she's not 11. Did they ever find the 11-year-old?
That's true.
Oh, hey Jeff, can you cover the boat wreck Paul did on Maritime Monday? One episode.
He got liquored up and slammed it into a
Mr.
pole.
Waters
The end.
is asking for your
You can make
opinion
that good.
as to the June 10th
Do it like
hearing.
NPR.
Based
This
on
like
40 years of
some jazz
experience
in the background.
One second.
Defending
I did not
cases.
ask for her for the opinion. I just asked what potentially could happen.
Didn't hear the question.
Based on your 40 years of experience, what was your opinion of the likelihood that the order to compel would be granted?
Objection, Your Honor.
Did
They
you
just spent all the
have
time talking about the
Let me ask
case.
you this. Just because it's possible that the order could have been granted, does that make it plausible?
Objection, Your Honor.
Sustained.
She's struggling. You have to get to mindset.
Your Honor, I'm trying here.
Get to his mindset.
Did you want it to be granted? Help.
It's basically anybody who has any civil background at all knows is the state's theory that he did this to get a continuance in a civil trial absurd? The answer,
Order the
yes.
documents to be.
I don't know. People have done a lot of things to get a
produced at the
continuance.
hearing. Would Alec have had to turn them over immediately?
No.
That's all I have. Thank you.
Anything further?
If that had happened, it would have set in a process, set in motion a process, though, would it not have?
A process.
You know,
Let me
if-
rephrase that question.
If he'd ordered production of all of the documents that were requested,
Right.
yeah. That would have been part of the process, right?
It would have started a process, an order of a judge, correct?
That's true, yeah.
It would have happened eventually if the judge had ordered that, correct?
One day,
If
maybe.
he ordered production
If-
of all the documents, right.
Nothing further, thank you.
Step down.
This guy's got a pretty like strong name, Morris Dawes Cook. That's a lawyer name
Next
right there.
witness.
All right.
Please, the court, Your Honor, the next witness is an expert. It's going to take a while. We can begin and break for lunch, and then I'm do whatever you want.
Ooh, an early lunch for
We'll
these
go for
guys.
about a half an hour, then break. As we anticipate him, however, let's all stand and stretch for a moment.
Cave Johnson, what's an alternate Jew roar? Exactly what it says. I'm an alternate Jew roar. Just listen to the judge.
Well, has he made any cringeworthy decisions this morning?
No,
whole
but
thing has
this
been
has been a very painful morning for the defense.
I don't think that last witness was, I mean, the one before this one was very good for this defense. I mean, I don't know. I really I question whether it was the best use of defense time. The issue that they wanted to get out with that witness is how bad SLED was at this crime scene, how sloppy they were. But I don't know if that benefit was worth what they got out of him from the state. You know, I don't. What was your opinion of that?
I thought it was a cluster fart.
I wouldn't go that far. I mean, it did show that SLED is just was sloppy as hell, right? But we kind of already knew that. I think, I don't know. I mean, I'm not sure. I'm just,
There was
I
so
wasn't
much-
really, it didn't blow, that guy did not blow me away
There
as
was
being
so
a
much
great
there
defense witness.
There was so much ugliness about his thieving, and he couldn't even get the guy to try and fix it in the end by coming up there and saying, with everything I know about everything that happened, with my whole lawyer perspective and everything I know about Alex, I cannot possibly believe that he killed his wife and son. And that, if you don't, my perspective is, you know, you can sit here, and I argued with, back on. You can argue the law, you can argue beyond reasonable doubt and all that stuff, and you're all correct about that. You're all correct about that. Every one of you who says that is 100% correct. The purpose of putting on a case, though, you could have also sat down. You could have presented no defense. You have to ask when you're putting a witness up there, what is the upside versus downside?
Today will be the truth, the whole truth, and nothing but the truth. So help you God.
I want to talk more about the motion to compel.
We will.
Stand.
Motion compel or Fifth Amendment rights of self-incrimination.
Fifth Amendment right. That's,
We're going to talk about that by lunch.
Speak into it, Lynn.
All right, we're gonna have a lengthy talk about the Fifth Amendment.
And if you would please state your name and spell your last name for us, please.
Yes, ma'am.
And welcome
If
aboard,
the judge restricts
Last name
the
Zercy, Z like zebra, E-R-C-I-E.
judge restricts Alex Murdaugh cross-exam, I'll be amazed.
E-R-C-I-E, Kenneth Zercy.
Xerxes.
Xerxes. Hey, this is Sparta.
You think he's a lawyer also? Think he's a lawyer?
Mr. Zercy,
I don't think that he's an expert of some
please
sort.
tell the jury a little bit about yourself. Where do you live?
My name's
Madison,
Bob.
Connecticut.
Okay. And what do you do in Madison, Connecticut?
Currently live with my wife and my
Bob
son lives up
Turtleneck.
the street from us.
Tell us something relevant.
Currently employed by the Henry Seeley Institute of Forensic Science at the University of New Haven as the director of training. In addition to that, I'm also on staff at the
I'm
university.
sorry, I can't hear you very well. Maybe it's just me, but
I'm also on staff at the university as an adjunct professor in various forensic science disciplines.
okay, let's talk a little bit about your background. You've been involved in law enforcement in your life?
Yes, sir, I have.
Tell the jury, please, where you began.
In 1974, I became an officer with the New Haven Police Department, also in Connecticut. Was promoted to the rank of detective. Most of my career there, for my 11-year duration,
Detective
prior to retirement,
Eeyore.
was with the Identifications Unit, responsible for crime scene processing, evidence collection, photography, and preliminary examination of physical evidence that's found at a crime scene. After that, I retired based on a disability. I was injured and was almost immediately hired by the state of Connecticut at the Forensic Science Laboratory located in Meriden.
I'm sorry, and tell me what that was again? What was that position?
They're getting taller.
The second
penguins are getting
career,
taller.
if you will, was at
His
the
shoulders are
Department of Public
climbing up the
Safety,
back of his neck.
currently called the Division
His jacket.
of Scientific Services Forensic Science Laboratory. Originally brought in as a latent fingerprint analyst, also doing footwear and tire tracking examination, as well as becoming the senior person as far as crime scene-related activity that the laboratory would respond to assist investigative agencies. Over a 29-year career, I was promoted through the ranks and eventually retired as director of the laboratory.
And that's director of the Division of Scientific Services for the state of Connecticut.
Yes, sir.
And in your duties there, you indicated you started off not as a supervisor or as a supervisor?
Not as a supervisor, as a criminalist, right, with a specific function.
And a criminalist doing what kind of forensic work?
Starting primarily with fingerprints, latent fingerprint identification, and all the processing techniques involved. Because I had also experience doing footwear and tire track from the police department, I was given that task. And again, because of the crime scene background, also ended
gonna
up
speed him up to
as
one
one
and
of
a
the
quarter.
senior people going to the major crime scenes when the laboratory services would be requested.
that works if it's
And
live.
eventually ended up supervising the photography section because of
I
that type
felt
of
like
background as
2
well.
minutes behind.
So photography is important in processing a crime scene?
Absolutely.
And while he's giving his
Is that
background,
just
what he's
for,
saying now is less
fingerprints
important.
or footprints or tire tracks or
He's going to be
everything?
talking about
It
background
involves
all
the
way to
entire scene.
lunch.
It's the only way to bring the
Probably.
crime scene before a jury after the incident has occurred. And so it can be reviewed.
We're
or
going to
seen
talk
in
about
time.
this a little bit later once I do qualified in these different areas. But after, and how long were you at the Division of Scientific Services?
For 29 years.
Right, now also, and you ultimately became the supervisor of that department for the state of Connecticut.
The director of the laboratory.
Okay, so you were there from July of '84 to October of 2012.
Yes, sir.
And what did you do after 2012?
I've been an adjunct professor at 4 different universities, off and on during that period, as well as approximately 20 to 25 years prior to retiring. I maintain that. I also had a private consulting business that I've kind of let go by the wayside a little bit.
So what's the Henry C. Lee Institute of Forensic Science?
It's located at the University of New Haven. It's a separate entity under the university, and we're involved in doing scholarships, training, and education.
I'm a huge Henry Lee fan.
Providing consultant work in cases, whether it's for the defense or the prosecution. But
Henry
more to
Lighthorse
stay
Lee?
involved with the community and provide modern technologies.
Okay, and then you're the owner and principal analyst
Virginia?
for
Good
Forensic
reference,
Consultants
Joe.
New England LLC. What is that?
Again, that was the private business that I had on the side for doing consulting work.
Are you still doing that?
Technically, this case falls under that today.
Okay. Now, what's your educational background?
As far as criminal justice and forensic science, I have an associate's degree in criminal justice administration, a bachelor of science in what was called police science, basically a hybrid between administration and the forensic applications or sciences, and a master's of science in forensic science.
That's all from the University of New Haven.
Yes, sir.
Okay. Now, you have a resume with several pages of different teaching things you've done. I'm not going to go into those in detail. Now, you have taught a number of courses, is that right?
Yes, sir.
Everything from footprints to bloodstains to tire tracks to
We're almost
crime
caught up.
scene
We're like a minute
supervision
behind, so.
to
This is the perfect time to go 1 1/4
it just
speed.
goes on and on and on and on.
Where he's just
Have
giving
you ever been
background or it's
qualified
qualified as an expert.
by any court to testify about fingerprint identification, but that is in a federal or state court in this country?
Yes, sir, I have.
And how many times?
Approximately 300.
300 times. And can you remember all the courts or several of the courts?
I can remember the states that they were in, but the specific ones, probably not.
Connecticut, I suppose.
Connecticut, Rhode Island, New York, Massachusetts, Florida.
That's enough. Okay, and how many times have you been qualified on footprints, or the more technical would be, what would you call that?
Footwear tire track examination or imprint analysis.
Imprint analysis. How many
Probably about
times?
200.
300 times you've been qualified by a state or federal court to be an expert on that topic.
About 200 as far as footwear and tire track.
Okay. Now, what about, maybe I'm getting this term wrong, crime scene management or crime scene analysis? You've taught courses on that, correct?
I've taught and been an active participant at crime scenes, yes.
Okay. How many times have you been qualified, if you have, by federal or state court to testify on that topic?
Qualified, probably 400.
400 times?
Yes, sir.
And you testified?
Yes, sir.
And this is both state and federal courts?
Yes, sir.
Your Honor, I would move to qualify him as an expert in fingerprint analysis, footprint analysis, tire print analysis.
Great
and,
reference. Jesus Christ.
crime
Great
scene,
reference.
Analysis, management. Sir, tell me what the term is. Make sure I'm not screwing this up. Crime scene.
It would be crime scene examination as an overarching title.
There you go. Crime scene. Very good said.
He said it, I didn't hear it. How many times have you been qualified in tire impressions?
Approximately 200.
For tire impressions? No.
Tire and footwear.
No question.
He's so qualified.
Thank you.
Thank you.
Now let's talk a little bit about, I have a PowerPoint here somewhere. I believe I sent you all.
Oh, goody, a PowerPoint.
Yeah. Can we call that up, please? You prepared a PowerPoint for your testimony here today? Sir, you have a PowerPoint?
Yes, sir.
Everything
Okay.
better.
Can we put that up on the screen, please?
You ready to voice any, sir?
I can, sir.
So, is this the PowerPoint?
Bend your neck a little
It's
bit
the
forward
first
into the
slide, yes.
Okay,
microphone.
and what is this showing us?
Basically, it was put together just to give a quick demonstration on what can be done with physical evidence at a crime scene and some of the base requirements that are involved.
Okay. This says recording of imprint, impression evidence, seizure of item, photography, lifting methods, and enhancement. And that's sort of a guide about what we're about to see, correct?
Yes, it's also an outline of what could be done with physical evidence at a crime scene and then later on at the laboratory.
Okay. Next slide, please. Now,
They're not going to show us anything, are they?
This is photographic evidence, enhanced photographs of the question imprint.
It's a very
impression
graphic
for use
footprints
in
that they're showing the jury. They don't want to
comparison
show it to
examination
our
with known footwear outsoles
our
or
chaste
transparencies
eyes.
of known footwear outsoles. Well, explain that. What does that mean?
With all types of evidence, especially at a crime scene, as I mentioned before, photography is one of the keys, documenting the evidence in place. In many cases, you can't take the evidence back to a laboratory, so you have to rely on the photographic images. If they're taken with quality equipment, quality cameras, and in a proper format, a lot of work can be done with them. They can be associated to a known and a question. Photography is still the key for bringing the scene either into the laboratory or into the courtroom.
And are there certain, and we're going to see this in just a minute, certain requirements, I guess is the right word to use, on how those photographs are taken, depending on what you want to use them for?
Correct. There are different types of photography, just as we have portrait photography here, the media that's present. All of that is a form of documentation.
Okay, we'll talk about that in just a minute. And by the way, inter-comparison examination with known footwear outsoles or transparencies of known footwear outsoles. What does that mean?
There's a difference between taking a picture of something and then taking a photograph for examination quality, where you do need the detail to find the individual characteristics that might be present for a comparison. And again, it would be a known, whatever the known object is, whether it's a shoe, a fingerprint, could be a tool mark, it could be any type of pattern, and the sample that's found at the scene, okay, or against the instrument that may have caused that mark. The more detailed the images, the better the quality of the examination, and the more reliable the showing of the detail and proportion. So the side-by-side comparison is your known and your question.
Okay, because most of these are basically eyeball examinations, either under a microscope or looking at it just with your naked eye, correct?
All of the above.
Right. Okay. Next, please. Photographic techniques, FUS. Tell us what that means.
It's just an acronym to help the photographer remember to do certain things, especially when it comes to analytical photographs. You want to take whatever the image on a picture or inside the viewfinder of the camera, such as the gentleman has, and fill that entire image that captures the picture. You're maximizing the amount of detail that can be retained either in a digital format or a film format. The opposite would be taking a medium close-up, where you show an overview, multiple items, or something as a wide-angle shot of the entire courtroom. So there's a whole series of photographs that go with this method. Secondly, using a scale. If it's going to be used for analysis, you want a known reference in there so that you can recreate the image later in a dark room or on a computer so that the image is now in life-size proportion. So again, if I have an article of footwear, I can place that or take a sample from it. That would be one-to-one or life-size. I can recreate the image, either taken from the crime scene or the stand or the photograph, using that scale to that same reference. I can also recreate that one-to-one so that I can get a size proportion right as part of the analysis. It would also be an elimination. If the sizes were different, it couldn't be from the same source. Side lighting is a lighting technique that's used. Right? When the photograph is taken, if it's an object of interest and if you're using it for analysis, you may want a side light coming in at different angles to show the different detail that might be there, especially in a three-dimensional picture. Two-dimensional, it helps, but it's not as critical. Right? And lastly, several shots. You want to take multiple exposures of each image. With digital photography today, it's a lot easier because the image pops up, so you can see that you've captured it. In past technologies, you had a photograph on film, and you couldn't see the result until you processed it.
He doesn't have to do cave paintings
long
anymore.
after you've left the scene or the incident. So there's several advantages to the newer technologies.
So this says special note, film plane must be level, parallel to the imprint impression.
Yes, sir.
What does that mean?
The film plane is actually the back of the camera. It's where the image is actually captured. That film plane, if my object is here, it would have to be here. I want those two images parallel. It avoids distortion and vignetting. Okay, the way the angles may come up. If you think of a tall building, right, and you look up at it, the building tends to come together. The same thing happens with angular photography. Okay, there's distortion that occurs, and even in close-up images, right, by using the scales and making sure that your film plane is parallel to the object that you're taking, right, you try to avoid that distortion as one of the considerations. And again, it would give you a more accurate rendering.
So when you take this photograph, you can compare it to a footprint, a fingerprint, a tire track. You want it, the photograph to be, the camera's lens to be parallel to that, so you're looking straight down at it.
Yes, sir.
That's one of the shots you should get, but that's the most important shot.
For analytical quality imaging, yes.
Right, you're not taking it to send on to mom, it's for analytical purposes, correct?
Yes, sir.
And then you have other shots from the side or whatever, and that helps you, if you see a detail, get more perspective on it, if you will.
It could, but it also shows the orientation to the surrounding area. And again, that 3-shot sequence, close-up, medium close-up, and then an overview. You're telling a story through pictures.
So let me stop and sort of go off script for a second. You started with what police department and when?
City of New Haven.
And what was your role or job when you started?
Initially as a patrolman, doing patrol activities. Spent a year in the Corporation Council doing civil investigation. Unfortunately, I got hurt.
Head script writer.
After that,
How did you get hurt?
on a burglar on the premise call, I fell through a drywall and ended up destroying my left knee.
Okay, and so you had to leave the police department after that?
No, well, it was about 9 years later.
Okay, so did you continue to be a patrolman after you hurt?
No,
your knee?
I was promoted and went into the identification unit after leaving the Corporation Council and was performing crime scene related activities, basic investigation.
So,
Again,
so when you first started, you were a detective at that point?
when I first started as a patrol officer, was promoted to detective.
Okay, and when you're doing crime, responding to murder scenes or house breakings or whatever?
Yes, sir.
You were a detective at that point? At some
Plainclothes
point?
officer or detective, yes.
So when you responded to the scene, did you take a camera?
Yes, sir, always.
Okay, and did you follow fuss?
Yes, sir.
And so, this was required by procedure and policy at your department, correct?
Yes, and also the teaching in the specialized schools that I'd been to
Okay. And you started that in the 80s?
in the 70s.
70s, I'm sorry. So this is what you've done while you were a
1870s.
police officer for a span of decades, correct?
Yes, sir. I
Starting in
also
the
taught it.
starting in the 70s.
Yes, sir.
So this isn't some newfound procedure. This is something you've done for
Those
4 decades.
things you newfangled kids are using.
Next, please.
It was newfound when I was young.
So this is use of a tripod.
I was there when it was invented.
Photographic
I was there,
evidence with detail.
Frodo.
A tripod must be used.
It's recommended. It makes it more stable. You don't have to worry about even the pulse in your fingers. And depending on the length of the exposure that's necessary, causing any vibration or defocusing that might occur.
And this is a process, a procedure, and this shows a guy shooting out in front, not straight down. That would be incorrect.
For a documentation or an analytical photograph, yes.
Okay.
What happens is
What
the
was it
camera's
like
at
when
an
they
angle.
invented fingerprint
He's
analysis?
doing a flat
How did
object
that-
here, and again, the distortion effects that I explained earlier.
Okay. And this is also a procedure you follow for decades.
Yes, sir.
And is it a procedure you taught when you taught police officers?
Yes, sir.
And is it a procedure you heard about when you attended classes?
Yes, sir.
Okay, next, please. And what does this depict?
Here we have 2 examples of the position of a camera, right? They're line drawings on a tripod, showing the proper orientation to an object being photographed, right? The film plane, even if the item is on an angle, the camera and the lens will also be on that same angle, right? Again, to avoid distortion.
So you ought to have a tripod, and the lens ought to be parallel to whatever it's shooting at.
It makes it easier to have the tripod, yes.
Right. Next. Is this demonstration the same thing?
It's a demonstration showing what happens when you don't do that. If you look at the object on the bottom, the black dots, you'll notice that they're distorted, right? They're not in proper proportion, and there's some angularity to them.
Okay, next. Okay, now, tell us what these photographs are of. Where do these come from?
These are images that I took at a homicide scene in the state of New York. Right. Essentially, we were asked to come and assist mutual aid, similar to the different agencies here helping one another. By going to New York, we had certain things that maybe their laboratory or their crime scene unit didn't have access to.
So tell me what the difference is.
Well, the 2 photographs show a kitchen area. On the right-hand side, you have what looks like a kitchen, right, a sink. And if you look directly down on the floor, there's kind of a reddish stain that you can barely see. By using various chemical processing methods, as well as photo documentation, right, the picture on the left, I was able to bring up a lot more footprints that were occult or latent. They were kind of invisible, just in very light blood residue. And the screening test that we use to try to develop those, right, reacts with the proteins that are in blood and causes a color change so that they're more visible, even if you couldn't see that area in the beginning.
So it's going to be a little
Similar
bit more
to a latent print
slow.
that's invisible when you touch the surface.
And what's a latent print?
It could be a footprint, it could be a fingerprint, but it's whatever residue is there that's left on a surface that you can't normally see without some type of enhancement.
Okay, and so you participated in putting the chemical on the floor here?
I put the chemical on the floor.
And what was it?
It was orthoethylidene.
Say that again?
Orthoethylidene.
Okay, and what year was this? Approximately.
Mid-'80s.
In the 80s. So this is not some newfound chemical. It's been
No,
around
sir.
for 40 years. Okay. And this is what y'all were doing in the 80s.
Yes, sir.
Okay. And so did you just spray it on the floor? How do you apply it to the floor?
It's sprayed with an aerosol, very similar to misting from a deodorant can or hairspray.
What were you doing in the
How long does
80s?
it take to raise these previously invisible
Raising
footprints?
hell.
Almost instantaneous.
And so once those are raised, what's the next step?
If we go to the next slide.
Next slide.
Basically setting up the tripod, the camera, right, to do photo documentation. The other option is literally to cut the sections out of the floor or counter or whatever the imprint or impressions are and take that with you.
Did you just take photographs or did you cut up the floor?
We relied on photographs in this case.
Okay. And this is a tripod we see, so you're shooting straight down on the image.
Yes, sir.
Okay, next. And what is that?
That's an example of what the footprint actually looked like after enhancement. Any of the bluish, greenish areas were not visible right in the beginning.
So wherever we see blue or green here, you couldn't see that on the print, on the floor, but once you did this, what had previously been invisible was now visible.
Correct.
Okay.
Photographs would have been taken before the spray and then after.
Next. And what is this?
Again, it's an example of a partial footprint or two. In this case, it's actually on plywood, and it appears to be in a blood-like substance. The scale is there just for size
Right,
and
the
measurement.
scale is important, right? Next. What is that?
This is after enhancement,
Okay,
after applying the same chemical.
Go back. Forward. So, again, you applied that same, what was the name of that chemical?
Ortho-otyladine.
We've heard some testimony about something called LCV. Is that the same thing or similar?
It's similar. It's a protein dye stain, and there's several others.
And would it raise, if you sprayed it like this and took, would it raise the
It
imprint?
could.
Would it do the same thing?
Quite possibly. Each one of the reagents has a sensitivity level. Some are more sensitive than others.
And you don't use LCV?
We've used LCV, we've used amido black, we've used phenolphthalein. Right?
Okay.
So there's any number of options, and a lot of it has to do with the color. You want to have something different than the background color so that you have contrast. And that's the other part about photography. You need contrast to see
Oh
something.
my God, I'm
So
falling
like
asleep.
LCV, I think, turns things
Purplish,
purple. So if you have dark background, you would not want to use LCV.
most probably, yes.
Okay. Next. Is that it? Okay. What time is it? Your Honor, it's 4 minutes till 1. This might be a good time to break.
All right, ladies and gentlemen, we will recess until 2:15. Please do not discuss the case.
Okay.
Cool. Hey, GoodLawgic abandoned ship.
Yeah, I noticed.
So it's who's going to take over? Who's the most senior here?
Me.
Okay, what's up, Civil? You go ahead.
No, I was really enthralled to learn about, once again in this trial, learn about whether or not the judge would have ordered the motion to compel with respect to the motion to quash in the subpoena, with respect to the discovery
We're in
dispute
recess
in
till
the boat
2:15.
case, because that really
Yes,
is
sir.
the thing
Really.
here.
Very quickly, I was
If the
going to hand up
judge would
those
have,
three cases I
the
mentioned this
judge
morning.
would have issued the motion to compel, it means he's a murderer.
Well,
Because we're doing it for a continuance, I guess.
Well, you know, I got you. And we're all
Murdering for
lawyers.
continuance is a whole new lawyer strategy.
We're all lawyers here. And what do you think? I mean, how much do you think the jury might be buying into the fact that this crazy motive here might actually be a motive? I mean, because we're lawyers and we know that that's a stupid thought. But what do you think about, like, to non-lawyers who may be sitting on that jury?
I don't know what this jury thinks about a lot of things. I think there is a fair probability that if they convict for the wrong reasons, which
Yeah.
is always a fear. You'd like to convict them because they really believe that he's a murderer beyond a reasonable doubt. But I think there's a lot of other garbage in this case, and that's the problem. And you can't know for sure
I
if we're
agree.
convicting for the right reasons, which is the whole reason
We invented the rules of evidence, and 403 in particular, to keep evidence out for exactly this reason. We thought about this a long time ago.
Absolutely, and that's the reason you keep a client, because you want a fair trial so that you can have confidence in the outcome. And when we're talking like, what we're talking about, this whole financial thing is just swamping this case. Are we really convicting on a murder charge when maybe it's something else because he's a bad guy, which is not the case issue? But the more they muddied up this waters, it creates the danger of an unfair trial in which we don't have confidence in an outcome. And I would say that my confidence is regardless of what the jury does, my confidence is undermined that this is a fair trial based on that overwhelming focus on the financial crimes by the state.
I think especially in particular because the judge made absolutely no attempt to try to restrict it down. Like if the judge had tried to limit the financial information in a more narrowly tailored way, I think we could disagree, but not perhaps as sharply. But we're going back 10 years into basically every financial deal he's ever done as part of this grand continuing series of financial crimes, which, I mean, if we're in a financial crimes case, that makes a lot of sense, because what little I know about financial crimes from talking to people who have done that, like at bar association meetings or whatever, and you run into people who do that kind of work, it's basically never the first crime that gets these people. It's always like the 20th one down the road as they get more and more comfortable and more needy and more whatever, and then it basically unravels and you kind of figure out the whole story. So that sort of pattern makes total sense. But yeah, I don't really have particular confidence in this thing. The other issue that we wanted to talk about during the break was the apparent decision, which seems to be the zeitgeist, that Murdaugh apparently wants to take the stand tomorrow, and the defense wants to again try to cabin potential cross-examination on this issue to not have it be exposed on all the financial crimes, so he doesn't have to choose.
Before we get to that, I just want to say, because you were just talking about this other issue, I've been banging the drum all morning. And I know that most of you are sitting here in my audience, the overwhelming majority of you, with the exception of one dude named Jeff H., who loves trolling my entire crowd, basically believes in the foundational principle that it is the state's burden to prove guilt beyond a reasonable doubt, and that they are so many light years away from having succeeded on that in this particular case that it's a joke that this thing was even brought to trial. I mean, what they really have here at the end of the day is he lied about going down to the kennels. That's
right. Yeah. Well, a lot of people get convicted of lying rather than the underlying crime. So that's always the thing. I would say I wouldn't put it quite that way, Joe. I would put it this way. This is a crime that has not yet been solved. They have evidence that he did it, but they can't exclude lots of reasonable hypotheses of innocence, and they have not solved the crime. They rushed, they jumped the gun, they charged the guy that they couldn't solve the crime. They didn't have good leads. So they went ahead and they charged the person that was closest to them that they thought that they could cobble together a case. But I think this is a crime that was not yet solved. They should have waited. They should have, who knows what's developing. I don't think they had the evidence sufficient to take it to the grand jury at that point. That's why they lied to the grand jury to get the indictment.
Yeah.
So it's not that I think, I'm actually leaning pretty hard that he did not do it. But that's Andrew Bronco said a few days ago on this thing. He says, well, but he's not really, that's not even the question. Us speculating on that's just idle talk. The only thing that matters, and I think Kurt agreed with this, is that can the state prove it beyond exclusionary reasonable doubt? Every other question is really just us.
But the drum I've been banging is okay. So I'm not really talking to those in the audience who are like, hey, the jury must find him guilty. I'm really much more focusing instead of on the law, and because I feel like anyone who's looking at this from a classic constitutionalist perspective, as far as like proving guilt beyond a reasonable doubt, will say there's no way that he should be convicted. If that's what you think the jury is doing, if that's where you think the jury is, if you think the jury, if you believe that the jury has that mindset, present no defense, say the defense rests and the state has proven nothing, and you won. And that's it. If you're presenting a defense, it's because you're worried that people are not going to be, in the jury, are not sitting with the same standard of approach to this trial that you have, which is a logical concern to have. That being the case, every witness that comes up here, you should be fixating not on the mindset of someone who's looking for the state to reach the standard of guilt beyond a reasonable doubt, but by someone who might conceivably convict him because they're angry at him because he's a thief, or they think he's a liar, or they think that he's a deceitful person, and they convict him for something other than guilt beyond a reasonable doubt of double murder. Now, if that's what we're presenting the defense, and there's no reason to present the defense for anyone else, because we already established that people who think like you, me, the rest of this panel, most people in my chat, they already would say not guilty, and you can go home. So the only reason we're presenting a defense here is for the other people. So you have to sit in their shoes and approach something that's targeting what they're thinking. And that's why every witness you put on the stand, whether it's Alex or Alex's friend or Buster or some expert, every one of them should be tailored towards that guy, that woman, that mindset, and how do I convince that person that they should say not guilty? And that's what I'm saying. Putting Buster on the stand, total sense. You want to put a forensic scientist up there who's going to say that it's illogical to think that Alex could have done this because he's too tall based on how physics works. Great. Okay, that makes them feel uncomfortable that, oh my God, it's like I'm denying science by convicting him of this crime. That's great also. If you want to try and get and convince them we can't trust SLED, that's so. And if the guy who's getting up there to say we can't trust SLED is he's also his lifelong buddy who you know is going to get crossed. And I predicted that cross the second before he stood up there. He's going to be like, you didn't really know him. We all could have predicted it. Every one of us would have predicted it because it's not really much insight because that's what Creighton Waters has shown us throughout this trial. Yeah, over and over again. And that he was going to bring up the financial crimes and you didn't know him and then start rehashing them. All you're doing to that juror who's our target, all you're doing is you're rekindling in them, they're inflaming in them all the hatred of Alex. Why do this? What is the upside? All you're doing is making them remember, oh my God, I really hate this guy. I was sitting here yesterday thinking about how physics can't work, but maybe this guy's so terrible. Maybe the physicist is wrong. Maybe Buster didn't really know him either. You're just giving them all this more incentive. Is that a reason that they should convict? No. But I'm not talking about what people should do. I'm talking about what people will do. And that being the case, I thought it was such a bad move bringing this guy up here, unless you know that on redirect or on direct, you can ask him confidently, sitting here today, despite all the crimes you know about, all the terrible things, as a lawyer and as his friend, do you really believe there's any chance that Alex committed this double homicide of his own wife and son? Unless you're positive you're going to get a resounding no, I do not believe you can put this guy on the stand today. I think it was a terrible, terrible tactical move based on the audience that you're trying to sell this to. That was my point.
Well, no, I think you're right in reality. I think the jury is going to go back and ask themselves whether or not they think that Alex Murdaugh being involved in the murders is the most plausible scenario of the possible scenarios. And if they answer that question, yes, they'll vote to convict. So they'll just simply ask, is it our number one theory? They won't ask whether or not it's been proven beyond a reasonable doubt. They won't, I don't think as a matter of reality, they'll ask themselves the question, are our alternatives reasonable doubt? They'll just ask themselves, what is the most likely scenario?
Yeah, it's possible. I don't know. It's, juries are very fickle things. You don't know what they think. But what the scenario outline is within the realm of possibility. You might have a very analytical jury. You might have, that's why jury selection is so important. But we don't know we really don't know what's going on. But think about, wouldn't you rather have the jury decide though than this judge?
Oh, hell yeah. My God.
Well, one thing that's not up for argument is it's after 3 a.m. here.
Yeah, it's my brother.
I have the option of pulling the ripcord on this insanity. You're stuck here, Joe.
I want to thank you. I want to thank you for leaving because as soon as you leave, the trial just goes into overdrive every day.
Yeah.
And I want to point out, I mentioned at the start of my stream, and I'm going to repeat it now. Tomorrow morning, I have my grandson's bris, so I'm not going to start till 11 o'clock. My game plan is Legal Vice is here. I'm going to ask you all now to sub up to him. Take a moment to pause and sub up to him. He's great content, and he's going to be streaming this thing tomorrow morning and at 9:30 when it starts. And here, my perspective is this. I don't know if Alex is going to be taking a stand tomorrow morning or not. They say he might take it, he might not take it. We're about to engage in a whole conversation about the Fifth Amendment rights and fraud and all the other stuff.
I'll be streaming. Of course, he's not going to do it while I'm streaming.
What I'm saying is, if he is streaming, then I'm going to want to watch that from the beginning, and I'm probably going to end up running it on delay from 11 o'clock. If not, if it's just like a witness, like, you know, the guy who's on the stand right now or someone similar to that, anyone but Alex, I'll probably just jump right in and start and go where I'm at, like 11 o'clock when I show up.
Just whenever Joe goes live, we'll dump into him automatically.
Oh, you're too kind. Thank you. So anyway, please make sure you sub up to Legal Vices. I thank you for joining me, my brother.
Thanks, Steve.
Hey,
thanks for hooking me up.
You got it, man. Look at that. That's a what is it? A $500 cable I set you up
It is. All right. Take care, everybody.
Take care. Have a good night, brother.
See you. Bye.
Well, let's, I don't know. I got to go in about 15 minutes here, but
so instead of going into super chats, I want to have this conversation with you about the whole Fifth Amendment, waiving his rights, and the ability of the state to cross-examine him about the fraud cases while he's trying to taking a stand on a double murder case. So, and those of you who joined late, just to give you an understanding as to what this conversation is about, this morning, before the jury came in, the defense got up and they say, we need to counsel our client as to whether or not he should waive his Fifth Amendment privilege and take the stand. One of the factors that we need to consider is whether or not the state will be allowed to cross-examine him with respect to the fraud crimes and potentially put him in a position where he has to incriminate himself, or whether he'll be protected from that. So we're asking the court to give us its perspective as to whether or not he'll be forced to testify about those crimes if he's asked about it by the prosecution. And then Creighton Waters, so he asked the prosecution for their perspective. He got up there. He was very prepared for this. And he gave three different legal arguments as to why it was that he's entitled to cross-examine on the fraud case. He's like saying it's relevant. He was like, and he's citing statute. He's citing case law, and he's basically saying it's a crime. These are crimes that he's committed which show a propensity for lying. And that alone, in order to get in, you have to basically have a reason. You can't just bring up someone's crimes just because he's a defendant and take the stand. It doesn't just open a Pandora's box. In other words, if in the Rittenhouse trial, for example, think about this for a second. If in the Rittenhouse trial, he once had been convicted of arson, they wouldn't be allowed to bring that up in his murder case because it's just not, it's not relevant to that situation. Well, I don't know about it. Probably not. Whatever. But the point is that if he had been, I don't want to get tied down with that. You are allowed to bring up something that shows a propensity for this type of crime or something that shows a propensity for lying. Fraud is something that shows a propensity for lying. The reason that the state's allowed to raise those crimes is because of the fact that they can say, look, you're sitting here trusting him. A lot of people trusted him. Here are reasons you should doubt yourself when you're trusting him. This guy has been proven to commit fraud. Now, so that's one reason that they're saying, and they also are saying it's highly relevant to his whole motive here. We need to explore his motive, and in order for us to be able to fully flesh out what his motives are, we're going to have to ask him about this fraud thing. And the state has lots of reasons for wanting to be able to ask him about it. They put him on the spot. They chill his desire to get up there and take the stand and perhaps raise some sympathy for himself. And they're definitely going to So they'd rather he not take the stand. And if he does take the stand, they can get him to convict himself, to admit to crimes, financial crimes, then they know they have the convictions on those crimes. So they definitely want to ask him about that when he takes the stand. And and from a philosophical legal perspective, there are grounds that the state has, legitimate grounds, irrespective of any bias some of you might feel the judge has, that if this judge has the wisdom and fairness of Solomon, he still could a judge could reasonably find in this circumstance, given where we're at, and starting from this point here, that it does make sense to allow the states to cross-examine him about the fraud. So I want to flesh that out with you, Steve, and with you, Kurt, two people who I think who approach and appreciate the philosophy behind law, and talk about which elements do you think weigh in here? And you probably had not researched South Carolina law, specifically. I wouldn't hold either you. I wouldn't have any expectation that either of you have done that. But philosophically, I think you both engage in philosophical thought a lot, and that's why I want to ask you your thoughts with respect to him, the state being allowed to cross-examine him if he does waive his Fifth Amendment rights, and he wants to talk about the murder and why he's not guilty of that, and being cross-examined about these charges involving fraud. So, Steve, you're on the limited window. I'll start with you.
Yeah. Actually,
I'm out of time.
Can I just say that I think, Kurt, are you going to be streaming tomorrow morning also?
Oh, I don't know. If Murdaugh winds up taking the stand, I might do it. Just because it sounds hilarious.
I don't blame you.
It's going to be an important thing. Can I just say that I gotta go, and I'm going to be streaming on Rumble tonight at 8 p.m. Eastern Standard Time.
Yeah,
so I'm going to actually because they don't have any gun restrictions. I'm going to recreate with my AR the 30-inch measurement, and I'll show you the angle. I'm almost 6 foot. I'm 5'11" and a half. And so I'm going to recreate that. I got to tap out. I'm sorry, guys. I got to go. Kurt, I'm going to pass it off to you. You can handle that question.
Steve, thank you so much for joining. Make sure you guys check out Steve Gosney. Sign up to him. Buy his book. He's amazing. You're going to love him. Make sure you check him out. In fact, I'm not sure if I have him there in the description. So what do you got for me, brother?
Yeah, so I mean, the standard rule is, you can't invoke the Fifth Amendment in part. It's kind of an all or nothing proposition. When you take the stand, you open yourself up to everything. This is also incidentally why they can't just ask like one question and be where the states then can't ask whatever they want. So the usual rule is that the scope of the cross-examination is not limited by the scope of the direct, and the scope of the cross is anything that's relevant in the trial, anything that they would have knowledge about. So the judge, apparently having determined that it's already relevant and also not substantially more prejudicial than probative, then he can take the stand, and then they should be able to ask him about it because it's relevant and say, well, are these things? I suppose they can't ask him like the ultimate question, like, did you do it or something, but they can ask him sort of any question of fact, like, is this your signature and stuff like that. And I don't really know what the basis would be except 403 outside of that, because it's so prejudicial. So outside of that evidentiary rule that the judge could invoke to cabinet, then I don't know what else you would use.
Okay. Let's say he gets asked a question, didn't you steal money from that kid, your maid's son's thing, right? He's asked a question like that. I plead the fifth. I plead the fifth. I plead the fifth. Every fraud question, I plead the fifth.
Yeah, that doesn't work. Usually, it's usually an all or nothing proposition. So typically, if you invoke the fifth, it means your entire testimony is stricken, all of it. You can take the fifth or not. You can't pick and choose.
You can't pick and choose. Let's assume for a moment it had no relevance at all. In that case,
which it doesn't.
Which it doesn't. Yeah. I mean, to my mind, it doesn't, but to the judge's mind, it does. And unfortunately, his opinion on this matters more than yours or mine.
Right.
So, let's assume that the state had never raised anything about this, okay, at all.
Right.
Let's assume that the state had a whole different theory on his motive. Let's assume there was an actual motive. Let's pretend there was life insurance on both of them. And they figured the motive was he wanted to collect life insurance. That's why he killed them.
Yeah.
Okay, that would be that's a much easier motive to sell. Now they
Yeah.
have these charges of fraud.
Right.
Do you think so? It's not conviction. They should not be allowed to bring that up in that circumstance, right?
Yeah. The rule for, at least for South Carolina, the way they operated on this is in order to bring it in.
South Carolina.
I lived there for 20 years.
Yeah.
The way they operated on this is that apparently the relevant legal standard is that it has to be proven by clear and convincing evidence. And then where things get tricky is the nexus or the tie to the crime in question. So as to the financial crimes, I think they've proved it by clear and convincing evidence. I think they're well on their way to beyond reasonable doubt in those trials. So I think they got the first half of that equation without breaking a sweat. Where things get tricky is the nexus to the crime, particularly as things get more and more removed from the date in question. Like, he was confronted about the $792,000 that day, and somehow murder.
It sounds like you're referencing Cartwright in the suicide thing.
I am writing it. Yeah.
Oh, okay, fine.
Yeah.
No, because so you're saying that standard they applied for an attempted suicide is the same standard, the same test that they'll apply for crimes.
Fundamentally, yes.
Interesting.
Yeah.
Okay.
So that's the problem. But yeah, you can't invoke the fifth in part. So if it's relevant, then they can ask about and the only thing that stops that, unless there's some constitutional law decision in South Carolina, which there might be, because there might be some state specific thing or some thing that I'm not aware of, but absent something that's outside my knowledge base, then the only thing that would be a safeguard to that is 403, and be like, it's just substantially more prejudicial than probative because it's tangential and it also relates to his fundamental rights. And so 403, I think, is a reasonable stopgap, and be like, yeah, you can't mention that, but heaven forbid the defense asks any question about it at all, because you know what this judge will do the moment the defense opens that door. It's wide open, assuming the judge was likely to, so they have to be real effing careful. Now, I think it was Nick Ricada who commented at one point that he thinks that there's really not much to lose at this point, and maybe he should do it anyway, despite all those concerns, and just basically admit to the financial crimes, because he knows
that was
down.
the take that Andrew expressed this morning.
Okay, yeah. So maybe it was Andrew in the first instance, or maybe it was Nick. It's always difficult to remember who said what exactly when you're on these panels sometimes.
I know.
But the idea being like, he's going down. I mean, he sees the evidence if he hasn't already. He's seen it presented in open court. He's seen these people. He's gotten a preview, basically, of his upcoming financial fraud trial. He's seen these people testify with the actual evidence they're going to use, and he knows what their testimony is going to be. So, like, he has a pretty good window into what's going down. Mm-hmm. It's like, and he's already admitted to some of this stuff in relation to his disbarment, and he's going down, and he's going down hard. And so the length of time in which he's going down, I think, is still open in the air. Although I think it's hard to imagine that whatever the number is won't amount to a life sentence in practice, if not in number. Right. If he gets 30 years plus, we're talking about a life sentence, and I think that's a very realistic number given the 106 pending counts we're talking about.
Right.
So that's that issue. But yeah, he takes the stand and basically just beats like he admits to it, which also has the nice advantage, I suppose, in some ways, of gaining credibility for the jury, because then they'll feel like he's taking a mission for that, and they'll also feel confident that he will be convicted in those crimes, because Dick Harpootlian's already raised that possibility of him getting a life sentence. And I don't think life proper is probably the right result, but it'll be life practical. So if he gets up and takes a stand and he admits to everything, and the jury knows that he's going down for all those financial crimes, then that makes it a lot easier. Well, he gains credibility, and credibility is huge. And the jury feels that to the extent they care, they feel like they don't have to convict him now because he's going down for all the other stuff anyway.
Right.
So I in the absence of some specific analysis that I'm missing, which I'm totally open to the possibility of, that's sort of what I think.
So if
I were the judge, I would keep it out, at least the vast majority of it. But then again, I would have cabined it in the first place for exactly the same reason.
Right.
So if I didn't do it then, I'm not sure why I'm doing it now, except maybe, I have other concerns. But
And when he first allowed this in, that first thought I had is, this kills his ability to take the stand, because I had exactly the concerns that you're raising here and now. At the same time, if I was his counsel, I think I would take this approach. You know what? You're gonna have to eat those crimes. There's no way around it, and hope that you're gonna get a healthier jail than you would if you get convicted on murder. Unless you feel that, I mean, the reason not to do it is if you feel you won already. In which case, why admit to something and make it that much easier to convict you if you feel like you won? I mean, look, everyone in my audience here thinks he won. If he picked, not everyone, there are a few exceptions.
Yeah. Well, I think people are rightly thinking that I think there's a very decent chance of odds of conviction. And to be fair to the jury, we have not seen, at least in real time, a lot of the evidence. Now, some of that evidence is published after the fact by the news outlets, and I've seen some of that evidence, but I'm not able to consider it in real time in the context that the jury is able to. So my experience of the trial is not the same as the jury's experience of the trial. Plus, I'm not from this community. Plus, I don't have all the baggage of all this stuff that's going on. So if the jury convicts, it may be for the right reasons. They may really believe that the state proved beyond a reasonable doubt. As Steve Gosney was pointing out too, like and you for that matter, the biggest problem is the kennel thing. And this is also, like, the Innocence Project will tell you all day about people who falsely confess to crimes, let alone make mistakes when they're telling the police their story, and are convicted for saying all kinds of crap. People say all kinds of crap in interrogations and otherwise. People falsely confess to crimes. People make up stuff. They lie. Or they're just confused, or they feel trapped or scared or whatever. And the amount of people that are in jail because they got caught in a lie, which was completely a self-imposed error in a lot of those cases.
Mm-hmm.
Well, the Innocence Project will be happy to tell you about many of them, I'm sure. It is a real problem.
And let's face it, he's not a very sympathetic individual, because he is a slime ball. He's, so, and I think most of us believe that he's guilty of these financial crimes based on the evidence we've seen so far. And it's disappointing that we've seen so much of that evidence so far in a double murder trial, but we have seen that evidence, and it's like, oh my God, this guy's like stealing from orphans who are like, who are the orphans of people who were, his own employees and working in his house, and he's stealing from them. You just think like, my God, you're a terrible human being. And double stealing from his own firm, which is, his lifelong friends. It's like, wow, you're a terrible human being. I want to ask you, I don't know if I've asked you this question. What are your thoughts on this whole whodunit? If, putting the whole what has been proven part aside, if you had to guess exactly what happened here, what do you think is what happened?
That's a good
You're
question.
not used to being asked to step outside your lawyer box.
Well, yeah. Based on the available information, I'm not sure that I have an opinion. If I want to speculate beyond that, I think the most plausible result, or the most plausible answer, is that I think they came to the house that night. I think gang-related activity is my working bet. Is that he was, in debt to some shady people, or they were concerned about him, and they came there potentially with not necessarily murder on their mind, but to scare them. And when Alex wasn't there, they caught them unawares, and things went wrong. Or maybe they came there to kill one of them and things went wrong, or something like that. So, the idea, like, if it was a gang thing, and they know that he goes to his father's house from time to time, and there's like, well, your father's in the hospital, they might have thought, the odds are pretty good he's going to go to his house to check on his mother tonight. And maybe they're lying in wait. And the moment they see his car leave, they drive up the driveway and they, do their thing. So some sort of gang related activity, I think, is my working bet.
Because that's similar to mine. I actually think he watched his wife and son die. That's become my theory. I believe he was at the kennels. I believe that the time of the murder was way too close for him to not be aware of the fact that they were dead. I think that his activity, I don't think he had any motive to kill them himself. I think that's ridiculous. I think it's kind of ridiculous to think that he pulled the trigger on them. But I do think, and if we look at all the forensic evidence that the state has presented, and we take it and say, okay, what makes the most sense if I try to figure out what actually went down that night? What makes the most sense? If I give any credit to the whole steps and time thing and everything that happened there, I think, and his trying to call his wife, why is he trying to call his wife? I agree with you. I think it's gang related, I think, or mob, whatever. And I think he saw them being murdered and he knew it was a message that was given to him. And he's like, I can't go to the police about this. And that they basically threatened him that, like, if you report this anytime in the next hour before we have a chance to, disappear, we'll kill Buster next, or something to that effect. So he basically felt like, I can't do anything about this. I don't want to, and I want to get out of here so that I'm not tied to these murders. And that's why he basically darts back to his house, gets in his car, tries painting as if he's not the one who's doing this. He doesn't take Maggie's phone because we see Maggie's phone goes 54 steps while he's going 280 steps. One of the other people takes the phone and ends up ditching it. And he's calling that phone to try and present an alibi for himself.
That's a lot of in response.
I'm trying to figure out what the forensic evidence has shown us happened. I'm trying to reconstruct why would this happen in this sequence of events? And then that's why he doesn't have to waste time trying to get rid of guns or bloody clothing or any of that. And that he basically ends up, and that's why he's all freaked out when he's racing back and he comes back to the kennels, and 10 seconds after he's at the kennels that night, he's calling 911 because he knows that they're dead. And, he saw them die an hour earlier, but he can't. And that's why he's saying things like they did him so bad. He knows it's they. It's not one. He knows it's two people. It makes sense why there's two guns, because it's two people. Everything here ties together as far as why things look the way they do. And it's the height of the shooter. It certainly could have been someone, some shorter individual. Everything here, to me, ties together why he's not really freaked out as far as he seems a little concerned about, being framed for it, but he seems to know that it's they. I mean, why would anyone think it was two different people? That they were saying they and instead of he. That's what I would.
Maybe it was a singular person and he knew their pronouns, Joe.
Yeah, okay, yeah, maybe he was being politically correct and assumed it was a binary who was a pansexual who killed his wife and son.
Pansexuals commit murders too, Joe.
Yes, that's true. That's true, and I think that's why we haven't heard him give any names, and he figured if people know I'm there at the kennel, in that case it's going to look bad for me, and he assumed that no one knew he was at the kennel. He didn't realize he was caught on that recording from Paul, and that's why he's lying about it, and because he feels like I don't want anyone to be questioning me as to what I saw. Or if I'm not there, it's just much cleaner. But I cannot believe he's any motive to kill them, and. It's convenient, if he has a shock memory loss.
I like your theory. The only problem with it is it requires a lot of presence of mind for him to make all those calls on the way to and from Moselle and go to Moselle with basically not tipping anyone off. I guess he's extremely well motivated in your hypothetical to not tip anyone off, but still pretty difficult for someone to pull that off.
Which fact am I missing? I'm literally going fact by fact here in order to come to this conclusion. If there's a single fact that is any piece of forensic evidence that at all refutes what I said, let me know.
Everything. I think it's consistent with the facts. I mean, we were speculating wildly, but then again, so was I. But that's fine.
Yeah. Anyway. All right. I love this. Everyone, every possible way. It's possible. Look, I could be wrong. You know what? I challenge you to come up with a better theory. I challenge anyone to come up with a better theory. I'm not married to it. I'm like,
this
is
point,
what makes sense to me.
Sled did it. I believe it.
I'm not married to it. I'm like, this is what based on the forensic evidence, this is the best conclusion that I can see. If I hear someone come up with something better, I'd be happy to embrace that. But I'm waiting for that day, and I'm starting to wonder if that'll ever come. That day will ever come. So let me take care of a few chats here. So first we have on Rumble, Bejan the Great says, consider the following. The state is local prosecution. If they seek out the financial case, may successfully uncover a large corruption case that also involves the prosecutor's office. Instead, they want the murder charge to drop the financial stuff, thus mailing him without taking anyone else down. I
don't really buy that. I mean, at this point, those law firm books have been torn apart by everybody.
Yeah.
The feds, the Secret Service, the FBI, the accountants, the state police, literally everyone. I don't think anyone's afraid of some unknown thing being discovered at this point. Those books have been forensic audited to death.
Yeah. Just Revere says, no, these are separate. Nick said admit all. Andrew asked if judge compels here, can it be excluded later in financial trial? What say you, Kurt? So what about that thought? That if he says, I plead the fifth, and the judge says, I'm not allowing it, and he's forced to testify, that if there is a later fraud charge, that they can get it excluded on the basis that it should never have been allowed by this judge.
I'm saying. You're depending on a future judge to put that in place. I wouldn't bank on it.
Yeah.
Not just incidentally a future judge, because how many indictments are we at? 15 or 16? It's hard to keep track. Although this is the same judge, and this isn't the same judge. This is the same judge hearing all these cases.
Is it
so
really?
He would have to overrule himself. It's even less likely. For like six minor,
you need the appellate court. You need the
7 minor federal charges that are pending. They're all being heard by the same judge, aren't they?
Justifier says, Kurt sensibly explains him being at the scene but not doing it, which is most likely, in my opinion. I have a very hard time believing he did it, just based on all of the state testimony. Anyone who knew him talking about how much he loved his family. I just have a very hard time buying it at this point. No one's come up with any motive that makes any sense. If there was tons of money there in life insurance, I could buy it. I can't. But that's just not the facts. So now you tell me, why did he kill him? And all of you who are sitting here just hating on my theory, you're free to do that. That's fine. I'm simply saying, explain to me why it is the whole timing of everything that happened with the phone, and why it is that do you think he killed him? This guy who couldn't put down his own dog when he had no motive? I mean, we can't think of any possible motive. Do you think he killed him? So I don't understand. But they're dead. Someone killed him. And he seems like he was really close. Like a minute or two before, 5 minutes before, he was really, really close. So you tell me, and why is it that he finds them really fast afterwards, and I can't believe that he pulled the trigger. So
yeah,
all sort of ties. Phones moving different distances, all ties. Just saying. Let me get to some of the super chats here. Let's do it. Lesko says, I'm going to Stout for lunch to eat some Guinness. Why are they trying to bore me to death again? Hit me with the buckshot already. Scott Baines, why go into the financial stuff with this witness on direct? I don't know.
Draw the sting.
Did you see the first witness, the friend, Mark Ball? What?
Yeah. Draw the sting. Because because you know for an absolute certainty the prosecution's going to do it, and so you do it first, so it doesn't hurt as much.
Yeah. I mean, he was pretty much. He was kind of a character witness also, so they would have come in anyway to refute.
You always,
testimony.
if bad information is unavoidable, you want to mention it before they do, because first of all, you get to control it a lot more, because you get to pose the questions and the answers, right? Because you're basically asking yourself this point. So you get to pose it, so you get to ask it a lot more, so you get to massage it a lot more. And you gain credibility by mentioning it first. And you take away their Matlock moment by like, isn't it true that? It's like, yeah, I already said that. So if bad information is unavoidable, you mention it first.
Okay. Lesko says, I would pull myself to the ceiling before reading all the going over at ETB. MS Krim says, here's some money. This will turn into financial crime questions. Redneck Ram says, someone really needs to tell old Crate and Barrel up there that he doesn't have to yell everything. He ain't in no 40-acre field. He does come out swinging and screaming. Lesko says, a 10% like ratio. Turn the stream volume off until the button is adequately caressed. Go ahead. Caress that button. You can do it. Hit the like. Hit the subscribe. Do show a little love. A little love. You don't have to super chat, but
You deserve the love. You're a good guy.
it. Thank you. I'm doing my best here. Eric Non-Idol says, misstates last 2 days. Anything moved the needle for you before they rested? No. They never managed to convince me, barring some bombshell at the end. They just had a timeline guy who got ripped apart, basically saying, yeah, everything I read to you, I don't really understand it myself. I just read a report. And yeah, if it conflicts, I can't explain. It's all just a guess. So, yeah. Alyssa Ramirez says, General Genaro Garcia Luna found guilty on all charges yesterday. Government corruption is real in Mexico. The U.S. system may be flawed, but there's still hope for justice. I'm going to tell you right now, American justice system stinks. I spent 10 minutes explaining how our civil justice system is garbage, and our criminal justice system seems absolutely no better, and yet it's probably the best justice system on the planet. So
God bless the USA.
Yeah. I can tell you that it's awful while still saying it's better than all the others. So, let's go, Brandon. Playboard has your highest live viewers at 7,331. Oh, okay, there you go. It's probably from yesterday. If you start tanking shots, people are going to hit the like button, and we're getting over 10K. Prove me wrong. I don't think YouTube will ever allow for that. MS Krim says, "Oh, what happened with the murder trial? We went back in time to financial trial. Old news."
Yeah,
Corn Pop. Was Mark Ball ESQ ever a suspect? I think he's too tall.
I've got some nice Knob Creek and 9-year and some Four Roses small batch, brand new bottles, Brandon. So available.
Exactly. You can't stream without clients. This is when I was talking about how Alex is a rainmaker, and that in many ways the rainmaker is the most important man in the firm. Without clients, you have no firm. You have nothing. And if he leaves, and he's got these political connections, whether they're political in the literal sense or political in the social sense, but he has these contacts and they go with him, your firm's cooked. So you make nice to your rainmaker, and that's why I'm sure they afforded him a lot of leeway. And Lesko says, exactly, you can't stream without clients, and the viewers want shots. You got to keep them happy. Also, why is the prosecutor yelling at me? I don't know why he's yelling at you. He was yelling at all of us. Gara! Welcome to the following. God bless you, Cara Fro. May all your dreams and hopes come true. All of them. Every single one of them. Empowered Life Apparel. I need Crane to learn to match energy levels. David Caggy. I think it's funny that the prosecution continues to act that there's no jump between financial crimes and murder. They have failed to connect enough evidence to overcome doubt. Here.
At this point, I want the not guilty verdict just so I could laugh in the state's face, because the Schadenfreude is going to be very real.
I'll tell you right now, I don't care about him at all, but I agree with you. I really want it. To me, it'd be like a win for our criminal justice system if he's found not guilty. It gives me hope in society, even though I think I want him to spend the rest of his natural life in jail for what he did for his financial crimes. But yeah, it would really give me belief in our system. Chris Scianti says, I think you guys missed it, but he almost admitted others in the law firm did the same thing with loans, but prosecutor cut him off and said, but Alec did it the worst, right? 8 minutes before the break that was just taken. I did miss it, so thanks for calling to our attention. And I do think there probably was more than one person doing shady kind of stuff. That's just a gut. I don't know. I'm not charging. Totally opinion. I have zero fact behind that. Don't sue me. Because I really don't know. But usually there's more than, usually birds of a feather flock together. We'll just leave it like that. Birds of a feather tend to flock
Which says a lot about LawTube, right?
There you go. Wait, no. What is LawTube? What is this thing you say of?
The genre.
It is a genre. Shane M says, if he takes the stand and admits to the crime, just make sure. I got the TV on in the background here for Law and Crime. Make sure, just checking the time. I have at least a half hour. If he takes a stand and admits to the crime, but this is overturned appeal, can it still be used against him? Yes, I believe so.
Yeah.
because it's a statement made under oath in a proceeding. Even if the conviction is overturned, it's his testimony given before an open court. It's a great question, Shane, but I believe it could be used. Yeah. Aaron Largue says the witness to board jury of financial before AM takes the stand. Well, he's not taking the stand today. Maybe tomorrow. If he takes the stand, we have to see what they end up deciding. Tyler M says we need to remember Alex had a drug addiction. As a recovering addict myself, I know well what kind of things I did to feed that addiction. That looking back now, I'd never have done otherwise. Murder is a whole other level. I agree. I don't believe he could have killed him. Some people are telling me in my Rumble chat, well, you're trying to use evidence in the fact that you couldn't down a dog. Hitler loved dogs too. Okay. Hitler loved dogs.
Did he love all dogs or only some of the dogs? That's the key question.
He loved the Gentile dogs. Play more family videos, defense. SOS. Yeah, I think this is complaining about that witness who was terrible. Don't get brazen with me. Isn't this the exact thing that Binger did wrong in Rittenhouse? How is it making him not messing with his right to remain silent? So that's what we're saying is that he has a right to remain silent, but if you waive it by taking the stand, you waive it. And the question is, when you're waiving it, how big a waiver am I giving? That's really what the ultimate question is that we're trying to grapple with. Is it a waiver on everything? That you can now ask me anything? It's philosophically, it's a really interesting thing because ultimately it does chill his right to protect his Fifth Amendment rights on the fraud.
Yeah.
That it's to me, because it's a pending charge, it makes it worse to allow the state to ask him about it. If it was not a pending charge, then I wouldn't care.
Well,
then
yeah,
I would say, go for it.
if you've already been convicted, then the Fifth Amendment's irrelevant because there's no jeopardy.
Right, or if he had been acquitted on it, but
then there'd also be no jeopardy. Yeah.
Exactly. But that's the point is, to stop to use a potential conviction to chill in case B, to chill his ability to defend himself in case A, to me philosophically feels so wrong. But I can understand why under the rules of evidence, you're correct that Creighton Waters has probably a stronger argument than the defense has. At least at this stage, now that the judge has deemed it to be relevant, at this stage, Waters has a more powerful position. I agree with you. We never should have gotten to this stage.
If it's relevant and it's and he has personal knowledge on it, so he can be questioned about it. So,
yeah,
it's like yeah. Maybe the judge will say no, and maybe there will be some specific reason why, and I'll learn something. That'll be cool.
Yeah, right. Let's talk about prepping. Nicotine is 21 now as well. It happened in an omnibus under Trump.
True.
I was talking about how alcohol is 21 nationwide. Winter said, I may have just woken up, but we all know it's all about the Penguins. Alex on the stand and nothing about money asked. Wouldn't it be outside the scope on cross? No, because
it doesn't work that way.
Yeah.
It doesn't work that way. The reason it doesn't work that way philosophically is that the reason that you can restrict on scope or cross is that's like that the judge will say it has to be within scope. The reason that that's typically true is because either party can call any witness. So if a judge says, okay, you can only ask questions on cross that are in the scope, I want to ask questions beyond that, call them as your own witness because you can. But of course, with the defendant, you can't. Right? That's why the exception proves the rule. So the state has no opportunity to call him as a witness. So therefore, the only way to give them the opportunity that they would otherwise have is to allow an unlimited cross. So crosses for defendants are unlimited.
And look who we have here. James from Court.
Hello. Hey, everyone.
Great.
Someone who might actually know something. How's it going in South Carolina?
It's going well. It's a nice, actually warm day here. The courtroom, of course, is in buzz about Alex Murdaugh testifying. That's kind of like the biggest talk from inside the courtroom. But otherwise getting ready for hopefully just another 2 or 3 days of this.
Yeah, well, it seems as if they said he's not going to testify today, but may testify tomorrow or Friday. So, do you think people are expecting that he's going to take the stand?
No, not today, but yeah, this week for sure. And that's what people are kind of excited about. The person who I do trust this because it's, and I've said this before, but both teams, but especially the defense, are very much like in conversations with the media all the time. So unless this is like a trick of them, which I doubt they would just do like a publicity stunt like that, when they're telling people in the courtroom, and especially kind of their go-to, I guess, mouthpieces, it definitely, I think, is probably something that's going to happen this week, probably tomorrow.
That he's going to take the stand tomorrow. Of course, it's going to be tomorrow. I know it's going to be while I'm like traveling back from Queens for my grandson's birth. So where is are you able to like see like how the defense team looks, whether they feel as if, because I mean, what was there a vibe today as to how today's testimony has been going compared to yesterday's?
Well, I mean, personally, I just feel like the testimonies were kind of used more for the prosecution at times during cross. And I feel like maybe the defense team noticed that as well.
Mm-hmm.
I don't know. I think it says something to me that they brought in one of the other attorneys at the very last moment. I don't know if she was always planned to take the last couple of days, but I've never seen her actually speak in court before. Yeah, exactly. She's just usually helping and stuff. So I don't know if they realized, okay, we need maybe a little bit of a softer approach here. We need maybe more sympathy, because I think yesterday the sympathetic tone that they needed with Buster did not land. And again, this has nothing to do with, I guess, I don't know if we're even in a trial over actual legal issues anymore. It seems like more of a trial now of just like, is this guy a bad guy? But if they're trying to argue him being a good guy, Buster did not help yesterday. So I don't know if this is now they're trying to do, cleanup or something like that. But I thought that was interesting.
So have you been able to tell from your conversations with anyone, or general perception, whether or not people's, or at least the gallery or the general public's perception of guilt or innocence has changed at all since the defense has started their case?
I think it's gotten worse, to be honest, but it's so hard because people who show up are so often very biased, either one way or the other. They show up because they really care about the case. But again, these are people that live in the area. So I have a hard time imagining that the jury is going to have a completely different reaction. But the media is also very different as well. When you talk to people in the media, they have a much more like level head about this, and they don't love some of the ways that the prosecution tries to insinuate guilt without providing evidence, especially, with some of the witnesses as well. But I mean, if you liked the technical, details with the forensic engineer, I mean, that could be something that would help. To me, it was something that's hard to follow. And I've said this over and over and over again, but the fact that the jury can't even take notes and won't have any, transcript, they'll be able to see evidence but not transcript. I think it's going to be hard to land any concrete information with them.
Okay, so I want to ask you. I want to frame it this way, because I one of the advantages I like about having you there is because you're sitting there in the room. You have the same feel as if you were sitting in the jury box, even though obviously you're not a juror, but you have the same feel for how the room might be taking something. So my question is this: Mark Ball, the friend attorney, shows up and spends most of the morning testifying here. Do you think his testimony did more to help the state or to help the defense?
I was shocked, honestly, that he was put up, because I thought he did much more to help the defense. I mean, the state, prosecutors. And I feel like from what I saw of the jury members, I also feel like they had a similar view of it. Now, it's hard because these are the same jury members who I often see now. I think that they kind of had their mind made up. to an extent, and all you need is one or two to, cast doubt. But I don't believe that it helped the defense, especially when he called Alec Murdaugh cunning. I mean, I don't know what he thought he was doing there, because what he basically outlined was a guy who could very well cover up a crime like this. You know what I mean? Even if we don't have evidence, it wasn't so far-fetched that he could do something so out of character. So I don't know. What do you all think as viewers watching it?
Well, no, to me, I hated him as a witness for the defense. I thought that was a terrible call. But I'm curious. The reason I want to get your opinion is because I feel like you're sitting there in the room, you're getting a feel for what it feels like to be in there in the room, not sitting there as an attorney, and I'm sitting here trying to look at it as an attorney being a legal strategist and what's likely to help your ability to sway a jury versus hurting your ability to sway that jury. And so I'm just trying to share with my audience my perspective as to what's likely to help versus hurt. And my take was I did not think that this helped them. I thought that Creighton Waters won that battle. That in the battle for is this, what should we take from this? Should we be more favorable toward the state after this, or more favorable to the defense? I felt that Creighton Waters won with respect to Mark Ball, and I don't think he's gotten many wins to my mind, but that one I felt was a clear win. That there was more. It was just an ugly slaying over and over again about what a thief he was. And cunning, I think, was that you locked in on that word, which I think is an interesting thing. That it's probably true. It's a terrible word that came out of the witness's mouth. One of the things I was hoping that he would do with that witness, I was hoping if you're putting that witness on the stand, that you can feel you don't put him on the stand unless you feel confident that you can ask him as a lawyer who's able to see through his BS now. After you saw what he did with the attempted suicide, you see through his BS. Now, today, do you believe that he actually killed his wife and his own wife and son? That the defense team should be confident that he will respond absolutely not. And in that way, he becomes a helpful character witness that, I'm not a shill. I'm not in the tank. I see the good and the bad in Alex. And despite seeing all this bad, there's absolutely no way that he would have gone to that level of killing his wife and son. And they never asked him that question point blank quite like that. And I think, and the implication was that he's really not sure anymore. So, and I thought that to me, that was terrible. I was like, if you can't get that out of him, I wouldn't put him up there. That was my take on Mark Ball. You're muted. I don't know if you realize you're muted or not. James, you still there? James. I guess not. Anyway,
we lost James.
All right. Well, I guess we'll get back to work on the uncovering these super chats here. So the guy that sold him 1,700-acre property for $5, he stole almost $300,000 from him while dying of cancer. What a turd!
Can I pimp my latest video on my channel?
Oh, please do. Yes. I want you all to know. By the way, I happen to love uncivil law's work. I urge each of you to sub up to him. He's a phenomenal content creator, doing this far longer than myself, far more experienced. He's back now. Give me 1 second. So,
Sorry about that.
Yeah, I don't know how much of what I said you heard, or versus what where I lost you. Are you there?
Yeah, pretty early on, to be honest. I got you said that you all don't have the same perspective because you're not in with the jury, but then I cut out because I'm in the backwoods of South Carolina.
Well, what I basically said was I would not have put him on the stand unless I knew that he would say that as a lawyer and his friend, despite all the garbage and being able to see through his BS, and even seeing through his BS, I don't believe for a second he could have killed his wife and son. And unless you can get that out of him, I would not put him on the stand. I would never put him on the stand at all. That was you, because you were asking me about my take on this. Are you there still?
Yeah, absolutely. And I agree. And I have another question because I felt like Buster was supposed to do the same job, but they didn't do that with Buster either. And I don't know how you feel about that, but I feel like they missed a huge opportunity. Never once did Buster say, "Oh my gosh, my father's such a good father. He would never do something like this. I can't believe blah blah blah." I mean, nothing. And I don't understand why the defense is like they set up the ball and they're just missing it completely. You know?
Yeah. And it could be that Buster doesn't feel that way. And they felt they had to put Buster on the stand because he's the son and everyone expects to hear from him. But Mark Ball is not someone everyone's expecting to hear from. And that's why I felt like they had a pure, open decision. Do we put him up there or not? You see what I'm saying? It's like if you don't put Buster on the stand, then it looks like he's hoping his dad's going to go down.
True.
But Mark Ball, they don't have to put on the stand. So when you're choosing to put him up there, I would hope you're picking someone who you know can say, even though I don't trust him anymore and everything, I still positive he didn't kill his wife and son.
I agree, and yeah, it just didn't feel like it didn't have that resonance in the courtroom. You know, that it wasn't a game changer. That like, wow, this guy, you know, stands up for him. He's really proving doubt. Not at all. If anything, he created more of an idea that somehow Alec could be involved. Now, I've said this before, and I'll say it again. It's hard because I feel like the defense and prosecution are both offering stories that don't fit what happened 100%. So it's hard to say, well, he actually did it the way the prosecution was doing it. But from what I've seen of all of the witnesses, and including defense's witnesses, is that he was involved somehow. I don't know how, but he was definitely involved, you know?
Yeah.
And I think if the jury reaches that conclusion, I think they're going to find guilt, notwithstanding anything else. I think that's really the bottom line, because no one wants to let a murderer get away with murder, and if he's involved, I think that's going to be enough.
Yeah, that's the way these things tend to go down. Doesn't mean it should. No one here is saying that that's the way it should happen. It's simply a matter of the reality of what does happen. So, all right, my brother, James from court. He comes in. Yeah, did you have any final thoughts you wanted to give me?
No, I was just going to say I absolutely agree, and I know people get upset sometimes, but this trial has turned into a trial that's more about character, and I don't think that was...
Yeah, I think we're losing you.
All right, I'm back. It's not that it's right, it's just that's how it's turning into, you know?
Yep. All right. Thank you so much. You guys make sure you check out James from Court. I appreciate that. Feel free. I'll send you a link tomorrow. You can give us your feedback as to what's happening then, and love having you pop in here, brother. All right, yeah, I think we're losing him.
All right.
Yeah. Okay. So you were telling us, Kurt, about your latest vid.
Yeah. So anyways, I released a edited video. I did one this morning on the whole Alec Baldwin, the gun charge being dropped, the gun enhancement being dropped. So I did a edited video that I released this morning on my channel. So if you want to, you can check that out. And I was experimenting with editing and adding a little bit more B-roll to try to make it more visually interesting. So you can let me know if you thought that was working or not. So trying something else in editing style. And then probably... Geez, I don't know when at this point. I was waiting for the audio to be synced. The Supreme Court's having oral argument today
on the 230
in a 230 case, and they had argument yesterday in a 230 case. And if Murdaugh's on the stand tomorrow, then I don't know when I'm going to have time to cover it, because I'm in Vegas this weekend with Nick, and I'm not planning on broadcasting from there. So I might not be able to cover the cases until next week. But at some point in the near future, I'll be covering the 230 cases from Gonzalez versus Google and Twitter versus whomever it was that were argued yesterday and today at the Supreme Court, and trying to go through that entire analysis.
Blackjack, Keno, poker. Which one is your game?
I might do some poker, but I'm so out of practice. I'll just get my ass handed to me.
All right. Well, I'm envious of you. Very, very envious.
Or I'll sit at the sports bar and just bet on the favorite horse to show, and because you can usually do pretty well in that.
So whoever is the favorite horse, you bet on them to win place or show, and you're going to make money.
Yeah, you usually break pretty close to even.
Wow. All right. Betting tips from Uncivil Law. Who knew? All right. Well, I'm gonna get back to the super chats and try and sit here envious of you people finding the warm weather and gambling shores of Las Vegas. Not that there are many shores, but yeah. What is the benefit of the defense thought they would get from this witness? Why even put him on the stand? I don't know, Steph. I don't know, Stephanie. I have the same questions. Defense could argue stay focused on finances to fool jury might be helpful. Yeah, I'm sure they will. I'm sure they will. I'm sure they're going to be saying that the reason you heard so much, the reason this sounded like a financial fraud trial is because there's no evidence he killed anyone. That's almost certainly going to be in their closing. Definitely. Stephen Weiser says, so in essence, you're saying the jury can't keep to the rules and the justice system is broken. I'm saying every justice system is broken.
I'm saying the way that people behave in the real world.
It's not always logic. It's frequently emotion. And you have to deal in that. Right?
Yeah.
Lancelot said, I agree with Joe. This was not a good witness by the defense. The state is just going to throw a bunch of smoke to confuse the jury. Joe, if you're going to call them what they are, you need to get the cage overlay from Rackets. I don't know how he has that set up with the cut cage. He says it's an overlay. I don't know how he set that up. Because he has this whole thing where you can see Riquetta Law thing on his thing. I have it as a background, not in front. He's able to put stuff in
He does it as a overlay. You can do it in StreamYard.
You could do it in StreamYard. I'm trying to figure out here. It's under brand? As an overlay.
Yeah.
Oh, I never tried adding an overlay.
There you go.
I see it here now. I have video clips, logo, theme, brand color.
Yeah, so he just assigns an overlay. It's the same way that he does that copyright cut cage. He just creates an overlay for it.
I just discovered background music here too. Oh my God, you guys are in for a treat. Or probably not. You guys are in for annoyance. Frank says, apparently when defense said they plan to wrap up end of the week, they forgot to account for the state's ability to drag out any and everything. My God, they really can. They're amazing at how they can stretch out anything. Cleo says, watching the trial is like reading Kafka's The Trial. Daniel Gammon says, the more the state focuses on everything other than murder, the more it looks weaker. The more it looks weaker, the weaker the murder case looks. Yeah, I totally agree with you. Push Joe over 100K subscribe today or space lasers are coming. We're trying to develop a new method to shoot from our eyes instead of like from space. So, no. Chandler's HBBQ. Why would you put up anyone from that law firm? I don't know. I don't know. I don't know. It was a bad call. Wikipedia says, do you guys think that he said different things to the defense and now he's throwing him under the bus for revenge or to play innocent for the financial crimes? That would be the best. That would be the best explanation. But I don't know. Who the heck knows what he told the defense he was going to say? There's no way to know. He seems like such an easy to trust guy, doesn't he? That guy looked like a puppy. Like, this poor guy. He was hurt by his own best friend. Like that's how the whole thing. He had so much credibility, and he could be like the shadiest person on earth. None of us know. Lancelot says, "Why on earth would you?" Oh, I got that one. Whoops, sorry about that. Why on earth would you put a witness from a law firm that he stole from as a witness when you know they have to be angry from the theft? Good questions, indeed. Ron, this witness is so boring the internet keeps falling asleep. MS Krim, someone new. She is cute. Okay, all right. Danny Simmons, defense should have hit on how they arrived to the kennels and thought to console Alex, wonder who did it. When they got a call about the shooting, no one believed it. One crime clearly planned by a druggie. They arrived to the kennels, thought to console Alex / wonder who did it. When they got a call about the shooting, no one believed it. One crime clearly planned by a druggie. Yeah. Christopher Violanta, normal 6. This is when the crowd was simping for the new defense counsel. Normal 6 is a South Carolina 8.5.
Yeah, there you go.
That's what she said. You can twist it back the other way. It all goes back to the Kennels video. Alex lies. This is Jeff H, who's really got like a thing about trolling my audience, and you got to explain to me the whole steps thing because I don't understand how the evidence comports. If you really
got trolls, it's good. It means that you're loved. I got a couple trolls that follow me around. It's hilarious.
He's more about trolling the audience than me specifically. I have a few people troll me specifically. He's more about like, Alex guilty, he's going down. Alex guilty, he's going down. And he was saying yesterday, I mean, this is how wrong this guy has been. Yesterday, when the Sutton was on there and talking about how the guy had to be fired too, he's like, this guy is going to get killed, is going to get crushed on cross, and like the witness melted the prosecution on that cross. I mean, it was like there's a puddle where that kid attorney was standing. That's still there in the court. Nick Naylor says a real court actually mentions admiralty law and vices is silent. I thought that was weird also. Professor Logic says the only thing I find relevant is Alex using single-use water bottles in front of him. Clearly, he is a murderer. The environment.
Thunberg is on the jury. You're screwed.
There you go. Rocky Fork says a Rumble rant. Maggie on Facebook at 8:55 and works in Alex's favor. 2 murdered after Alex leaves home. Yeah, that is a really key thing there, that she's on Facebook at 8:55. This is absolutely no way he had time to clean up from these murders. There's zero chance he had any opportunity to clean up these murders. It doesn't make any sense. That's why I can't believe he killed him. That and the lack of motive tells me I don't understand how anyone thinks he killed him. It doesn't make sense to me anymore. Cards 96, retired maritime risk manager here. Cool. All right. Nancy Jennings, after this case, the hide-and-seek suitcase trial will seem like a tragic comedy. Flux! Pants are prison. Hashtag pants are prison. That really works in any setting, that hashtag. British Gridiron Film says, Your Honor, I'd like to qualify Darrell Brooks as an expert in admiralty law and subject matter jurisdiction on these grounds. My Jew roar. No shekels, no peace. Darrell Smith, the guy sounds like he's about to break down in tears. We're talking about now I think that's the new witness. That's the new expert. That's just to stand. I'm an expert for hire, America. There you go. How accurate was his crime scene photographs with him using a bellows camera? He does look really old. He also says this guy needs mutton chops, a top hat, and a visit from the ghosts of Christmas past, present, and future. There's a strong Ebenezer vibe with this guy. Rocky Fork sends a Rumble rant saying, Maggie on Facebook, I covered that, 8:55. Yeah, it does work in Sox. I just want to make sure I got that. Rumble rant. Nicholas Starrow, quite sure he testified to knowingly covering for Alex using company property as his own for years, so why surprised over the escalation? I guess he figured he wouldn't steal from his friends. Maybe. You're asking a good question. Maybe he feels like there's honor among thieves. You're not gonna rob from us. You might rob from other people, but you're robbing from us now. You're robbing from me. It's a good life lesson there. It's a really good life lesson. People tell you who they are. Believe them. Believe them when they tell you who they are. So, and if they're being nicer to you than they're being to others, there's a reason for that. It's because they need you. And when they don't, they'll stop giving you that nicer treatment. Bring the smoke. I know how Jews love brisket. So if you want to learn how to smoke one or cook other delicious food on YouTube and Rumble, thanks, Joe, for the plug. Bring the smoke. Check out Bring the Smoke. There you go. There's your plug. Check out Bring the Smoke. Jimmy Ingle. If the defense doesn't explain the Snapchat video in some shape or form, then he's going to be found guilty. I feel that is what this jury wants to know. He's being charged because of the Snapchat. I think that I think the most beneficial witness to him right now is a very, very, very credible expert about shock and memory, like the impact of shock and memory.
Yeah,
that is
just that the human memory kind of sucks just generally.
Yeah. And then you follow that up with him taking the stand saying like, yeah, you know what? I can't even believe how I forgot that I've been there. I mean, think how embarrassing that is. That's the last time I saw them alive, and mea culpa and embarrassed and whatever and really sorry. But that's what happens with the brain. I really thought that I had no recollection of it. And I guess seeing my own son's head being vaporized by a shotgun. I couldn't process that I was there, that I'd seen that I saw them at that place. I don't think he's gonna admit that he was there when it happened, even though he was. You all know I'm right. Every one of you knows I'm right. Creed M says, do you all agree with Branca's recent take on the cop who smashed Tyler Canara's skull? In my mind, it's just another case of Branca S-ing off cops. I didn't see his take on that, so I don't know. New member Lynn Gilliam. Welcome to the following, Lynn. Welcome aboard. I wish for you nothing but champagne wishes and caviar dreams. Check that. Nice. Lucky Sarita, how would each of you explain the kennel lie? So,
memory sucks. Memory sucks generally, and then traumatic events, we're going to fuck up your memory even more. Well, first of all, let's just say it's a mistake. For it to be a lie, it has to be knowing. He has to be knowingly false. So if it's a lie, then that's one thing. So first of all, let's just say it's an inconsistency. How do you explain the inconsistency? Human memory generally sucks, and traumatic memory sucks even more. And it's not very hard to bring this to your attention. Like if you particularly things that are like everyday and normal to you, tend to be filtered out. The brain tends to only pay attention to things that are normal. And so one way to explain it is, well, he forgot, because for him, going to the kennel or not is just a normal everyday event. So it's nothing that particularly registered.
That's crappy. But I'll tell the reason it's crappy is because literally it's the last time he saw his wife and son.
Yes, but it's not significant till it is.
Yeah, but
so
after
the moment it
dead,
happened,
after they're dead, after they're dead, that 3 months later, he doesn't remember the last time he saw his wife and son. He has to blame that on like the trauma of shock, and wiping that entire visit to the kennels from his memory. That I've since learned that the reason my brain probably did that is because I couldn't process that the place that I found their bodies, that's the last place that I saw them. So yeah. the human brain is a weird thing, and it's embarrassing for me, and it's horrific to me as I think back. That
people forget things. They manufacture memories. The ability to implant memories on people, and for them to remember things that never happened. It's really scary how pliable memory is.
Yeah, but if he takes the stand, he's going to have to explain that. I mean, she's correct about that. He's going to have to give
memory
some
expert
sort of
will go a long way,
and that's
so
why
memory generally sucks. Eyewitness testimony generally sucks. People's perceptions suck. Their ability to recall sucks, and then how traumatic episodes screw with all that on top of it.
Yeah, but
that's basically how you deal with it.
He can't be the one to testify that memories in general suck, because that's
no,
he's
not. Expertise. He needs an expert. He needs someone with it. He needs someone with an MD to explain something I can tell you.
Yeah,
but he needs someone with an MD to do it.
Yeah. Rocky Fork says, with all the guns that Alex had, he would have killed or be killed by the perps. Loved too much to just drive away cool and calm. With all the guns Alex had, if they would have been killed or be killed by the perps, if they're the mob and they threaten that they're going to kill Buster next, it's very nice to say he'd be such a tough guy, but I think he would have wet himself. I think if he stopped in his house, it was to change his shorts.
Yeah, the SM58 is treating you well there, by the way. Your
it's
microphone?
Better? Oh, thanks.
I like it. It's a good microphone.
It's actually my old microphone, but my other one, I have a port issue with it, so it's probably going to take me a couple of weeks to get that fixed, because it's still on the
man, that's a good microphone.
Yeah, I like the other one better. The SM7, the Shure V7. But
yeah, that's a good one too.
Yeah. I know a guy says, I think Alex knows he's going to jail for the financial crimes, so he took on the murder rap for Buster. You think Buster killed him? What's his motive? Why? And Buster was in another city. Supposedly he spent 2 hours driving there.
Another city ordering the cartel hit because he's the cartel boss.
I don't know why everyone thinks that Buster's related to this whole thing. Mag's Design says, I think the state missed their mark. Why not research all the drug activity that he and Cousin Eddie were involved in? I tend to believe this was a drug-related crime. When I say that, people call me crazy, but you know, I have a minor tweak on what everyone else says. Everyone else saying it's a mob hit. I'm saying it's a mob hit plus he was there, and all of a sudden I'm insane. Despite there is 280 steps there, and video that shows him at the kennel. To me, that's more forensic evidence than people who think he wasn't there. Kyle Cowan says, didn't one of you all say Maggie was on Facebook at 2156? Yes, we did. We did. Which means that she would have been dead. She probably would have died within the next 60 seconds after that. A generic count, cut it out with the weird Grisham take, Joe.
That's not possible. 956.
Not 2056 is probably what he meant.
Yeah.
856, yeah.
Yeah, I was like, that's not possible.
Cut it out with the weird Grisham take, Joe. It's not Grisham. We know he's by the kennels within like 10 minutes of them being dead. And there is a recording of his steps going 280 steps. So when did that happen? And tell me why we shouldn't think that actually happened.
Not for nothing. But
between 902 and 906. Why should we not believe that happened?
What evidence excludes them being killed at 9:55?
It's the lack of phone use. That's the only reason. That's why they kept hitting on how much he uses his phone.
Yeah.
So
other than that,
yeah,
they're such phone addicts that okay.
And neither of them use their phone. A generic count, cut it out. Sorry. I think the biggest issue with your theory is he is now at his mom's house just after the murders and not visibly agitated, according to the caretaker. I missed the caretaker's testimony. Did you see the caretaker's testimony? Did she say he was not visibly? She said he was not visibly agitated.
Yeah, yeah, that was basically testimony.
That's huge.
Yeah,
that's really huge.
Yep.
I missed that testimony. Now I gotta check that out. DCV Titan says, why would HD said when it could just as likely be a she? And didn't he point out that it could have been over the boating accident? Most people tend to associate double murder with a dude. I think that's human nature, just assume it's a dude. But yeah, it could be a woman for sure. Also says, big hole in your theory. You think that after witnessing the murders, he goes to the mother and doesn't break down in front of her and the nurse? He could have been in fear also. But I did not know about the nurse.
Buster's being threatened. He does have a strong motivation to keep it together.
I did not know about the nurse. So I want to reassess that in my brain. Dana Church says, research the Lindemuth bankruptcy. How he got away with 170 counts of bankruptcy fraud. He could walk on all charges. Joe is nuts, by the way. He ratted out his dealer ASAP. He found them dead. The girl's mom did it with her son. Why would you say, just because he rats out a dealer doesn't mean he would rat out a mob if the mob is threatening Buster?
Yeah.
Look, he was doing something with $50,000 a week on drugs, and he wasn't snorting and all. So that means there probably was money laundering that was happening there somewhere. And there's millions of dollars that just went missing. Scazzy theory. Alex took Maggie's phone with a plan to answer as her showing her as alive while he was leaving, but he got scared by face recognition and tossed the phone. Okay. I like the creativity of this. I like the creativity here. I'm still left wondering. I didn't think they're coming back now. I'm still left wondering why her phone's showing 54 steps while his is showing 280. And no one in the state can answer that. And it's a huge, huge hole in all these claims that Alex did this. To me, it's forensic evidence which directly conflicts everything we understand about this case. Let me get us back into trial mode because it's the movie's starting.
Jury is present.
All right, thank you. You may proceed.
Possible motive here. He tells the wife about the stealing, knowing it's coming out.
So, Mr.
She
Xerxes,
threatens to
before we
leave
broke
him,
for
and he
lunch, we were
snaps.
talking about
Pulls the wrong
how
place, wrong
one would
time.
process.
Extremely
I
speculative.
showed a floor that
Even the state doesn't believe that one.
Chemical, I can't remember what the name of it is.
Yes, sir.
Which would bring out previously invisible imprints of feet. You could do the same thing for fingerprints.
Yes, sir. Or it would enhance what you can see already.
I'm sorry?
It would enhance what you could see already.
All right. But it would also bring out things that you can't see.
Yes.
Okay, let's talk a little bit about crime scene processing. Let me We could bring the video up, please, and y'all need to cover your screens, please. And that TV's off? Okay.
Every time I see that guy there with the mullet haircut from the prosecution team, he's now sitting in the first row.
I think we want to
with
do
the dark beard and glasses.
Stage number 1. Okay, we'll start that, please.
I think of the Hobbit from The Office.
Can you play that for us, please?
I mentioned this last night.
This side of it. You got right here, the opposite. Well, the desk over there. Actually, hold on. Some people just won't do it.
Fire rescue might have some more sheets we can steal.
That's right. It shouldn't be.
Okay, so you recognize that as Paul Murdaugh's body covered by a sheet?
Yes, sir.
Okay. We just saw some officers apparently taking that sheet off. This officer in particular stepped inside the feed room.
Objection.
Has that officer stepped inside the feed room?
The one on the extreme right of the image, yes.
Okay.
Oh, we're going to get this lawyer cross-examining.
Did you notice any protective covering on their feet?
No, sir.
And I call them booties. What do you call them?
Shoe cots or booties.
What?
Shoe cots or booties.
Or booties, okay. And is that, what if anything is, under the procedures you understand, is the purpose of those?
It's to keep your shoes from contaminating the scene with any residue that may be on them. And secondly, also not to allow the imprint pattern from your footwear to contaminate the scene.
Okay. Is that procedure that you teach? Is that procedure that's accepted? Is that, what is that?
It's standard operating procedure.
Standard operating procedure around the world?
It should be, yes.
Okay. Now, go forward with it, please.
There is his law firm right there.
This is court audio, not my issue.
You can see that officer has 2 feet inside the feed room?
Yes, sir.
No booties?
Correct.
Okay, keep going.
I don't think they want to show us this.
Not unless it's the shortest room the blackout's ever been made. I don't think he put that phone down.
I haven't asked the dad about the phone, but dad did say he came over and checked their pulses. Beyond that, I don't know what else he may have done.
He had a shotgun.
He did have a shotgun with him, and I have secured that in my vehicle.
Yeah, but it's set up with shot against his one, although it's still a hit where my wallet brings like it's not good. Yeah, but that's he didn't get his head off. So that is done.
Let's go to McDowell body cam, stage 6. And that was, for the record, Green's body cam, stage 1.
There is parts next to him there.
All I want to do is if I can, get where you can lift it on each corner. Lift it that way. You go right here to the office. So the desk over there. Yeah. All I want you to do.
Fire rescue might have some more sheets.
That's okay. That's all right. It shouldn't be anybody fire rescue.
There is his
I don't know. It's a good question.
Is that the same shot, but shot from inside the feed room?
It appears to be, yes.
Okay, thank you. You can turn that off. So let me ask you a couple questions about what we've just seen.
Yes, sir.
You indicated just a moment ago that they should have had booties on, and you've explained why.
As a basic precaution so that they don't contaminate the scene, and also the scene doesn't contaminate them.
Let's talk about that sheet that was on Paul's body.
Yes, sir.
Tell us first, would you use a sheet to cover a body
Depends on the circumstance.
under
If-
these circumstances?
Under these, in that the victim is not in a public access area,
Right.
possibly. If there were other signs of contamination, in the last video, you could see raindrops coming down. But instead of a porous sheet, I'd probably use a tarp of some sort.
Something that's not absorbent?
Correct. And as a last resort.
And why would you not want to use something that was absorbent?
Well, one, because it absorbs, but it absorbs both ways. The water hitting on the sheet would go into the matrix of the material, and anything that's under it, or in this case on Paul's body, could also be absorbed up into the sheet, whether it's blood or other biological fluids that might be present.
And if you had used a sheet or any other material, would you, once you've done using it, would you discard it, or would you save it and have it analyzed, and why?
It should be preserved, and it should go with the remains, right, presumably to the medical examiner's office, and then be turned over to whoever the investigating agencies are.
This is an
right, for
effective way
further
of showing
analysis.
SLED
And
incompetence.
what would you be looking for?
Because
You
there's
don't need
physical
Mark Paul to
contact
do this.
between the sheet and the victim's
There's gonna be a question
body,
about financial
any
crimes.
trace evidence such as hairs, fibers, or
This
other
is good.
materials that may be loose could be picked up, especially when it becomes moist. Right? It now becomes like a sponge and actually picks things up and takes it away. You don't know what's not there.
So, let me understand this. If somebody had walked by, let's say the assailant, had walked by that body, and we're all losing hair all the time, some of us more than others, but if you run your hand through your hair, you'll lose hairs, right?
Yes, sir.
And if the assailant walked by there, and it looks like he was, the assailant, I think everyone agrees, was relatively close on that second shot anyway.
Objection.
In a
Objection is sustained.
In a hypothetical, if the assailant was close to somebody and walked by them, is there a possibility, probability, that hair or other trace evidence from the assailant would end up under that sheet, in between the sheet and Paul's body?
It's possible, yes.
Okay. Now, with the possibility, is that the reason you say save the sheet and have it processed?
Yes, sir.
Okay, let's also talk about, well, first of all, you've read all the records in this case. You've looked at all the evidence that was taken from the scene. You find any record that that sheet was saved?
I saw no indication of it, no, sir.
Okay, or processed?
Correct.
Paul's clothes. He was clothed. What should be done with those?
Again, once they're removed from the victim, whether it's done at the medical examiner's office or in another location, again, they should be submitted to the laboratory for analysis. And again, it would be trace transfer evidence, hairs, fibers, or other materials, as well as any of the wound patterns that would appear on the outer garments themselves. Looking for things like gunshot residue, pattern analysis. It would be very helpful.
Do you see any evidence in any report of those clothes being preserved, let alone examined?
With the documents I've been provided, I have not seen any.
Okay. Now, you just recommended doing some things in your 30 years of doing crime scene, 20?
40.
Okay, I'm sorry, I don't want to exaggerate. 20 years of doing crime scene work, going to crime scenes and preserving evidence. Are these the kinds of things, or these things that you've done on your crime scenes in the past?
Depends on what stage the crime scene is being examined. If it's at the very end, you finished all your documentation, you finished your evidence identification, you finished all your photography, your sketch maps, as long as there's not an exigency, an emergency that's present, and i.e. that would be life safety. If it's been determined, or the presumption of death, in this case from both victims, you can slow the investigation down, right? There's no longer an emergency to rush through everything, and you take everything through a very systematic approach.
Have you
try
done
to be
that?
as detailed as possible.
Have you done that in the past?
Yes, sir.
And if this had been your crime scene, would you have saved that sheet and saved its clothes?
Definitely.
I'm sorry?
Definitely.
Okay. Now, let's talk about Maggie, and I'm just going to cut to the chase on this. Maggie had the same kind of sheet over. Would you have done the same thing?
Yes, sir.
You would have saved the sheet, sent it for analysis, saved her clothes, sent it for analysis.
Bagging and tagging each thing separately so there's no cross-contamination between the items.
Each item bagged individually so there's no cross-contamination.
Correct.
Was that done in her case?
Not to the best of my knowledge.
Okay. Now, let's talk a little bit about let me see, I'm going to try to expedite this a little bit. Okay, let's go to the Elmo, please.
Oh.
Tell me what's the number on that? States 39. This is States 39 for the record. Now, you understand, what do you understand this to be?
It's a photograph, and it's from a report from Agent Worley from SLED.
This is of the feed room floor?
Yes, sir, it is.
Okay, now, earlier we saw you spray some things on a murder scene in New York. I'm going to get to that in just a second. Have you, I think Agent Worley identified or testified that in her opinion, based on her experience in footwear, that Paul's shoes were in here somewhere. Is that correct?
A pattern similar to the shoes that Paul was wearing is present, yes.
Okay. Now, did she also indicate that she also found patterns consistent with one of the law enforcement officer's shoes?
Yes, sir, she did.
That may very well have been the guy we saw step into the feed room, right?
Possible.
Okay. Now, if you had come on this crime scene and saw this, would you felt compelled to do more that we've heard from Agent Worley?
For several reasons, yes.
Okay. First of all, what would you have done and why would you have done it?
I wouldn't have walked into the room.
Okay.
Right?
Okay.
You stand back, you make your observations, and you determine a course of action. And everything is done in a sequence at a crime scene. Right? Again, the first part is viewing it, using a visual examination. Once you've identified areas of interest, then you determine the methodology that you're going to use to either collect, seize, document, right, the type of evidence that might be there.
So what would you have done? If you looked in the door and you see this, what do you do?
Later, brother.
I would have started from the doorway and worked towards the back of the room, in that it's a small enclosed area. So you work from front to back.
When you say work from front to back, what do you mean work? What would you do is right inside the door?
This is good
or
because
right
it's
outside
spelling
the door?
out process.
You would start
to the
documenting
jury.
close-ups and
Clinically, coldly,
yes, sir,
assessing.
that there's an imprint just to the right of the door.
What a terrible job SLED did. And
That
how
would be my
obvious
first
it is that
area
they
to
did
do
this
detailed photography and imaging, right, for later comparison.
And as you work your way back, are you careful not to step anywhere? You're wearing booties? What are you doing?
You're wearing the shoe cots or booties. In addition to that, we would usually build a bridge. Basically take two 2x4s and lay them in an area where there were no imprints, put a piece of plywood and actually stand on that so that you're not standing on the surface that the imprints are on. There are commercial products that are available that look like Tupperware
Every
boxes.
teenager who's
that you
seen
can
a
literally
crime
stand
drama
on and do the
knows
same
you don't
thing. So it
contaminate the
preserves
scene.
and protects the area that you're interested
So why
in
wouldn't you
doing
put
the
booties
detailed
on?
work that you may be able to get more
I know the
evidentiary
word sounds
information
silly.
from.
You still
Once
do
you've
it.
done those photographs all the way back, what do you do next?
In this case, once the initial photographs were taken, determine if chemical processing is necessary, or could I seize the item? In this case, it appears that these imprints are on a concrete base. It's a little difficult to take the entire concrete foundation and remove it, but it has been done before. In this case, again, now we work from the back towards the front, using some type of enhancement reagent to try to increase the amount of detail and the
that-
clarity.
That agent is what you sprayed in New York on the floor that brought
That
up
would be
those-
one of them, yes.
Those images that aren't visible to the naked eye.
Even if some of the image is visible, it can give you additional detail in the periphery or other area where there's just trace amounts.
Okay. And you work your way to the front, taking pictures as you spray?
Yes, sir.
Okay. Now, once you've finished that, are you done with the floor?
No, sir.
What's now? What do you do now?
You want to take overviews to show the work that you have done, right, and show any modifications that you made to the scene. and again, make the determination, can I take the area that that prints on with me? If it was a tile floor, we could pull the tiles up. But again, because it's on concrete, we'd have to rely on the documentation.
And these are still 90-degree straight down shots?
That would be the analysis part. You would still take general photographs on an angle showing the relationship.
But as you worked your way up and worked your way back, those would be vertical, I mean...
Yes, sir.
Okay.
Those
And
would be
then you're taking general photos from different angles?
Yes, sir.
Okay, then what?
With digital, you would make sure that the photos came out, that you had an image captured, and that it was sufficient for whoever needs.
Okay, now, let's...
You would also take a sample of the blood from those areas for later typing or DNA analysis, should it be necessary.
Did you find any evidence that they took a sample of this blood and analyzed it?
No, sir.
So we surmise it's Paul's blood, but it could be somebody else's blood there too?
Possible.
And the only way you could rule that out is take samples?
Is to take a sample, do an analysis, and try to identify the donor.
I'm with you, Tyler.
And that was never done?
To the best of my knowledge, no, sir.
Okay. So then we have a number of surfaces. Let me have them put up number 26, stage 26. Okay, so, and just to cut to the chase, this is the door to the, well, I could see it a minute ago. There you
Don't
go.
worry, Law
That's
and
the
Crime.
door
You don't
the
have to
feed
show
room.
us any of
Yes,
this
sir,
stuff.
the door frame on the right, door on
We don't
the
need to
left.
see
Did
it.
you see any evidence that
We'll
they
take their word
dusted,
for it.
not dusted, that's old-timey language, that they processed that door or any other surface in the feed room for fingerprints?
Not to the best of my knowledge.
Now tell the jury, please, in a summary fashion, what you would have done. Well, first of all, do you have to see a fingerprint before you lift it or whatever you call that?
No, sir.
So how do you determine whether or not they're fingerprints you can't see? What do you do?
The base processing methods, again, depend on what technologies the agency has. The simplest and the oldest is dusting with contrasting color fingerprint powder and a brush by just applying it to the surface and dusting it through. If a finger or palm or foot or toe has come in contact with those areas, the secretions from the ridge detail, right, leaves a pattern behind. Those latent fingerprints now become patent or visible. They can be lifted, they can be photographed. They also help tell you what was touched and how things were handled. So it would help in a
I
reconstruction
did not realize
as well.
that patent
That's
was
the
an
oldest
obsolete,
technology
but
there
it
is, though, right?
Good
The
call.
throwing dust down, fingerprint dust?
At a crime scene, yeah.
Okay. I'm not talking about going into the lab and using
No.
super glue or whatever. Say, at the crime scene.
Yes, sir.
What is the more modern? Do you use lights or do you use chemicals? What do you do at the scene?
The first method would be to use an alternate light source.
What does that mean?
It could be
Alternate light
anything
source.
from a flashlight held at an oblique angle to see if you can find any smudges or smears. More sophisticated portable laser units, right? Laser is an acronym for a light source that produces a wavelength of light at a very specific number. The more common today are called the alternate light sources. These are various colored lights, and usually they're light-emitting diodes or LEDs at different wavelengths of light. So in concert with a pair of glasses that are filtered, you can get a shift and you may be able to pick up fluorescence or luminescence. One of the problems is that our secretions, the oils, the fats, and the salts, don't reflect. They don't give off light. So you would need to process those, if you discovered one, with some type of chemical staining that would act as a fluorescent. And essentially, it would be similar to my watch, that when it's dark, it glows.
So are these new technologies or, I mean, is something space age stuff or has it been around for a while?
The light source technology has become simpler and simpler. It's now battery powered. Literally, it's a very simplified flashlight. There are also very sophisticated ones. The technology's been around for about 25, almost 30 years.
Okay, and not uncommon to be available to law enforcement labs?
No, sir. I would expect every laboratory to have some type of alternate light source.
Okay,
And
now-
the oldest traditional is ultraviolet.
Ultraviolet's a black light?
Yes, sir.
Okay, so simple mobile black light, you could look at.
Scanning the surface to see if it gives you any information.
Okay. And if you didn't use the powder or the light, what else? What else could you do?
There's chemical fuming stains that you can use, and the simplest is super glue or cyanoacrylic acetate ester.
Can you do that on a scene?
With a door like that, if I chose to do that, literally you could bag the entire area, place a super glue packet or super glue with an accelerant in it inside the chamber, now inside the plastic bag, and fume the entire door. The other would be to take the door with you and process it
But that
later.
takes a while, doesn't it? The super glue process?
Not necessarily. Okay, half hour, 25 minutes.
Okay. And could you spray it with something else?
Again, the same reagents that we used on the footprints to make those visible, where there was limited amounts of blood-like material, could also be used there.
And you could do that on the door, you could do that on the door frame, you could do that on any object, the methods you've talked about, on any object, literally, in that room.
Yes, sir.
Okay. Did you see any evidence of any fingerprints, any effort to lift fingerprints, when I say lift, to identify the fingerprints in that room or anywhere else on the property that night?
Again, not to the best of my knowledge.
And that's indicative that they're not ever really looking for other suspects. Because if you know Alex's fingerprints are going to be there. So they never really gave any effort to finding any other person who might have done this.
Yeah,
How
it was
about
just
put
sloppy,
stage
sloppy work.
195 up, please?
Yep. And this is not a witness who you're at risk of him talking about terrible financial crimes and what a horrible person Alec is in other capacities.
I know I missed before they got back, but
Okay,
was that
maybe
more of
see if
this,
we
or
can
did they just get back
turn
on?
that in a little bit. There we go. Now, how about make it closer?
Like, how long ago did you guys start
the
back
other
up?
Okay.
Say about
Tell me what this
15,
is,
20
please.
minutes ago.
Oh, okay.
It appears to be a photograph of multiple
He's basically been
footwear
documenting
impressions,
Sled's incompetence.
three-dimensional renderings of a soft surface.
Very effectively.
Okay,
He
and this
seems
picture
very
was taken,
knowledgeable.
do you remember who took it?
No, sir, I don't.
Okay. I may have a document here that'll help you with that. I can't remember. Let me suggest this just to cut the chase. You remember reading a statement concerning Solicitor Duffy Stone?
Yes, sir.
Is that picture taken by the solicitor?
I couldn't remember his name. I believe so.
Yes, okay. And it was taken on the night of June 7th?
That's the indication in the letter.
Okay. So tell me what we're looking at here.
Again, it's a soft soiled surface. Someone or some people have been walking through that area multiple times.
And did you attempt to identify any of those footprints by comparing them?
Just by looking at the basic pattern type, the flat surface ones that have could be consistent with these sandals that Miss Murdaugh
Mag Murdaugh was wearing. What about these other shoes?
There were no exemplars that I was made aware of taken by SLED to do a comparison or to try to eliminate them.
Could you tell whether Maggie's shoes were walking over the other footprints or were the other footprints walking over her imprints?
If those are from Maggie's sandals, they're on top of the other ones. But they're also going in two directions, and some are superimposed over the other.
When you say, okay, let me ask the question this way. Are Maggie's imprints on top of the other imprints, or are they on top of hers?
In the area that they appear, yes.
I'm sorry?
And in the area in which they appeared, the answer is yes.
Yes.
Yes, what? Which one's on top
They
of
were.
which?
They were made there after, right? The heavy
Are they on
mud-
top of Maggie's?
No, Maggie's are on top.
Okay, so the other imprints were there and Maggie walked on top of them?
Apparently, yes.
Okay. Now, let me see if I can save us some time here. Well, you have also reviewed the SWED procedures manual, correct? Parts of it.
In brief, yes, sir.
Yes, sir. Okay, and let me ask you this. There's certain certifications different labs receive, correct?
Yes, sir.
And the certification SWED receives for their lab, there's an acronym?
The current acronym is ANAB, A-N-A-B.
Okay.
It's the American Board of A-N-A Accreditation. I forget the last word.
Okay.
But it's a pickup from an older accreditation program that was run under the ASCLAB program, the American Society of Crime Lab Directive.
And tell me just briefly how that accreditation program works.
A laboratory or a crime scene unit can apply to this organization for this national, actually it's international, accreditation, which means that they're meeting a minimum criteria and minimum expectations from the parent body. Right? It's a formal recognition, technically, that you're doing a good job.
Oh, tell me
or
that.
at least your procedures.
Tell me
are
they
well
couldn't
written.
meet standards.
The
Tell me they
operation
couldn't
manual
meet
when I started
standards.
reviewing was very thorough, was very well written, very easy to understand. But it involves everything from how evidence is processed in the agency, what the responsibilities of the different people are, including the director of the laboratory, the basic procedures and operation of the lab itself, or the crime scene unit, if it's involved in a police department that may not have a formal laboratory. The accreditation is well recognized across the country, and
so you're
He's going to tell me that.
They certify that you're meeting the standards, basically.
that you're following the guidelines that you've put, and your guidelines meet a minimum standard, yes.
Okay. So, and have you ever performed these analysis? Have you ever been appointed or assigned by this group to do this?
Yes, sir.
To
Under
look at,
ASCLD, the precursor to ANAB, I was also one of their auditors, and we would go to different laboratories. In fact, I did the Columbia Sheriff's Department a number of years ago.
Richland County, I'm sorry,
Yes,
Sheriff's
sir.
Department.
I forget.
So,
I
you're
think
very
you're right,
familiar
Joe.
with what the standards are.
Yes, sir.
Yeah, he's about to bury SLED
In
as an
reviewing
entity and
what
say they
this
suck.
file and these pictures and documents.
He didn't get
was
in-house
SLED
training,
following
though,
the
so I don't know if we can trust him.
Procedures that are required by that certification on this case.
What I had for procedures were their operation manual, how to run the laboratory and the functionalities. There's also a second set of documents called the technical documents for each one of the sections that would further in detail give you the information of how to do things. And as an example, recipes for chemical processing, right? How to put the chemicals together, how to apply them.
Well, they didn't apply any chemicals here.
Again, I didn't see those technical
According to the
procedures.
records, okay. I guess what I'm saying is, and maybe the easiest way to just get that down to the generic, did they do what they were supposed to do under these standards at this crime scene for most things? Maybe they did some things that we're not aware of, but for instance, you looked at a number of foot impressions, correct?
Yes, sir.
You're required to do the 90 degree and then from different directions, right?
In a best case scenario, yes.
Did you see any footwear or foot impression that was taken that way?
No,
Why am I
sir.
losing
Okay,
100 people
all of
a
them were
minute?
from an angle?
Yes, sir.
Every 10
And
seconds,
once
I'm
you
losing
do
another 100
that,
people.
are they suitable? I think we even
weird's
saw,
Can't leave the witness.
any of those photographs,
YouTube is
No.
being weird.
which of any of those photographs met
Yeah, it is.
the standards
Don't know.
required to do?
Went from 6,900 to
a
6,100
comparison.
in 60 seconds and back to 65.
None of the ones from around the victims or in the small shed area.
It's all those 5'2" hitmen.
How many, if any, had that 90 degree on a tripod, if you will, shot? How many?
None of them.
Okay. And as a result of that, were any of them suitable for forensic comparison?
Maybe this is right.
They were suitable for pattern identification, the gross pattern, but not as far as the detailed individualizing accidental characteristic that might be present.
Well, welcome back.
Oh my gosh.
Based on the reports we have, what effort, if any,
Blowing
was
them
made
out.
to take fingerprints at the scene?
None that I observed.
Okay. Does that conduct, either for the footprints or the fingerprints, meet the standards that you use or anybody else is using when they try to evaluate?
Objection.
I'm sorry, I don't understand the objection.
Anybody else uses objection.
Any other department uses, any agency uses, any evaluating agency uses.
Let's get ticky-tacky because I don't like how this
There
is
was
going.
much more work that could have been done.
Okay.
Ooh.
Did they do a terrible job here? He's an expert, I can ask an opinion.
I don't know what their limitations were, and I don't know what the training of the people doing the crime scene processing was. So
I'm not asking you the limitations. Looking at it, did they do a terrible job here? Did they do a less, terrible is the wrong word. Let me get it more scientific. An adequate job to show the absence of, at the minimum, the absence of any other evidence. They do an adequate job to
I don't
eliminate.
believe so.
What?
I don't believe so.
Okay. And that's your expert opinion?
Correct.
Okay.
That much more could have been done.
Okay. And much more being done might have uncovered additional evidence that would have exculpated Alex Murdaugh, helped prove he's innocent, correct?
Objection.
The basis for the objection.
Speculation.
In response.
Your Honor, it's what, I mean, the key here is the absence of evidence. And certainly the absence of evidence, if there was evidence they could have uncovered that they'd done this process right, it would have helped at the minimum prove there was another person that did this crime.
Speaking response, if you have one.
He's testifying in addition to speculation.
Well, he is testifying.
The objection is sustained.
Thank
means
you
you're
for
testifying.
indulgence. One moment.
I think he was okay. He wanted to speak out that response. He's like, look,
Yeah.
I want the jury to know.
Yes. he
That,
wants
when they
training
say
on-
speaking response, what they mean is you're basically getting up here and preaching to the jury what
Yeah.
you want them to hear, rather than like raising a valid legal argument. And that's true, and that's what he wanted to do.
Yeah.
he's like, I want them to know where we're going with this, and that is
Cross-examination.
we would know who the real killer is if they actually did their job.
I love the whole. Well, I don't know what their capabilities are. Like, this is a state level law enforcement organization. They should have all the capabilities.
Yeah.
And it sounds like they're a bunch of hillbillies with cell phones. Flip phones.
This expert witness has the good fortune of being crossed by Jerry Seinfeld's dad here, Morty.
Yeah. Yeah, he doesn't. Also, he sounds really good now. At first, he sounded like Eeyore. Like, well, I guess. And I was
Yeah.
the police officer, and then I hurt my knee.
Good afternoon.
Good afternoon, sir.
Wouldn't you have loved to have been
You're not alone,
Laura
Siege.
Rutland?
I'm not sure who Laura Rutland is.
You don't know who Laura Rutland is?
No, sir.
Laura Rutland is. It's repetitive.
Asked and answered.
Mr. Harpootlian.
Are you in love with Laura
Mr.
Rutland?
Harpootlian asked you if you, and maybe I think he told you, you had read all the records in this case, and you said yes. Remember?
No, sir. I've been qualifying that each time he stated it.
I'm sorry. Do what?
I have been qualifying that question each time he said that.
Well,
The records that were made available to me,
okay.
the entire case jacket was not made available.
So tell these folks what was made available to you.
Photographs from the coroner's office that were taken apparently by a photographer representing them at the scene. Photographs, I believe, were taken by SLED or an investigative agency. Later, I was the recipient of 4 images, now that I know were taken by the state, well, we call them state's attorneys, district attorney. Copies of the autopsy report, some of SLED's investigative reports, such as the fingerprint section, which actually also did the footwear the footwear examinations. let's see. I was given access to the operations manual for SLED, right, and the letter that I just referred to as far as the origin of some of the photographs.
So you have not read all the records in this case?
Correct.
And you don't know who Laura Rutland is?
No, sir, I don't.
He should respond, is she one of the idiots?
Would it be important for somebody, well, let me ask you this much. When did you get all that, the reports and the pictures from, when did you receive those in your possession?
Some of them as long as 2 months ago, 3 months ago, others today.
And I spent the weekend looking through some of your background.
Yes, sir.
You provide reports in a lot of cases, don't you?
Yes, sir, I do.
Written reports?
Yes, sir.
What you do, what your findings were, correct?
Yes, sir.
And in fact, you do that in most cases, don't you?
Yes, sir.
Did you do a report in this case?
It was not requested.
Okay, well, so are you taking notes and are you just doing all that from memory up there?
Testimony so far has been more about procedural issues and the specifics of things that I've already reviewed.
I understand that, but that wouldn't answer my question respectfully. Have you done a report for yourself?
Do I have notes that I was taking? Yes. Do I
You
have
have
copies
those?
do I have them with me?
Yes, sir.
Strictly what's on my computer,
You going to provide those to me?
if you wish.
Entitled to reports, not his notes. He's not entitled to Brady. He's not entitled to anything but a report under Rule 5.
Yeah.
And there is no such thing.
He just said if you wish. He just told me I could
I
have
didn't
them.
ask for argument. The objection's overruled.
You
What?
said I can look at them?
They're not physically here, but whatever I have. at
No,
another
no, stop.
location,
That's
you're
not your
welcome to.
job. You don't get
You
to
said
do
you had them
that.
on your computer.
Not all the handwritten notes, right? Any of the documentation I was given was by virtue of digital
That
copies.
is, bro, that you don't
have
get to do
something on
that.
your computer up there. You actually motioned toward it.
Please?
You have some on your computer up there. You
Not the
motioned
actual
toward it.
notes, no. I have the actual documents I received to review. The handwritten notes or any of the notations on images or photographs are at another location.
When did you prepare? We got the PowerPoint last night about 10 o'clock. When did you prepare that?
Which one?
Was there more than one?
There were two.
Where's the other one?
They were both shown.
Those were two PowerPoints?
There were two separate ones, yes. I take it back. I'm mistaken.
You're what? What'd you just say?
I said I was mistaken.
Okay.
There was one PowerPoint. There were two sections to it.
And when did you provide that?
Probably a week ago.
And you just said you were mistaken. You have made mistakes in your life, haven't
Yes, sir. I have an eraser on my pencil.
you? And
So sled techs can make mistakes.
I'm old school. You're old school. And I don't mean that bad.
Thank you.
And when you were around investigating crime scene years ago, you didn't wear booties every time you were on a crime scene.
This is a double
When
murder.
I started doing crime scenes, they weren't part of the equipment.
So
As
my-
technology has come along, the fear of contamination, they become standard operating procedures.
But you have not always wore foot protection when you were on a crime scene, have you?
Going back 20, 30, 40 years ago, no, sir.
And you made mistakes before.
As everyone in this room, yes.
Yes, sir.
Wow. That's his best.
Well, as you just did a minute ago, too.
Everyone
Can I
makes
pull up
mistakes.
one, whoever's. do you have
Yeah,
that?
sled made a ton of mistakes. He should have said that.
Would you pull up something for me?
I've never made like 40 mistakes in one case.
195, please.
Yes.
If you're not, if I can't.
Well, I'm sure Poon's going to come back with that.
This 195.
But no, asking for those notes, that guy does not have the authority to give out notes and offers. That he has a client. His client's the only one who can release that.
Yeah.
That's a problem. That he should not be offering that crap up. And I'm sure his notes are going to say, "Oh my God, these yokels have no idea what they're doing."
Now, you remember a minute ago when Mr. Harpootlian asked you about states 195?
Yes, sir.
And it's important when these footprints were put on here, isn't it?
Yes, sir.
And you know who first saw those footprints?
No, sir.
You don't, that's right. It's Laura Rutledge to you to come in, and you're basically second guessing.
Oh, we're getting footprints.
The Colleton County Sheriff's Department, the South Carolina Law Enforcement Division. Well, you're being paid to come in and say they did a bad job, aren't you?
I even qualified that answer. Depending on the limitations of their skill sets, depending on the limitations of
They
equipment that they
naturally
have and their training, they may have done the best job they could.
But they still suck.
But you're second guessing the Colleton County Sheriff's Department and SLED and saying they did a bad job, didn't you?
With that particular image,
Well, no, you've said it about the whole thing.
Have you finished your answer? I'm sorry.
Go ahead, I'm sorry.
are you referring to this image or the
Right now,
entire?
okay, yes, sir.
As far as that picture goes, it's a good general overview documentation of an area without additional photographs, which I know there are. There were 4 in the series, if I'm not mistaken. Right? It does show this area in concert with a portion of the crime scene. That can be equated back to one of the diagrams that was prepared. This particular picture is a medium close-up showing a particular area, as I tried to explain with the photography, showing multiple images and how they relate to one another. The other photograph would show how it relates to the scene. The part that's missing are the macro or the close-up photographs showing the detail of the images, so that should a pair of shoes or article of footwear be available, they could then be directly compared and analyzed and either included or excluded from consideration in the case.
And if you had a witness, let me just ask, if you're giving an opinion up here and evaluating the crime scene, wouldn't you want to know if there was a witness who saw this image when they were just the sandals on it? Wouldn't you want to know that if you were evaluating, second guessing whether a law enforcement did a good job? Wouldn't you want to know that?
It would be helpful, but that's not what I was presented with.
You weren't even presented with that.
I was presented with a photograph and asked to interpret what's there.
But if there's a witness who said, I saw those and they were just those sandal prints and nothing else there, you'd want to know that.
First off, I'm not an investigator. I don't do interviews. I don't talk to people about what they did or saw. As a scientist, you evaluate the information that you're given to work with insofar as possible. These images have very limited value for analysis. How they got there, I don't know. An article of footwear came in contact with that surface, as I explained, and left an impression, a three-dimensional image. As far as who was there, how many people walked through, I don't know. I was not at the scene at the time of the incident, nor have I ever been to the crime scene.
You've never even been in the crime scene.
Correct.
I mean, isn't that important? If you're going,
Not for the limited purpose
This guy is
that I was asked to look
unflappable.
at the evidence. And as the time had elapsed, there's no
He is
way to go back to
unflappable.
a scene that occurred 2 years ago and try to interpret evidence that probably no longer exists.
and will you just please answer this one question?
Yes, sir.
If there was information from an individual who saw this scene on June 7th, 21, that when she saw it, there were nothing but the sandal prints and nothing else, wouldn't you want to know that?
Again, as a scientist, I can only deal with what's put in front of me.
He's not an investigator.
I
so he
avoid
wouldn't want to know.
witness statements because of their unreliability.
Ooh.
An eyewitness who said, I just saw sandals, you wouldn't want to know that?
I would not care.
Would you care
I'm
about
looking-
this a beat cop if you just saw sandals yourself?
I was not a scientist at that point. I was not subject to bias, accusations, all right, and undue influence from others.
You talking about Mr. Harpootlian or me?
Both.
Okay.
That's a fair statement.
That's a good joke. That was quick-witted.
And the reason I'm following up on that, and I wasn't clear, Mr. Harpootlian said, were these over other imprints or over? They're actually over each other. The sandals are over themselves, the imprints,
I
correct?
said that, yes.
Okay. Well, it wasn't clear. You're not saying they were over these other.
Mr. Meadows, it was clear to me, it was clear to everybody else in the
I
courtroom.
also stated that they're on top.
Objection is sustained.
Objection.
The objection is sustained. Examination by the counsel. Cross-examination, not direct examination.
Look at those numbers again. This is the
And
weirdest
finally, on
thing.
this topic, Mr. Whodunit said that these
What is your StreamYard
photos were taken on June 7th of 2021, and that's what you thought, correct? That's what you were provided.
The appearance from the letter that was, I believe, attached to those images gave that indication, yes.
Okay. And did it say what? Beg pardon, no.
It's just StreamYard. That's what you're saying? I don't know what the hell's happening here.
They were actually taken on June 8th, 2023, later that day. Did you know that?
Apparently, the person who authored the letter authenticating the photograph was inaccurate.
This is weird. There's like 500 people bouncing from like minute to minute. It's the weirdest thing.
Yeah, I don't know.
If you're one of the people who are bouncing in and out, you could tell me like what's happening, that you've been like thrown out or something. I'm very curious.
Well, Joe, I was asking, you just StreamYard counters show the dips?
Yes, sir.
Yeah.
Do you recognize those?
Oh.
Yes, sir, I do.
Your Honor, with that
StreamYard counters
objection,
went
565.
from 7,000 to 6,200 in like 4 seconds.
No objection, Your Honor.
And then now it's back
What
at
about
6,800.
And Mr. Searcy, looking at, I think it states 139, and this now states 565, using common sense, are those consistent with this?
Brian P. saying I was thrown out of YouTube earlier.
Nature of objection.
He's an expert
Legal
witness.
basis for this.
The legal basis is he's applying the wrong standard,
bouncing
common sense. He's a
in,
scientist.
out,
He can make a
back in,
comparison
just
scientifically.
bouncing.
Objection is overruled.
In general pattern designing, this pair of sandals possibly made the smooth imprints that appear in the picture. However, I cannot tell you size, right, or individual patterns, as the images here, again, were not recorded properly, if that's what they were.
Okay.
There are similarities to basic pattern design to these shoes.
Okay. And you'd have said that, and I'm sorry, you'd have said that as a beat cop 40 years ago, and same thing right now today, wouldn't you?
Except now I have to do it as an expert witness, which is much different.
You're getting paid a lot more.
Yes, sir.
How much are you getting paid now?
The base fee was $350 an hour,
I'm sorry?
$350 an hour.
That's the base.
Yes, sir.
Do you get paid for travel?
Yes, sir.
How much?
This time, strictly the airfare.
Okay. You don't get paid while you're traveling?
No, I'm not charging for time.
You usually do?
Again, depends on the circumstances.
And you know I gotta ask this.
That's okay.
Do you get paid more for sitting in that chair than you do for not being? Inside the courtroom, testimony costs more than outside?
It's the same fee.
$350.
It's a basic 10-hour charge for testimony.
And how many hours have you logged so far?
Total 20, plus today and, the travel. But I'm not charging for the travel time.
And is there extra charge for the PowerPoint?
No, sir, it's all part of the examination.
So $10,000 for an expert witness is not crazy.
No.
I'm not sure how it's different from an expert for the state. I mean, they get paid also.
They have not done anything to hurt this guy.
No, I said he's been unflappable. And this is a much better witness to destroy the state because it's much tougher to cross. The cross by Crane Waters of the friend, he's able to just attack on a side attack, saying not about like all the sloppiness of SLED, but fixate on Alex's terrible behavior and make him look like a jerk. You can't do that with this witness. That's why
So
this
this guy's
witness is a
what,
much better
footwear?
witness. He's a forensic expert.
He's a
who
crime
basically-
scene expert, yeah.
And he was destroying SLED for being basically incompetent boobs.
Or if they weren't incompetent, they clearly have a bare, horrible level of training and equipment. So either they suck or they aren't very good.
The point being that the work product that they turned out here was
poor.
terrible.
I'm going to show you what's marked.
Yeah.
States 559 and 558. Mr. Cersei, do you recognize those?
They
Yes, sir,
covered,
I do.
They covered
Your Honor,
Paul's
558
body
and 559 without objection.
with an
Without
absorbable
objection, Your
sheet,
Honor.
and then threw that sheet in the garbage. So anything that's soaked into
560 and
from his
561.
DNA
Mr.
is in the
Cersei,
garbage.
Do you recognize those?
Yes, sir, I do.
Your Honor, 560 and 561 without objection.
No objection, I'm sorry, Your Honor.
He took no fingerprints and trampled all over the crime scene. So
564.
Yes, sir, I do.
564 without objection, Your Honor.
Admit it.
566.
Yes, sir.
And you're saying yes, sir, that means you recognize them. And
Yes, sir.
566 without objection.
Without objection, Your Honor.
And 557.
Yes, sir.
557 without objection, Your Honor.
Without objection.
You admit it.
562 and 563.
These are not expensive experts, by the way, folks.
Yes, sir, I'm
No.
familiar with this report and this one.
medical
Your Honor,
malpractice
562,
expert is
563
10
without
times as much
objection.
money as this.
Without objection, Your Honor.
You admit it.
I have to like mute myself when I'm not talking because I have
And Dr.
someone vacuuming in the
Mister.
back here.
Apologize. Mr.
No problem.
Mr. Cersei. 5-6. And I'll stand back here so everybody can hear. Sorry. 556 and 564 are pictures of Paul's shoes and Alex's shoes, correct?
There are photographs taken at the laboratory of the two articles that you mentioned by ownership, apparently.
Okay. Who've been
With-
identified as Paul and Alex's shoes?
Okay, yes.
Yeah. And then, what are these, 561 and 560?
Depending on the methodology that was used, either placing a slurry of ink on the bottom of the shoe, rolling it onto a contrasting surface, i.e. a piece of paper, of both, you have a set of the left and two sets of the right shoe, right, to try to record any of the detail that would show in a two-dimensional impression when the shoe comes in contact with the surface.
And that's 589 and 559, I believe, are the right shoe. And 560 and 561 are the left shoe of Alex Murdaugh. Would you disagree with that?
No.
Okay. And that's good to do, isn't it?
Yes,
No question about that.
it's part of the examination process.
Take a picture of the soles,
Photograph the items,
do an imprint,
life-size, not as represented in those pictures, but yes.
because you're trying to see if they're characteristics, correct?
If you have something to compare them to, yes.
Class first.
There's 5 criteria: size, shape, wear, pattern, manufacturing, and the final one is individual. The accidental cuts, scratches, gouges, or residue that may be stuck in the bottom of the shoe that would leave a pattern behind.
General class, and then see if you got some kind of individual defect, or I pronate, so that would show on my shoe, wouldn't it?
Yes, sir. And if you supernated, it would too.
Say what? Super, I got you, my bad, I didn't hear you.
Has to do with the way the foot flexes at the ankle.
I understand, I didn't hear you. In 198, 199, already in evidence, would you dispute that these were the right and left of Paul?
They were shown to me as representative of that, yes.
And that's good.
Yes,
I mean, that's good law enforcement.
that's part of the examination process, yes, sir.
And what's now been admitted into evidence, SLED's.
So they didn't F everything up.
Special Agent Worley.
They got one thing right.
two reports, one more detailed than the other, where she basically gave her conclusions about looking at these footwear impressions, correct?
Yes, sir.
And you can't disagree with anything that she came up with, can you?
No, in fact, I agree with her comments about the limitations that were placed on her to do the analysis.
Pretty good examination, wasn't it?
I have no problem with it.
You have no problem with it?
No, sir. In regards to the limitations that were placed on her.
But she tried,
Yes, sir.
and they tried,
Yep.
and they took pictures.
And the pictures that were taken made it difficult, if not impossible, as she states in her report, to draw a positive conclusion in one direction or another, to only be able to give a class characteristic of basic pattern design.
She wasn't basically 90 degrees over it, but the picture was there, still there, correct?
Pardon?
She could still compare these to a picture, couldn't she?
As far as general pattern characteristics, yes.
Apparently, the burden of proof for the state is, well, they tried really hard.
And I think Mr. Whodunit showed you some of these.
I've not been impressed by this prosecutor on cross. He's the one that tried to interrupt cross for a redirect with that other witness.
Yes.
They're out of order.
But yes, I'm serious though. This whole, well, they're trying really hard. Okay, they still suck at it.
SLED should be the special law enforcement division.
Yes.
As in Olympics.
Well, they won't use the O, so they can say Special Olympics Enforcement Division.
An inked impression and overlay of item 103 shoes, which I think you and I have identified were Paul's shoes, correct?
If that's the number that's on the shoe, yes.
And she compared those to the digital photos, and I think, well, they're in here. This is 38. It's got 105.1. You remember looking at these?
Yes, sir.
And 105.2 and 105.3 inside the feed room?
Yes, sir.
And 105.5.
Is there a question?
105.1. Right here.
Right here.
And did she make that mark and put it on there, 105.5, 105.1?
Yes.
Okay. And again, that's states 38.
That's a
What'd
good
you say?
To the
thing.
best of my knowledge, she made that mark.
I understand. What did she conclude about that?
If I could have a report, I'd be happy to read it. Either her report or her work notes, either one.
How about if I hand you this? Ain't got enough room in here, so.
This is from her examination worksheets. Under the
105.1.
Under the accreditation, these notes would have been taken contemporaneous with the examination that she was conducting. All right, now there may be a typed transcript of those. And could you repeat which section again?
You got my mark, huh?
There's a mark on 103.2. And you have an underlined section on 105.1.
Yeah, it is the I'm sorry about your mom guy. Yeah.
105.1. You read my underlined section, please.
Strictly that out of context?
No, you read it all. I didn't mean that. You read everything you want.
Ah,
Tell
I
them
love
about what
that.
she did. Tell it everything.
No, this is what Agent Worley did. From her examination worksheet dated 6/23/2021, all right, regarding reliability tested, not applied, all right, examination notes, subsection section 105 for item 105.1. unknown footwear impression in photograph number 0139. Each photograph that was taken has a specific number assigned to it by the digital cameras, so you can go back to that specific image. Near the feed room door threshold, this would be, to me, it's closest to the entryway itself. The item 105, unknown footwear impression, consists of partial impressions in suspected blood on a cement floor. The outsole design consists of at least 4 rows of parallel rectangular blocks. One block is in a row by itself and appears to be 2 blocks that are joined together, forming more of a V or a U shape. Due to the amount of suspected blood, right, in the impression, it is difficult to determine if those or any of the blocks that appear to be joined together are actually joined in the design, or if the volume of suspected blood is masking the separation of the joints. The sentence with the underlined section, overall, the item 105.1, unknown footwear impression, is consistent with the outsole design of the item 103, right shoe.
That's consistent with Paul's shoe, correct? Assuming Paul's shoe is 103.
It's consistent with that one that's represented, yes.
Thank
you. Okay. Again, this is her opinion.
I understand.
All right. Specifically, the unknown impressions appear to be consistent with the 2nd through the 6th rows of the toe end of the outsole. There is barely a noticeable difference between the design of the left and the right shoe. However, there is a slight variation in the slant of the blocks, especially in the middle row of the impression. Additionally, it is the photograph where, if the photographs were true to size, there is an outline of the blocks that would align with the 5th row of the toe end of the shoe, which is obscured in item 103, left shoe, but is clearly visible in the right shoe. Due to the quality, of the impression, a more meaningful conclusion cannot be rendered. The item 21 and 95, all right, have been eliminated based on the outsole design.
So
those would be Paul's shoes and Maggie's.
So she found that that was consistent with Paul's shoe, correct?
Based on her opinion, yes.
Okay. And I'm not going to go through every one of these, but I would just want to briefly go through. Did she also, on the 105.2 footwear impression, say that Paul's shoes were consistent?
Well, this is what an expert's
And
demeanor should be
continues, the
like,
lack of
folks.
clarity
Not
in the
just
impression
calm,
makes it difficult
answering
to
questions,
determine
not flustered,
if it was
not
made by the
defensive.
left or the right shoe.
Exactly.
Therefore, a more meaningful conclusion cannot be reached. And they were eliminated.
It's consistent, correct? The lack of clarity make it difficult to determine a more meaningful, but it's consistent, correct? They weren't eliminated. Why'd you say that?
I read the next line.
Yeah, but that's item 21 and 95.
Correct.
You were trying to imply that.
No, I wouldn't do that.
You made a mistake?
No.
Well, you said they
The
were
last-
eliminated.
Standing up, badgering this witness next to him. He can read it. He can comment from back here. He's in the doorway, but again, I object.
For clarity.
This moment.
He's been
The
up here.
objection is to you standing in the doorway.
He's been standing up here the whole
No.
time. And aimed a gun at us yesterday from here.
Pardon?
He aimed a gun at us from here yesterday.
For the goose, good for the gander is a rule, and I can't find it in my rule book.
Well, we're operating with limited space. Just as a matter of trial procedures, extremely unusual for counsel to stand in the locations where counsel have been standing throughout the trial. But given the limited space, it's somewhat understandable. But he has moved to the podium. Go right ahead.
Did you
The
misspeak
lectern.
just then?
I did. All right, the last sentence states, the items 21 and 95, the other two articles of footwear, are eliminated based on their outsole design
But Paul's wasn't eliminated.
in a very basic way. And because, again, by her report, by what she reports as the contamination issues, right, blood seeping into other areas, the detail is not there to be definitive. Also, there is no rendering of the size of the image from any of the crime scene photographs. Could it be this big, or could it be this big? I can't eliminate based on size.
I can't eliminate them. She shouldn't have said they're eliminated. She says she should have said I can't eliminate them because I
And
can't.
if we could go to 105.3, I'll stay back here and left you a copy there, and I've got a copy.
Yes, sir.
That's the unknown footwear impression represented.
Tell us what exhibit he's looking. No, I mean, what exhibit you just handed him? What did you just hand him?
To the report that you didn't object to.
No, I don't object to it. I just don't want to know what it is.
It's photograph 29.
It's 1562.
Thank you.
Sorry.
This guy gets really flustered, this prosecutor, man, when he's on his back foot.
I forgot where we were.
105.3.
Thank you. Under 105.3.
He just said size doesn't matter, right?
Can you tell me,
Yeah.
which is comparing,
It's a lie.
It's not true.
I'm looking now in states 40, and do you see 105.3 in states 40, and did you review that when you were evaluating this case? And
I read the reports and matched photographs up to the scene, yes. Or the reports. Whoops, sorry.
And did Agent Worley conclude that item 105.3 unknown footwear impression is consistent with the outsole design of item 103 right shoe? Did she conclude that? Item 105.3 unknown footwear impression is consistent with the outsole design of item 103 right shoe? Did she conclude that?
I just,
Oh, I didn't read it. I picked it up, but it's still up there, sorry.
it cannot be,
5.3.
it just says it cannot be excluded.
Did she say impression is consistent with the outside design of 103 right shoe? In the second paragraph.
And continuing, although there is minimal amount of detail observed in item 103, right shoe cannot be excluded due to the basic design and structure. Again, the limited amount of detail made a very qualified findings. The other part, continuing on with this document and her final report, they all indicate that there could be no size comparison. And again, there's no way to determine that.
But she tried.
She
tried the best she could, yes.
She done tried hard is not an argument.
Was there any treadwear from sneakers with Velcro straps holding them on, like, you know, for an 11-year-old?
I can't believe
And going on down, 105.4.
She tried is their
there was an
best.
unknown impression
No, that's going to be their
represented
burden
on
of
the back
proof.
Maggie's leg.
Ladies and gentlemen, the cops tried.
Yes, sir.
They call it a trial for a reason, folks.
541.
We're just practicing law here.
It's
We're not
embarrassing.
practicing law.
What did she say about that?
Bless her heart.
I believe that she couldn't do anything with it.
You know, listen, boss, she done try real hard, just like John
Although
Coffey.
there's a definite pattern visible,
I
it
take it
cannot
back.
be definitively determined if the impression is a footwear impression or if it was created by some other object, right?
Correct.
And you agree with that?
Yes.
That's good, isn't it?
I can't believe we're 3
And
minutes
the only
into
thing she said, it was kind of consistent
testimony
with
about a
the
woman cop
fabric
failing, and we
portion
haven't
of
heard
item
Andrew
95
Branca chime in.
sandals. That couldn't be excluded. And those are Maggie sandals,
She
right?
didn't take the photos.
We don't know what it is, right?
I want to know about the woman
Sandals?
investigator who took the photos.
Could be that. Could be anything.
Could be a tire on an ATV.
Possible.
She is the one who drew the diagram, not the scale, though, right? Wasn't that her? Made Maggie 17 feet
Yes,
long.
Agent Foster. Yes.
Oh, that was Foster. I thought this was.
No, I
Valerie.
meant
Almost
like
through 105.5.
Miss Jodie Foster. I thought it was that. Yeah, it's that Jodie Foster lady.
Oh, okay.
Yes. Hello, Currys.
And is that?
Well, she has paid
compared to
15% less
shoes
than the
with
male investigators,
557,
statistically.
Yes.
Can't expect as much.
which has been offered
What is 557? Okay,
105.5, 105.6. You've looked at this.
the area behind the door, yes, sir.
You've looked at that. Overall, the item 105.5, unknown footwear, corresponds with the outsole design of item what right shoe?
He so wants the jury to think corresponds means
103.
match.
That's pause.
Again, these are class identifications. There's very limited detail.
And let's go to the final one here, 105.6. Unknown footwear impression, too partial to determine if it was made by the square diamond pattern of one of the item 21 shoes. Therefore, no conclusion could be rendered. Item 105.6, unknown footwear impression was not made by 95 and 103.
Yes, sir.
She examined every footwear, every one of these, correct? She being Agent Worley?
According to her report, yes, sir.
Took pictures of them, imprints of them,
Yes, sir.
compared them,
Yes, sir. Insofar as she could.
and came up with a report.
A report.
Again, I was not requested to write a report.
You don't even have a report.
Correct, sir. I've said that 3 times.
To be fair, this attorney is trying too. He's trying.
Was a report like on a piece of oak tag, like from grade school? For the science fair?
I'm going to urge you all to make sure you like and subscribe, because after I'm done here, I'm just going to be pitching like Andrew Branca's Guide to Healthier Relationships.
I have a very healthy relationship.
I'm joking.
It's not my fault other people can't pull it off.
So you have no idea if everything else they didn't provide you was done 100% correct, do you?
No, sir.
Well, perhaps it's possible.
That's all.
Yeah, very, very briefly. Let me see if I can do this in less than 5 minutes.
Oh, that's not very, very, very.
He asked you,
Let's just briefly.
yes, there's a photograph up here he asked you about in the sand with impressions, shoe impressions, right?
Yes, sir.
So if this Laura Rutman person that saw this earlier said all she saw were sandals when she got to the crime scene, and then there were impressions over those sandals, would that indicate that somebody in some way spoiled or affected the crime scene that arrived after the police did, or with the police, or were the police?
After the observation, yes.
Is that something encouraged in these policies and procedures, to actually walk over footprints in the crime scene?
The primary redress at any scene is to protect the evidence, whatever it might be.
Was that protected?
I don't know.
It would appear if one officer saw just sandal impressions, and then after that, there were footprints on it, it's not protected.
Objection to leading.
Can't lead the witness.
We'll move on.
He made his point.
So you were asked if Agent Worley did all she could do, and you said she tried.
Yes, sir.
Okay, now, she tried with, she even says that the impressions, the pictures of the impressions are inadequate, correct?
Yes, sir.
And that's because they didn't follow the simple procedures you've been doing for the last and most police departments have done for the last 2 or 3 decades, right?
And has been taught for a number of years.
no tripod, no direct angle. And let me ask you this. I believe we've asked this before, but if she had done what you did in that New York crime scene and sprayed a chemical.
Objection, Your Honor.
Hypothetical.
Question.
I haven't finished.
Speculation.
So,
He's an expert.
if she had sprayed the chemical we saw in the pictures that you had in your PowerPoint from New York, what, if any, difference could that have made?
If there was a blood-like substance present, and more especially in and around the partial prints that were visible, it could give you additional detail and further enhance the pattern design and hopefully give you individualizing characteristics for comparison at a later date. The difficulty with this whole case is I can't tell you when those prints were put there.
You can't tell me what?
I cannot tell you when those prints were there. The only comment that you can make is sometime prior to the time the photographs were taken, the print was placed there.
Okay. And this technology of using that spray is decades old also?
Yes, sir, it is.
So you said she tried. Could she have tried harder? Could she have tried better? Could she have used the techniques that have been around for 20 or 30 years to make sure there wasn't the perpetrator's bloody footprint in the feed room? Could she have done that?
She or someone with their investigative group that would be qualified to do that.
Okay. And he asked you a series of questions, went on for 10 minutes about she compared this.
Objection.
The objection
Fictional about
sustained
that.
as to the comment.
Okay.
Were you asked about a series of report with a series of comparisons of pictures with different known shoe impressions?
Yes, sir.
And I believe you indicate that now if there was a match, what word would be used? Would it be consistent or would it be something stronger?
It depends on the type of analysis and the amount of information that you could call or get from it.
Do you ever say this shoe made that impression?
In an all-better world with proper individualizing characteristic and the 5 criteria that I mentioned before, you could reach that conclusion.
Okay, but she says consistent.
Correct.
That's not that shoe made that impression. It's that shoe could have made that impression.
Well, that's what you hit on,
Sure,
Andrew.
any other pattern similar to that could have made it.
Okay, thank you. No further questions.
Mr. Metters.
Do a second PowerPoint that said that Marco Maggie was consistent with the shoe. Did you do another PowerPoint?
I've done several.
You've done several?
Yes, sir.
Where's the other one?
Chose not to use them.
They chose not to use it. That's all.
You may step down.
Thank you, sir.
We'll take a little break.
See, that's sort of trying
go
to
the
mislead the
room.
jury.
You
As if,
cannot
like,
discuss the case.
the other ones necessarily are conflicting rather than this one just enhancing the others.
The state has them.
Yeah.
Yeah.
It's so disingenuous because it's a way of trying to frame something in a way that's
Yes.
really got nothing to do with the proving your case or anything. It's just that sort of thing bothers me. All right.
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 It's almost like The Rock, where Sled's sitting there like, I'm doing my best, and they're like, your best? It's like Sean Connery should come in. It's like,
Oh, right,
best
right.
isn't good enough.
Everybody tries. The winner bangs a cheerleader.
Yeah, the winner fucks the prom queen.
I didn't see that one. So, in my opinion, the afternoon has been going far better for the defense than this morning did. That's just my take. I think that this guy, who looked like a feeble old man that could be pushed around, and some speculator looked a little bit like Ebenezer Scrooge after he shaved the mutton chops. But he was very unflappable, and he held up really well on cross. And I think he did a good job of tarnishing the findings of SLED and saying, like, look, I don't know why the results are what they are, but this is not consistent with standard operating procedure. And you can see what he really hit on was that no fingerprints were lifted from the scene. The footprints were contaminated. You didn't take proper aerial photographs. You covered the body with absorbent material, which potentially, to protect from the rain. He said, when necessary, you'll cover a body. If you have to protect it from being contaminated, you'll cover it. But then you cover it with a non-absorbing tarp so that it doesn't, because an absorbent tarp will absorb both from things coming from above and from what it's covering, and could lift DNA from this scene or other things in this scene. And if you did use an absorbent tarp, you shouldn't be throwing that in the garbage because you might have relevant DNA evidence on that tarp. So yeah, I mean, there's a lot of ways that you can say, she tried, but that's a lot of screw ups for a crime scene. And I think it'll help the defense at closing say they never seriously considered any other suspects to the detriment of Sled. And if they had, they almost certainly would have found a great deal more evidence, but they just literally threw some of it in the garbage. And I think that could be very helpful in their closing arguments. But I'll take feedback from you guys on that.
Well, I wasn't here.
I mean, this is just...
was this guy since when I left? I mean, when I left this morning, they had just finished with the
first witness with the
two attorneys they did
with
earlier.
the attorney who got slaughtered.
Right. The friend. So the friend, the pudgy guy who was a partner in the law firm.
Yeah, this guy's been there since.
They did another attorney after that.
Oh yes, there was a second attorney who was there to try to establish for the defense. This is his counsel from the boat accident, basically trying to testify that while there was a demand for discovery about financial, that it was really not anything that was pressuring, and he felt like he could negotiate down towards away from it being anything that would really be intrusive into Alex's finances, i.e. the claim that he needed a delay and that he decided to off two of his family members to get a delay isn't really consistent with the pressure that he should have been feeling given the nature of that civil litigation.
Right. So all this discovery, all these motions, everything was still fluid and in play. They had room to maneuver.
Right.
As you generally do.
On cross, I felt that Waters, I think it was Creighton Waters who did cross-examination. I felt he did better. He did a pretty decent job of pushing this guy into say, but reaching. Like, I, as an attorney, understood he was reaching. I don't know if the jury could tell he was reaching when he was like, but if he would have got an order from a judge, in that case, he would have been facing tremendous pressure. To me, I'm like, that's a lot of hypotheticals, but I'm an attorney who knows, who's been down that road and dealing with discovery. I don't know how much a jury would take from it because the defense counsel who was doing it was this attorney, this woman who we haven't seen yet, and she seemed flustered when she was getting objections sustained to her questions. So I would say he was okay, but this one has been much better. This witness was easily the best witness of the day. I don't think there's much question about that. Potentially poisoned Sean. How you feeling, brother?
Feeling a little bit better. Sneezing a lot today, but other than that, not too bad.
All right. You getting tested for like any chemical issues or stuff in Ohio there?
No, I didn't. I got tested for all the stuff out of the train tracks yet.
All right. All right. I'm just wondering if if your house is, I have to worry about your house becoming a contaminated crime scene. As like evidence of like the negligence that's happening there.
No, and the railroad didn't come by with the hold harmless agreements they've been shoving in people's faces.
Are they really starting to do that?
Well, there's supposedly it's shown up, and I've tried to explain to people. It looks like somebody whipped up on Word after 10 minutes. And it's not clear who's being held harmless. It sounds like it's for just the testing. If they test it, it says, "Oh, your house is fine, but sorry, it was full of cancer." Right. But it's not 100% clear how far that actually goes, and the railroad might be getting held harmless, and it doesn't specifically. It looks real sketchy.
Right.
So, but they're holding it up in your face, saying, "If you don't sign this, we're not testing." So have fun.
Everyone wants that get out of jail free card. They saw how Big Pharma got it when it came to COVID. So I guess they figure,
What doesn't matter? The railroads. I don't know, like people, I don't think you get it. Like suing the railroads, holy cow, that's never an easy thing.
Yeah.
I mean,
I'm sorry.
They've had 200 some odd years of enhanced legal protections and things that go their way. It's not. I mean, there's entire like the labor law. They have their own version of the labor laws. I mean, on top of every other thing they have special.
Yeah. I mean, like half the cases we studied in torts were railroad cases, right?
Yeah. Yep. And no, guys, I did not go out and get free Taco Bell from Trump. So.
But can you tell everyone about your channel and who you are? So, because I want people to appreciate the greatness of potentially criminal Sean, whose link should be in the description. I want to be 1,000% sure that you are. No, you're not, but you're about to be. I apologize.
Okay, well that works. So yeah, guys, my name's Sean Martin. I run the channel Potentially Criminal. I am a defense attorney outside of Cleveland, Ohio. I try to focus on the criminal stuff because there's enough of that in the world. I do a show every Thursday night, 9:30. We cover what's been going on. Do shows on locals. I do right now 2 a week. Do one on Monday nights, 7:30, and then I do one on locals after my 9:30 show. Just try to cover all the things that are going on out there. There's always something fun. There's always something interesting, whether it's Alec Baldwin or it's just kind of more general topics. Like what can you do? Like how do you handle matters that are in front of you? Like people have asked me like, how should they handle a police stop? And I mean, there's a bunch of them that have done it, but people are asking for it. So I'll be working on one of those myself. We got a couple things coming up. I know the Sarah Boone trial. Well, if she ever has it, I'll be trying to cover that one down in Florida. She locked her boyfriend in the suitcase. And now it sounds like she's claiming self-defense.
So not in a good way. Although I think it was she claims it was intended in a good way, right?
Well, she's claiming it was like, well, she might be claiming battered spouse, so it's going to be like, I assume she's going to say, I locked him in there to stop him from hurting me, and then I accidentally killed him. So that'll be kind of interesting if she goes down that road.
Well.
So that's in April. I don't think I have any trials necessarily coming up, but if there's something in time for it, we'll probably cover it.
Cool.
So yeah, you can find me on locals at potentiallycriminal.locals.com, Rumble, BitChute, everywhere else.
And I heard Law of Self-Defense now has an advanced class. That's what
I've heard that too. I wonder when it is. Saturday, April 15th. I should make it Sunday so I could do it like the car race commercial.
Sunday.
But it's Saturday, April 15th, 2023. The only one of these scheduled for this year. Law of Self-Defense Advanced Live Online class. Learn how to be hard to convict, an unattractive target for prosecution if you ever are compelled to defend yourself, your family, your property against criminal predation. All in one day, taught live by me, streamed to you on the convenience of your computer or on Zoom. And if you sign up for it this month, that's February, folks, only about a week left. Sign up this month for that class and you get 25% off your registration. You can learn more about the course, including a list of the more than 100 questions that we answer in the course of the class. Learn more and register at lawofselfdefense.com/advanced. And separately, oh, by the way, if you can't make it on that Saturday, register anyway, because you'll have access to the playback version of the class. So you can still enjoy the class content, just in a recorded playback format. Also, get this book. You want this book, Law of Self-Defense Principles, real physical book, not just a PDF download. Check it out on Amazon, 5-star rated, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. I only ask you to cover the cost of getting the book to you. You can get this free copy of the Law of Self-Defense Principles at lawofselfdefense.com/Joe. And if you'd like the very handsome hardcover edition of this book, makes a great gift, you can get the hardcover at lawofselfdefense.com/gethard.
There you go. I highly recommend both of these gentlemen for the work that they provide. I am positive that you will be satisfied if you take advantage of the information and insight that they offer. So could not endorse highly enough. And while you're here, by the way, I'm desperately trying to get to 10,000 on Rumble. You Rumble folks are very slow. You're very slow to sub up. You're very slow to sub up. And honestly, YouTube of late hasn't been much better either. I'm getting like, I don't know, these videos get like 30,000 views and I get like 100 new subs, 200 new subs out of it. So while you're here, you can sub up. I'm trying to get to 100,000. I don't know, sometime before I turn 70. So,
Get that plaque.
Yes, I need that play button. I need something to hang behind me because, yeah.
No wants his play button with Mama Susan's, not the new guy.
Yes. Who wants the new guy? Anyway, so if you could sub up, I would greatly appreciate it. So thank you for that. And obviously hit like so that someone else besides you might be able to enjoy what we're offering here. What do you guys, as far as who's left to testify here? The two people that I can think of that they would definitely want to bring in here would be one. I would definitely want to have an expert who can testify about the impact of shock on the human memory, because he has to lay groundwork. And the second one is I do think I would have him testify at this point. He has to have the groundwork laid for him before he gets up there to testify. He can't be like the next witness here. They can't be first thing tomorrow morning unless because we need to have an expert witness come in and explain to the jury that when the human mind, that research shows that when someone undergoes the level of stress that he must have undergone, finding his dead wife and son, that the memory blocks things out to protect itself, and that we should not be remotely surprised that even 3 months, 4 months later, that his memory literally erased any recollection of his ability to of seeing that his last time he saw his wife and son was at the place that he would later find them an hour or so, after they're killed, and that he just blocked that part out because it was just too violent. It was just too traumatic to think about that, and that's why when he's sitting here, recalling like where he was, he kept denying that he was at the kennels. I think he needs that groundwork laid by a memory expert. And then I think he needs to come in there and basically plead mea culpa, say I've made a million mistakes. My drug addiction's led me to terrible things. All the things he said on the phone, that he admitted on the phone after he had fessed up on the roadside assistance, then he admitted to the police. I think all that stuff, he basically recreates that for the jury here. So I had terrible drug problems. And this led towards money issues, and this led to me doing things that I'm humiliated to admit that I did.
I am a sinner.
Yes, the reforms. Yeah, but aside from that, who do you think? So, and then come in there and basically tell his story, and then say how he blacked out that memory, and that and here's how the night went for him, and walk the jury through what he did that night. Who else do you think should testify besides that?
I can't imagine, to tell you the truth. And those two people might well take the next 2 days.
That's true.
Yeah, I don't know. I mean, this guy he just pointed out how bad the investigation was. I don't know what more you can show.
145 into
Yeah.
Submitted without objection.
Do I have to buy you dinner now?
Ready for the jury?
Do I have to buy you dinner now? Is that a I just effed you joke?
I don't know.
Harpoolian coming in hot.
Yeah. Based on what we've seen so far, Jim takes the stand. I assume it's going to be Jim. Alex takes the stand. I assume it's going to be Jim Griffin who's going to do the direct examination, right? Not Harpoolian.
I would think so.
I think Griffin's been the stronger one.
And he's been there from the start.
Yeah. I think that makes sense.
Harpoolian, big dick energy.
and it's definitely going to be Creighton Waters who'll do the cross. Yeah, he's not going to pass up the opportunity. He's not going to pass the opportunity to let someone else.
No, he'll probably have a flaming spear in his hand.
John Diaz says, I wonder how much the way the prosecutors are carrying themselves and how aggressive, hostile they present as is affecting the jury. The defense seems relaxed and calm. Their witnesses as well. Their witnesses definitely have seemed much calmer to me when they've been crossed. Oh, wow. Without glasses, he looks like an owl.
Ooh.
Jury is present, sir.
Thank you. Your next witness.
Thank you, Your Honor. Defense calls Barbara Ann Mixon.
This is a family member, right? Maggie's sister or something?
You know, he hasn't had a family member come in yet. Anyone come in and say, I cannot possibly believe that he would do this. I know that he's
Raise your right
committed all his
hand,
crimes.
left hand on
Even
the
Buster didn't do it. His friend today didn't do it. No one has said
The
that.
testimony about to give the court in this trial shall be
Sorry,
the truth,
slow
so
to
help you
attack my
God.
Wi-Fi.
Thank you. Take
They
the
don't
seat in the
appreciate
witness
my
stand.
comments.
You can adjust the mic if you need to. State your name again for the record, please, ma'am. Barbara Ann Mixon.
Mixson.
Nixon with an S.
Can we pull that mic close to you?
Yeah, I guess it's not Maggie's sister.
Mixon, will you tell the jury a little bit about yourself, where you're from, how old are you, and what do you do?
My name is Barbara Mixon, and I'm from Farmville, South Carolina. And
Oh,
I'm a
my
widow.
God.
I have 4 daughters.
The court
5
reporter just
grands,
shot herself
2
through the head.
great-grands, and I do housekeeping and care for Miss
Oh,
Elizabeth
she's-
Murdaugh. And I'm 71 years old.
That ain't no problem.
71 years old. And how long have you been doing housekeeping for Ms. Libby Murdaugh?
42 years.
42 years. And you did housekeeping for Mr. Randolph Murdaugh when he was alive, I take it?
Yes, sir.
And do you know all the Murdaugh children, Randy and Lynn and John Marvin and Alec?
Know them just as good as I know my kids. They are my kids also.
And they're part of your family.
That's right.
Now, are you part of their family?
Yes, sir.
How well do you know Alex sitting here in the courtroom?
Just like I know one of my kids.
And you love him like one of yours?
I sure do.
Okay. Did you know Maggie?
I know her real well. She was like a daughter and a friend.
You talk to her frequently.
Every day.
And did you know Paul?
I sure did.
How often would you see Paul?
I would see Paul practically every week. He would come down to see M and Hanson, and then I would be there during the day. And some days he'll come by my house and see me.
Right. And you know Buster?
I sure do.
And he's sitting in the courtroom today?
Yes, sir.
Got a chance to see him?
Yes, sir.
I'm not going to take a whole lot of time, Ms. Mixon, but we just give the jury a little bit of a understanding of how frequently Alec would go by and check on his mom and dad over, say, the last 10 years.
Practically every day when I'm there. I see them every day, and I'm there Monday, Tuesday, Wednesday, and Friday. Sometime I have to work on Saturday and Sunday, and he would come by.
And what time of day, I guess, the hours that you worked over at, did you call the place Almeida, or do you call it Almeida?
Yes, sir.
And what are your normal hours there at Almeida?
8 to 3.
And it's always been 8 to 3 for?
8 to 3, always.
And you took some time off when your husband was sick, and then you went back to work. You know when you went back to work?
My husband passed on January the 2nd of 2019, and I went back to work in August of 2019.
And during that period of time, you were working 8 to 3?
8 to 3.
Okay. And I think you said Alec would come by frequently.
It's the
and check
Waffle
on his
House
mom
night
and dad?
shift.
Yes, sir.
Would Maggie come with him?
Well, not through the week. I mostly see Maggie like
I'm
on
sure they
Fridays,
would.
or she might stop by like that. But it will come through the week by itself.
Okay. And I think you mentioned Paul would visit?
Yes, sir.
Just want to go to June 7th. You remember that awful day, Ms. Mixon?
Yes, sir.
Did you talk to Maggie that day?
I talked to her on June. I talked to her on June the 9th. I think it was between 7 and maybe 7:30.
You didn't talk to her on June the 9th.
That's when she was murdered.
Right, June 7th.
And you talked to her that evening?
Yes, sir.
And you remember what y'all talked about?
Yes, sir.
What'd you talk about?
She said, Barbara, I was trying to reach you before I left to go to Somerville. I had to take my mama to the doctor, and I couldn't get a hold of you. But I am going to fix supper for the Murdaughs and for your family for Wednesday night. Because Thursday, I got to go take my daddy to the doctor. And she said, oh, Barbara, I'm going to call you back. She said, no, hold on a minute. That either Elliot or Buster calling me. She said, I tell you what, I'll call you back when I unload the car. And I never got the call back.
Wow.
That the last time you talked to her?
Yes, sir.
That's very detailed
The last
recollection.
conversation you had with her, she was planning to make you dinner. Is that right?
Dinner for me and her in-laws.
What was happening on June the 7th? Do you remember Mr. Randolph, what his situation was?
Well, John Marvin came to take Mr. Randolph to the doctor. And, you know, I remember that part. 'Cause he
I
was
don't know
real
why there's no
sick.
closed captions. I'm not
And,
sure. Add them on.
And after
Closed captioning
John
gave
Marvin
up.
took Mr. Randolph to the doctor, you remember that Mr. Randolph got checked
He
into
only
the
does
hospital
English.
that day?
Yes, sir.
Okay.
It does not speak South
Remember
Carolina.
calling Alec
Yes, sir.
on the afternoon of
Should get Jim Griffin.
June 7th.
Yes, sir.
And what'd you talk about?
Objection, hearsay.
What did you talk about?
Objection's overruled.
What'd you talk about, Ms.
Oh, I
Mix?
called Elliot. Well, first I called Chrissy. I always call Chrissy first. I couldn't get Chrissy. So then I said, well, let me call Elliot. So I called Elliot. I said, Elliot, your mom is very agitated. She is crying. I give her medicine, and I want you to come check on her later on during the day. And he said, okay, I will.
Was Ms. Libby agitated?
Because Mr. Randolph had done gone to the hospital.
But, and she was in fact agitated, is that right?
Yes, sir.
And what do you mean by agitated?
Well, she was crying a lot, and I couldn't get her to eat, and she just, you know, she just agitated. She wasn't.
And
She's a very credible witness.
I'm going to show
So not so mysterious why Alex went
exhibits
there
and evidence.
that
All right,
hour.
Doug, if you could pull
That
up
odd, like the state's suggesting.
Precisely.
State's Exhibit 520 and go to page 21, which is the Rudolphski extraction long version. Ms. Mixon, can you see, there's an entry on this timeline at 3:58:39, Alec Murdaugh receives an incoming call from Barbara Mixon. Do you see that?
Yes, sir.
You think that's when you called Alec?
Yes, sir.
Okay. And that is on June the 7th, for the record. All right, you can take that down, Doug.
She's also got the advantage. They're not going to be able to lay into her too much.
Nope.
How'd you learn about Maggie and Paul?
Well, I was sitting on my porch,
She's a great
and my
witness.
daughter, which she's in the courtroom, Shirley, Officer Stacy Lord-Hope came and pulled up. Shirley, my daughter, which in the courtroom, she jumped out of her car and told me to say, Elliot found Maggie and Paul dead.
So a police officer came to your house.
Two of them. It was Stacy Lord-Hope and then another one. And I said, could I go out there? And they said, no, you couldn't go out there.
Okay. And Ms. Mixon, that was a Monday night, and do you remember Mr. Randolph dying on a Thursday, passing on a Thursday?
Yes, sir.
Okay, and that was June the 10th.
Yes, sir.
And do you remember that the funeral for Maggie and Paul was that Saturday? The funeral for Maggie and Paul was that Saturday. Do you remember the funeral service at the graveyard for Maggie and Paul on that Saturday?
Yes, sir.
And then Mr. Randolph's funeral was on that Sunday. Remember that?
Yes, sir.
And the next day was a Monday. Did you work that day?
Yes, sir.
And what time did you come to work?
8 o'clock. Well, about 5 minutes to 8.
And who did you relieve?
Shirley Smith.
Okay, so Shelley would have worked the night shift and you came on at 5 till 8?
Yes, sir, and released her.
And did you work that Tuesday?
Yes, sir.
And what time did you get to work?
5 minutes to 8.
And were you relieving Ms. Shelley Smith?
Yes, sir.
And what about that Wednesday?
I released Shelley Smith 5 minutes to 8.
All right. And Ms. Mixon, on any of those days, Monday, Tuesday, or Wednesday, when you relieved Ms. Shelley Smith, did you see a tarp opened up anywhere in Ms. Libby's house?
No, sir.
No blue tarp? You see no blue tarp on a rocking chair?
No, sir.
Have you ever seen a blue tarp laid out in the house?
I never seen a blue tarp laid out in the house. Never.
And you relieved Ms. Shelley
Yes,
every
sir.
day, Monday, Tuesday, Wednesday of that week?
Yes, sir.
All right. Thank you. That's all the questions I have.
Why don't they ever ask that question? I don't understand. Are they afraid of asking this question?
How you doing?
I'm doing good, and you, sir?
You could open up an
Been better,
awkward
been
door.
worse. We met a few weeks ago.
Yes, sir.
You remember down at the,
Yes, sir.
not far from here.
Yes, sir.
You love Alex.
I love all of them.
You love
They
them.
like my children.
They like your family.
Yes, sir.
And we talked about that day before, briefly. You remember that day, the 7th, like he just asked you. We talked about what you did that day and who you talked to, right?
Yes, sir.
Okay. And you didn't tell us about that conversation you had with Alex that day, did you?
No, sir.
Okay. Have they talked to you about that recently? When's the first time you told anybody about that?
I can't remember, but I can't remember. It's been a little while. I can't remember.
That's all, thank you.
Yeah, they
Thank
do.
for
Nice
that.
try.
Thank you. Ms.
So if you ask, do you believe or can you imagine Alex killing Maggie? They'll come back and cross and say, can you imagine him stealing
Yes.
this money? Can you imagine him stealing that money? Can you
Two
imagine him
steps
being a
down.
drug addict?
He's excused.
Yeah, that would be a risk.
Next witness.
Your Honor, this defense calls Micah Sturgis.
That was a very solid witness for the defense. So
Well, it explains away the whole state narrative of he went to the house to hide the guns. It was an otherwise unexplainable visit.
Yeah, and just her going back in her time history with them, that he checks on her, cares about his
Raise your
mom.
right hand, left hand on the Bible. Do you
Feels
affirm the
everything
about
testimony you about to give the court shall be the truth, so help you God?
I do.
Thank you. Take a seat in the witness stand. You can adjust the microphone when you seat if you need to. State your name again for the record, please, sir. Sure. Spell your last name.
Micah Sturgis, last name Sturgis.
The motorcycle rally.
Good afternoon, Mr. Sturgis.
Good afternoon.
Vroom, vroom.
To start with, can you just tell us about yourself? Where are you from?
Sure. My name is Micah Sturgis. I'm from Charlotte, North Carolina. I am the Director of Digital Forensics for Barefoot Professional Investigations.
Pull the mic a little closer.
Sorry. Better? I'm the Director of Digital Forensics for Barefoot Investigations.
Okay. And tell us about your experience in law enforcement and then cell phone forensics.
Sure. So from 2004 until 2016, I was employed by the Cleveland County Sheriff's Office. It's a full-service sheriff's office located in Cleveland County, North Carolina. They're on the border of North and South Carolina. During that time period from 2004 to 2006, I was a patrol deputy. In 2006, I was promoted to a corporal or training officer, where I trained new hires. In 2009, I was promoted to detective. In that capacity, I handled everything from larcenies to murders, and then I took on the role of the digital forensic examiner for the sheriff's office. Was the first one that we had, and I formed the digital forensics lab at the Cleveland County Sheriff's Office.
And before we get more into digital forensics, you've been involved in murder investigations before?
I have, yes.
Okay. As a lead detective?
As a lead detective, yes.
And then as you go into digital forensics, tell us about your experience with digital forensics in law enforcement, and then after that we'll get to your certifications and training.
Sure. As the digital forensic examiner for the sheriff's office, it was my responsibility to handle all the digital evidence that came into the lab, and I was also in charge of ordering things that needed to be ordered and stocked up on for digital forensic purposes. And during that time period, I was sponsored by the United States Secret Service to attend the National Computer Forensics Institute in Hoover, Alabama, where I was trained in mobile device examination, multiple tools, Celebrite, Blackthorn, which is a form of burla ivy, XRY, which is another forensics tool, Paraben was another tool that we used.
All the tools.
And so I received that training from the NCFI. They also sent me back with several things, one of which being a laptop computer or a MacBook in order to do examinations on, and also a Ramsey's box or a Faraday box that I used to use
Faraday
whenever we
box.
had phones that came in.
And let's just, since we're kind of on it, could you go through the training you've had in digital evidence?
Sure. So I have had the basic and intermediate cell phone forensic courses, introduction, intermediate, and advanced, computer forensics, internet investigations,
all the
introduction to
certificates.
wireless investigations. I was a Lantern certified examiner, attended the Lantern cell phone training. Lantern is a forensics tool for Apple devices, primarily Apple devices, does some Androids. Apple iOS forensics, I attended that at the American Academy of Applied Forensics in Charlotte. Cyber investigations, I was, like I said, I was nominated and sent to the National Computer Forensics Institute by the United States Secret Service, where I received my mobile device examiner certification. I also received Celebrite certifications while there at the NCFI, and Paraben mobile forensic training, Celebrite certified physical analyst, received XRY training at the Tennessee Bureau of Investigation, and took the XRY intermediate courses. In 2017, I attended the Infuse conference in Las Vegas, Nevada, where I sat for my ENC written examination. Later came back to Charlotte and did the practical examination, where I was certified as an in-case certified examiner in 2017. And attended the Magnet User Summit a couple of times, received some training on their tool there at one in Las Vegas, the other in Nashville, and received introduction to alternate data acquisition training, wireless analysis training. I received my Lantern certified examiner from Katana Forensics, my XRY certified examiner from MSAB, the Celebrite mobile forensics fundamental certification, the Celebrite certified operator certification, the Celebrite physical analyst certification, and then the Celebrite certified mobile examiner certification, and also
Could
my
you list the
in-case certified
certificates you
examiner
don't have?
certification.
And can you tell us about how many extractions or acquisitions of digital evidence you've performed?
Sure.
Thousands.
Well over 500 logical physical acquisitions and extractions using Lantern, the Apple device forensic tool, Celebrite, Blackthorn, XRY, Paraben, and over 750, well over 750 images of hard disk drives or solid state drives of computers, and analyzing that data within either FTK or in-case. FTK's forensics toolkit. It's a forensic suite.
Everybody in the courtroom is busy erasing their
Examined an in-case
internet search history
Magnet
from their
IEF,
phones.
which is Internet Evidence Finder. That's what they started out as. They're now Magnet Axiom is the product that they produce and put out. So I've used Axiom to do multiple examinations with that. Image with hardware forensic imagers like the Forensic Falcon. I've used Paladin to get
It just never
live
ends.
acquisitions, Macquisition for Max, and Recon ITR for
Your Honor, we'll need 3 hours for his qualification.
also
Oh, Joe, they're probably going to have
had
a
to collect checkpoint
private
encrypted devices
medical
with my time
examiner
at the bank.
testify, I assume, at some point. I
And,
think
and
maybe.
it leads into, when did you leave law enforcement?
yeah.
What have you done since you left?
Sure. In 2016, I received a phone call from an individual who owned a private firm in Charlotte, and I went to work for him as a digital forensic examiner in the South Park area of Charlotte.
Okay, and after,
After that, I worked for him from 2016 until roughly 2019, and then I went to Wells Fargo, where I was one of
With Nick.
24 examiners for
Yes.
the Wells Fargo and Company.
See,
After leaving Wells Fargo,
this guy can help
in
delete your search history in case you
2021,
die.
I went and formed this lab at Barefoot Professional Investigations.
and have you ever been qualified as an expert by court to testify before?
Yes, I
Hell
have
yes.
in both criminal and defense work.
Okay. Criminal work, civil?
And
cases?
civil as well, yes.
And in the
There you
criminal
go.
cases, have you been on the defense side, the prosecution side, both sides?
I've been on both.
Have you ever been qualified as an expert in digital forensics in a murder case before?
I have, yes, in 2015.
And was that for the prosecution?
It was for the prosecution.
Your Honor, at this time, I would offer the witness as an expert in cell phone forensics.
We object.
So qualified.
Mr. Sturgis, before we get into the what we're here to talk about, are you paid by the defense to be here?
I am.
And how much?
My rate is $300 an hour for any type of examination
Eddie.
work or consultation, and then $600 an hour to be on the stand.
And does that go to the company that employs you?
It does.
In your experience, are you aware of anyone who does this work for free for the defense?
No, I'm not. In fact, I do IDS work. And
What's that?
IDS work is indigent service, so people who can't afford defense experts.
Indigent,
And I do that
not
work.
indigenous.
The state pays me.
Turning to this case,
So he's going to testify for American
have
Indian.
you, what information have you reviewed regarding the cell phones in this case?
Everything that I've been able to look at and review has been provided by the state.
And specifically, the extractions, where they're
Right, for
from?
specifically the extractions of the mobile devices and reports that they've produced.
So you haven't done anything independent of what the state has provided?
No, only the state's data.
Okay. And have you had a chance to review the timeline that's been introduced into evidence in this case? I believe it was, I don't have the exhibit number on me, but the large timeline of events that was.
The one provided by the state, yes.
And as far as the cell phone information goes, is that timeline accurate?
It is there, with the exception of a couple of things based off interpretation of the data, but for the most part, yes, it is accurate.
Is anything missing?
There are two instances where there's some things from the Knowledge C database that aren't in the report that I've been able to locate and identify.
Okay, and we'll later on get to that, but we won't have to belabor it because we'll just sort of be filling in those gaps. But there are three phones here, Paul, Alec, Maggie, Murdaugh. What did you do with Paul's phone, if anything?
With Paul's phone, the extraction reports that I received, there wasn't much data after 8:49, somewhere in that time, on 6/7. So I didn't really focus much on that one. With Alex's phone, that one reviewed the steps that were there in the Apple Health sections. And with Maggie, I really focused my attention on Maggie's.
Okay. And so we'll focus on her phone. Was there any GPS data on her phone?
There was GPS data, but there was nothing from 6/7.
Remember when the GPS data started?
It was 6/9.
Okay. And you mentioned when talking about, I think, your qualifications, Faraday bags or boxes. What are those?
So a Faraday bag or a Faraday shield is something that completely takes the device off the network. It also prevents GPS signal from reaching the device and changing data to the device.
You could describe your experience working with those in law enforcement?
Sure. So part of my responsibility as the when I worked at the sheriff's office as head of the digital forensics lab, was to make purchases. So I would purchase these Faraday bags for our patrol officers. So when they came out on the scene and came across, if we had an instance of a crime where a phone was used and they needed to seize that phone, they had access to those bags, either in their cars or back at the office in the shared vault room where they could go in and put their evidence up. And if it's a good bag, which, you know, if you buy the right bag and the phone's put in there the proper way, then it prevents signal from reaching the phone.
And then, did you mention a box?
Yes, so it was a Ramsey's box, is what I called it. The Secret Service provided that to me when I left their training. And with that box, what I would do is I'd take the phone from the Faraday, or from evidence that was in the Faraday bag wrapped up, put it inside the Faraday box, or the Ramsey's box. It has two gloves that I'd shove my hands into. My computer and the forensic software would be plugged into the side of the Ramsey's box. It was a powered box. There was a light on the inside, so it had a window I could look into, and then I could manipulate the bag and open it up and pull the phone out and keep everything in that Faraday shield.
In your opinion, if Maggie Murdaugh's phone had been secured in the way you just described, would it have GPS data from 6-7?
It likely would have.
Can we show what's been admitted as State's Exhibit 278?
Again, designed to show more incompetence in SLED.
Can we show
Because the new GPS data kicked out the old GPS data. Overrode it, whatever. Snowing in Vegas. Please tell me you're lying.
And can we see the top of the screen? So do you know what the little arrow in the top left of the phone screen is?
Yeah, that's the locations. I'm sorry. That's a location services arrow.
And I probably should have asked first, this was admitted as a photo of Maggie. You've seen this before. Do you recognize it?
Yes, I have.
And again, that arrow indicates...
Yes, that location services are active on the device, even though the phone's in airplane mode.
Does that mean that right there in the lab it's writing GPS data?
Yes.
You can take it down.
Wow. Wow.
I'll show you what's been marked as Defendant's Exhibit 156. I'll ask you if you recognize that.
I do. This is Alex Murdaugh's steps and Maggie Murdaugh's steps from the Apple Health data.
Your
We
Honor,
get
I
the
would
weaknesses
offer
in the
without
step
objection,
data.
Defendant's Exhibit 156 in evidence.
But they tried. They did their best.
No judgment.
What if they were river dancing for 30 seconds? How many steps is that?
It's the Apple. I want to just ask you to explain what some of these terms are. How does, and obviously from the title, this is out in Murdaugh's phone. How does the phone come up with that steps number?
So there are accelerometers.
Mic a
I'm
little
sorry.
closer, please.
I hope I sit up a little further. There's accelerometers inside the device. So whenever the phone is jostled or moved and there's the accelerometers move, then that accelerometer data logs a step. So independent upon where the device is, if it's on your waist or in your pocket or you're holding it in your hand when you're walking, that movement of the accelerometer indicates those steps.
And what does, how does it come up with the distance that corresponds with those steps?
It uses the satellite's GPS.
And what does the start and stop times, what do they mean?
So in the Apple steps or Apple Health data here, you see, for instance, entry 26, that the between the times of 7:55:32 and 8:05:07, that 270 steps were taken during that time period.
Okay. Now, do we know when in that time period the steps occurred?
We know that the steps or the logging of those steps started at 7:55 and 32 seconds, but whether we don't know each individual step, when each individual step took place. We just know that sometime during that time frame, those 270 steps were taken.
And between the steps numbers and the distance, do you have an opinion on which one is maybe more accurate?
In my opinion, the steps are going to be more accurate.
Why is that?
Because of the accelerometer and the hardware in the phone, they're more accurate.
Does that mean that the distance is not useful information?
It doesn't mean the distance isn't useful information. I think the totality of everything altogether is what we have to look at here.
Go to the second page. And is this the same thing for Maggie Murdaugh's phone?
It is.
Before we get into time, just some other things to cover. There's been a lot of talk so far about orientation changes. You can take that down, that exhibit. What is an orientation change on an iPhone?
So an iPhone has two orientations. It has a portrait or up and down, or a landscape, which is horizontal or sideways. And whenever whenever the device is backlit, that's when the orientation change will log and show. Now, we're not specifically talking about like a phone. If you physically take the phone and you turn it like this, we're not talking about the physical.
I'm going to just interrupt for a second. I know they don't let you have a phone, but since you're gesturing,
thank you.
There's a phone that might.
So what we're talking about is not the physical positioning of the phone, but the orientation of the data that you're reading on the device, that orientation change.
And what do the start and end times mean for an orientation change?
So when a orientation change is made, a start time is logged. That's the start time of the orientation change that you're seeing on the device itself.
A deja vu back to the written
For
out
Maggie's
file.
phone, what was the last orientation change? When was that?
I believe that was 9:06 and 12 seconds p.m. on 6/7.
And when did that one end or complete?
I believe that was 9:06 and 20 seconds.
And when it completed, what was the orientation of the phone for the rest of the time?
It was in portrait mode.
Okay.
Not
If the
landscape
screen
mode like
is
the
off,
state said.
can an orientation change occur?
If the screen is off, no, the orientation change can't occur.
That's what I said earlier.
If the orientation
In my
change
experience.
happens in the database at the exact moment the screen comes on, does that tell you anything?
When I see that, when I see a orientation change at the exact time that the screen is lit up, if the device was in horizontal or landscape mode and then moved into portrait mode and the screen comes on, then all of a sudden, the exact same time, it changes into portrait mode. To me, that indicates that the phone was in a portrait mode position, and then the screen comes on, and then the orientation change takes place inside the phone.
You've got to explain it clearer than that, my friend.
Does that mean that
I thought that was pretty clear.
No.
movement when the screen is off can appear as an orientation change when the screen comes on?
When the screen comes on, yes. When the screen's backlit, that's when the orientation change. It cannot make an orientation change unless the back screen's lit.
So kind of moving on then to, we've talked about orientation changes and they don't happen when the screen is off, as you said. Can motion of the phone turn on the screen?
Yes. Very little motion can turn on a screen.
And what is the raise to wake feature on that?
So the Apple has a raise to wake feature that's set by default. Currently, this phone, and unfortunately you can't see there.
Well,
but
could you, if the court's permission, could you come down to show the jury?
It's on. See that small movement. Can I put it right here? No? Okay.
It really helped if you would demonstrate with the phone.
Will indicate. So when the phone's here, if you raise the phone, it raises the wake. So if you raise the phone like that, if the phone's flipped over, you flip the phone back over, it wakes up. If you move the phone from this mode to here, the phone comes on. So that's the raise the wake function.
And was this feature turned on Maggie Murdaugh's phone on June 7th?
By all indications on the database, there were that, it was there, yes.
Are you familiar with the location of Maggie Murdaugh's phone when it was covered by law enforcement on 680?
I am.
And have you reviewed the recently received GPS data for Alex Murdaugh's Suburban when it was passing that location?
I did.
Okay. So do you know when the Suburban passed the location of the phone?
When it was leaving the house where the crimes took place, it was around 9:08. When it was passing the location where that phone was located. And then on the return trip back, it was 9:59, I believe 19 seconds.
Was Maggie Murdaugh's phone screen off during those times?
Yes.
Now,
so he passes
now
it
you're
2 minutes
just
after
here
it's
as a
thrown
cell
on the
phone
road.
expert, right?
That's correct.
So can you offer any expert opinion on how a phone would tumble or bounce or move when thrown from a car going 40+ miles an hour, into the brush and the side of a country road?
No, there's just too many variables, and I'm not an expert on physics, so.
Can you tell us how much motion would be required for the screen to come on a phone?
Very little, just reaching and picking this phone up like I just did there, the phone comes on, so very little.
Okay.
Steve.
And again, in the times that Alex Murdaugh's car was passing, the screen never came on.
That's correct. The database indicated it was off.
Turn to Maggie Murdaugh's phone.
Show you what's been marked as attendance 158. You recognize this?
I do.
And what is it?
This is a PowerPoint presentation printed off that you put together, but it's based off of the knowledge seed database data that I
And to be
reviewed.
clear, I typed it into PowerPoint. Have you reviewed every slide in that presentation?
I have.
Have you verified the data on every slide?
I have.
And you've confirmed independently the data on every slide?
Yes.
I hope he gets to the fact that they can't calculate 4 minutes.
Your Honor, I
You
would
know why they
also
did that? That makes a
mark
work
this finish
product. It's not the
158.
expert's report.
That's a great point. That's a great point.
I did the calculations on the
I'm
steps.
going to go through this. No, don't zoom the screen.
And the steps, the 280 some steps is only 0.15
So we're looking at
miles.
just a very short period of time, right? Can you describe the time period we're looking at?
Yes,
Perfect. This is what we
on
need
June
right here.
7th, from 8:49 p.m. until 9:07 p.m.
All right, so we're going to go through here and just see exactly what was happening with her phone on that time. So next slide, please. And what's happening here?
At 8:49:26
You can pull the mic closer, please.
Sorry. At 8:49 and 26 seconds, that's the last text message that was read by Maggie. It was indicated read on the device.
Next.
At 8:49 and 28
Oh, nice
seconds,
touch.
the backlight goes off.
And what does that mean?
That means that
The screen?
the screen's dark. Yeah, sorry.
And next.
At 8:49 and 31 seconds, the phone locks, and it remains locked until it's recovered by law enforcement the next day.
Next.
At 8:53 and 8 seconds, the backlight comes back on. The phone's eliminated.
And next.
And 8:53 and 12 seconds, orientation to portrait starts.
Next.
Interesting. That's when you assume.
At 8:53 and 15 seconds, that's when the phone began logging the 59 steps.
Next.
And
And it's on the screen. And
Yep, sorry. And at 8:53 and 20 seconds, there's Siri usage. This was indicated in the Knowledge C database, and that can be done by squeezing the side button, holding on to it for a short period of time, and Siri activates at that point.
So this is a user interface, you know?
Yes,
somebody squeezing the
it actually shows up as Siri UI, so it's a Siri user interface.
Next.
At 8:53 and 24 seconds, the orientation to portrait completes.
Next.
At 8:53 and 28 seconds, the backlight goes off again, so the phone's dark.
Next.
At 8:53 and 32 seconds, the backlight comes back on the phone and illuminates.
Next.
At 8:53 and 44 seconds, the backlight goes off again.
Do you have any opinion about why it just popped on and off like that?
I mean, there were no indications in the Knowledge C database that any notifications came in or anything of that nature. The only thing I could think would be that the phone were jostled or lifted or somehow the light came on.
And next.
At 8:54 and 32 seconds, the backlight comes on.
Next.
At 8:54 and 34 seconds, there's an entry in the Knowledge C database about the camera usage, camera starts. So in that, there are, in that database, and if you don't mind, I'll kind of expand on this. In that database, the Knowledge C database is comprised of tables and rows and columns. And in that database, on that specific item where the camera was, there is another column that is called the Z-structured metadata. And so if I follow the camera under the value string there indicating that the camera was activated, if I follow that line all the way across to where that structured database is, structured metadata is in that table, I'll get a PK number, a primary key number. That number was 571. In the Knowledge C database, there's another table within the Knowledge C database called Z structured metadata. So if I go to that table, because I found that number under the Z structured metadata column, if I go to that specific table in the database and look for that primary key 571, and I scroll all the way out to the end, I'll see a description of what that 571 is. And in that case, it was com.apple.springboard.lockscreen.scroll, which would indicate that it was a camera function on the lock screen, and that when you press that button in the bottom right corner of the phone that has the little camera indication, it'll scroll over to a camera, or you can swipe over from the left, and then it indicates that there's a camera there.
So was this some sort of attempt by the phone on its own at Face ID?
It didn't indicate that it was a Face ID at all. It indicated that it was a camera.
And by indicated cameras, did it indicate that someone was a person using the phone activated the camera?
Yes.
Okay. Next.
At 8:54 and 35 seconds, the camera use ends.
Okay. And keeping in mind the time stamp, go to the next slide.
At 8:54 and 40 seconds, the orientation to landscape starts.
Okay. And so how long was that since the camera usage?
About 5 seconds since it ended.
Next slide.
And then at 8:54 and 44 seconds, the orientation to landscape ends.
And next.
At 8:55 and 4 seconds, the backlight turns off and the orientation to portrait starts.
This is
what's happening in this one? What's happening?
Pay attention,
So
guys.
right here, the phone was previously in landscape mode, and it settled in at that landscape mode at 8:44 seconds. The backlight went off at 8:55 and 4 seconds. At that same time, the orientation of portrait starts, and this is indicative of what I was talking about earlier, when you rotate the phone while it's in, the screen's not lit, and then the screen comes on and the orientation changes once the screen pops on. It'll flip over to wherever camera or wherever the phone is turned to. At this time, orientation The portrait ends at that time, and the orientation to the landscape starts at that time. So that's exactly what I was talking about. And then
cool.
the phone stops logging those 59 steps at that time as well.
I'm going to kind of emphasize this. Could we go back 4 slides? All right. So when the camera use ends here, 8:54:35, going forward, one slide, we have an orientation change.
That's correct. To the landscape starts, yes. Orientation to the landscape ends at 44 seconds after.
Are we all
And
looking
then
at
the
our
next
phones
slide.
trying to figure out what's going trying to picture this?
So now that the screen has gone off, how long has it been since the camera use?
Let me go back in my. So it's 8:55 and 04. Since the camera use ended at 8:54 and 35, and then the backlight goes off at 8:55 and 4 seconds. So, what is that, a minute?
Minute and a half.
29 seconds?
Wait a minute, hang on, sorry. Yeah, it's 29. I apologize. My math was terrible, wasn't it?
Don't use math in
Yes.
courtrooms. It breaks everyone's head.
And then going forward, so what we had in that 29 seconds was an orientation change, and then the screen goes off.
Right, that's correct. Where are we going with it now? I just flipped the slide on me.
They skipped a slide.
All right, so let's go back to the slide that's timestamped 8:55:32. Is this where we left off?
That's where we left off, yes. So here, the backlight's on, the orientation to portrait ends, and then the orientation to landscape starts immediately when the backlight comes back up on the phone. And then the phone stops logging those 59 steps at that time as well.
And the next slide, 4
And
seconds later.
4 seconds later, the backlight's back off again.
Okay. Now we'll go kind of quickly here. The next slide comes
At
on.
9:03, the backlight's on. At 9:04 and 23, we have a missed call from Alex that starts. At 9:04 and 23, the backlight goes off.
But now let's go back to the previous slide.
One more.
The backlight went off at the exact same time that a call came in from Alex Murdaugh.
That's correct, yes.
And now the next slide.
And then we have a missed call from Alex that ends.
That's the
at
call
9.
we just saw, right, ending.
Yes.
Do you have an opinion on why the screen light would go off pretty much right when a call comes in?
The only thing that I could figure is when the phone came in, or excuse me, the call came in, that the person hit the side button to turn it off and then put it down or flip the phone over.
Do you
And
know
the
of
backlight
anything on
goes
the
off.
phone that would cause the screen to go off right when a call comes in and stay off during the call that does not involve human interaction with the phone?
No, I don't.
I'll go to the next slide.
9:05 and 44 seconds, the backlight comes back on. And at 9:06 and 12 seconds, orientation change to portrait begins.
Okay. And the next one, and we'll stop on that.
At 9:06 and 14 seconds, there's an incoming call from Alex that starts at that time.
And then the next one.
And then the incoming call from Alex ends at 9:06 and 18 seconds.
And the next slide.
And then we have an orientation change to portrait ends at 9:06 and 20
And
seconds.
stopping here, that call we just saw coming in from Alec, that was sandwiched within this orientation change.
That's correct, yes. It was in between them.
And next slide.
9:06:52, we have another incoming call from Alex that starts.
And the next one.
And then it ends, the incoming call from Alex ends at 9:06 and 59 seconds.
Now the last slide.
At 9:07, the backlight goes off and it remains off until 9:31 and 44 seconds.
And do you know from your review of the GM GPS data where the Alec Murdaugh Suburban was at 9:07?
Yes, at 9:07, he was, it was like traveling from the house or from his home to the house in, I forget the name of the city.
Like, precisely at 9:07, where was he at that moment?
The 907 would be the driveway, I believe.
Right. The driveway?
Yes.
And Maggie's phone, the screen did not come on again until 9:31?
That's correct.
And just one more time, how much motion does it take to turn the screen?
Very little. I mean, just the slightest lift of the phone turns the screen on.
Boom. Case closed. Someone else had her phone.
Yep. And the
How
steps,
can you not say reasonable doubt? Like,
and
how
the
can any
steps
jury
do not correlate with the distances that they're saying. If you believe the step data, the steps are insufficient to explain his walks. So the steps are completely incongruent with the state's theories.
Right, because his,
Yeah.
yeah, his steps, he went like 230 steps at a time that she's going 59. None of this, there's no way he could have had her phone. Someone else, we know from the touching of the phone and the lighting of the camera up, the activation of the camera, someone was handling her phone,
Please
and
answer
it
any
could not
questions
have
from the state.
possibly
No
been
further questions.
Alex.
And before that,
This is just lethal to the state.
This is the most devastating. There's the two experts have just destroyed the state's case as far as I'm concerned.
Good afternoon, Mr. Conrad. I'm well, thank you.
He didn't ask about the whole 4 minutes and 30 seconds.
Yeah, he didn't.
versus 4
I
I believe
minutes.
at the beginning of your testimony, you testified that you felt it likely there was some location data stored on Maggie's phone from June 7th that potentially was overwritten. Did I understand that correctly?
I said that there was data that was on the phone from June 8th, and that, correction, June 9th, and that data likely could have been on there had it been preserved properly.
And explain to the jury just real quick, how does an iPhone store that GPS information? In generic terms, and then if I need to get more specific, I will.
Sure, so the iPhone keeps that data, and it uses the GPS location, the GPS satellite, triangulates with the GPS satellites, and it stores that data.
Right. And does it store it in a sort of cache?
It does.
All right.
It is a cache.
And when it comes to iOS, as opposed to, say, a standard hard drive, iOS keeps certain databases caches fairly limited, correct? And it
That's
doesn't
correct.
allow them to access the entire memory available on a device at any given point, correct?
That's correct, yes.
Okay. And do you know, or at least in your training or your investigation, have you been able to determine just how big a typical cache is, at least would have been for Maggie's phone during this time?
No, I didn't research that. No.
Okay.
No, I didn't research that, no.
Okay, so you don't know how long Maggie's phone would have potentially stored GPS information at this during 2021, correct?
That's correct.
Okay.
The state raising uncertainty. I love it.
And just so I understand correctly, you agree that a iPhone will not record an orientation change if the screen is off, correct?
That's correct, yes.
All right.
It'll record at the moment the screen comes on.
Mr. Barber handed you his phone to kind of demonstrate this lift to weight thing, correct?
That's correct, yes.
And do you know what model iPhone Mr. Barber has? Did you look at it?
Don't know exactly which iPhone he has.
Okay. And do you know what version of iOS is on Mr. Barber's phone?
I do not know.
And Apple updates its iOS fairly frequently, correct?
They do, yes.
Do you know, at least, we don't know what's on Mr. Barber's phone, but do you know what the current release version is today?
It's 16 point something.
Okay. Do you know in your review of Maggie's phone, what version was on Maggie's phone on June 7th of 2021?
I believe that was 14 point something.
I'm sorry.
I think it was 14.6, if I'm not
Okay.
mistaken. It was somewhere in the 14 range.
And are you aware that in some of these iOS updates, some of these sensitivities and some of these settings can change, correct?
Depending on bug fixes and things, yes.
And are you aware of a change that occurred in iOS 15 that changed how iPhones record orientation changes, or when they record orientation changes?
No, I'm not aware of that.
Okay.
late in the trial to be suggesting that.
Well, that's a good bit that's a good expert. If that's true, that's good. Good cross, but you got to follow it up with something.
Can we go back to the?
But then their
to,
expert would have had to raise
see.
it. This guy just says, I don't know.
What exhibit was that? I believe it was it 155? Was there two? I just was aware of one. The 158? For this witness.
I much prefer the demeanor of this prosecutor, though.
He has not been in the courtroom the whole time, has he?
I don't know. He hasn't learned the bad habits.
Well, no. I wonder if he handles the technical data better on this stuff.
Yeah, I wish they would have brought in the dark-haired guy.
This doesn't have slide
He's fun.
numbers, so bear with me. But first of all, before we talk about Maggie real quick, you did review Paul's phone to a certain degree, correct?
To a certain extent, yes.
All right. And do you recall from your review of Paul's phone when the last time his phone was unlocked on June 7th of 2021?
I don't recall, no, I'm sorry.
And we can find the state's exhibit if we need to, but would you disagree if I told you it was 8:49 p.m. or shortly
If
thereafter?
that's,
8:49 p.m.?
if that's what's in the state's exhibit, I don't disagree with that.
Okay. And I believe one of your first slides here is that Maggie's phone locked. Let's see, go to 1, 2, 3 slides. One more. All right, back one, I'm sorry. 8:49:31, and your review of Maggie's phone found that her phone was locked at 8:49:31, correct?
That's correct, yes.
And it was not unlocked until when, the next day?
The next day, that's correct.
All right, and that's when it was recovered by law enforcement?
By law enforcement, yes, sir.
Okay. And did you review Alex's, you said you reviewed Alex's phone to a certain degree too. I think you said the steps, right?
The steps, yes.
And in your review, did you find any steps on his phone between 8:09 and 9:02 p.m.?
Let me go back and take a look at that. (8:09) and 9:02 p.m.
Correct.
Correct. No, I don't recall seeing that. I'm seeing the stuff in the knowledge C here.
Okay.
Because Alex would never leave
But
his
Maggie's
phone
phone's
behind.
locked at 8:49:31, and it does not unlock till the next day, correct?
That's correct, yes, sir.
Paul's locks for the last time around the same time, correct?
That's correct, yes, sir.
And Paul's phone, in your review, to recall what time the battery died on his phone?
I don't recall, no, sir.
Would you dispute me if I said, and we can find the exhibit if we need to, his phone shut down at about 10:34 p.m.?
If that's what's in the report, I don't dispute it, no, sir.
And would you agree with me if I said that Paul's phone locking at 8:49 and remaining on until 10:34, first of all, that's about, what, hour and a half or so?
That's correct, yes.
And do you know his battery state when his phone locked at 8:49 p.m.?
It was in low power mode.
So it was less than 10%, 2%, something like that?
Yes, that's correct.
All right. And would you agree with me when the fact that his phone remained on until 10:34 be indicative that it wasn't really handled much at all or used at all?
Yes.
Okay. And did you find any other evidence of any usage on Paul's phone after 8:49 that you can recall?
No, I didn't.
Okay. And when I say use, just so it's clear between us, I mean either answering a call, making a call, reading a text, sending a text, orientation change.
No user interaction
Okay.
with it.
All right. And so let's talk a little bit about the orientation change for a minute. So would you agree that the most likely reason for an orientation change is human interaction, meaning humans using the phone?
Yes.
All right. Are there any other possible explanations when you see an orientation change, or any other explanations that you, in your opinion, that could explain an orientation change?
Only if a phone, was in one position, lit up, fell off, and landed in another position.
Okay.
But no.
And when you see a series of orientation changes, 30 seconds or a minute between each orientation change, it'd be difficult to explain that by a phone just kept falling on its own, correct?
Repeat the question, I'm sorry.
If you see a series of 3 orientation changes, just speaking hypothetically for a moment, if you see a series of 3 orientation changes, say 30 seconds separate them or thereabouts, or a minute separate them, could you explain that? Would it be very likely that a series of falls caused those orientation changes?
It depends on how many falls it was making, but, being jostled around in a pocket and the light on, being turned, if it's in a person's hand and being turned back and forth, and that would be the only thing I could indicate with an orientation change.
Okay. All right, can we pull that slideshow back up, please? Let's go forward 1, 2. Okay, 8:53:15. There you go. And this is when Maggie's phone starts showing some steps, correct?
That's correct, yes.
And you would agree that the most likely explanation for this is the phone is moving in some manner, correct?
That's correct, yes.
And those accelerometers are recording, or the bounces are jostling, that would most likely be explained by steps, correct?
That's correct, yes.
Now, you can't tell us who's carrying that phone at this time, can you?
No.
All right, next slide. All right, and so at this 8:53:20, you say there's some Siri usage and a squeezing of the side button. And let's just, is that the only explanation of why you'd see the Siri pop up on a phone, is squeezing the side button, or are there other possibilities?
There's another possibility of her saying, hey Siri, and then that happens because it's a Siri user interface.
Okay, so there could be another explanation, but it's most likely someone squeezing the side button saying,
Could be
hey
the side
Siri.
button say, hey Siri, but it's a user interface with it.
Okay. All right. Go to next slide, please. Actually, let's go to 8:54:34, please. Should be one more. One more. There we go. All right, and here you say the camera gets activated, correct?
That's correct.
And you think the most likely explanation is somebody swiped the camera symbol on a locked phone, correct?
Right, either swipe the camera or touch the bottom button because it's coming from the springboard lock screen.
Okay, we say bottom button. Which button?
If you're looking at an iPhone and well, my most recent iOS, I think it's 16 point something, in the bottom right corner, there's a button that you can touch and hold and the camera comes on. But when that happens, it comes over from the left and the camera scrolls over.
Okay. And then next slide. And then 8:54:35. This is 1 second later. The camera use ends, correct?
That's correct. Yeah.
And so, in your opinion, based off the fact that that was used for a total of 1 second, do you think that was someone intending to actually use the camera and take a picture?
I wouldn't know, but I wouldn't think so. I mean, that's just a.
But the camera's only open for a second, correct?
Right. They couldn't have taken a picture in a second.
All right.
I don't know how long I was
All right.
muted. But
8:55:32.
you guys missed gold. You missed gold.
Okay.
I'm sure it was a banger.
We see the orientation change here at 8:55:32. Next slide. And the backlight goes off at 8:55:36, correct?
That's correct, yes, sir.
We go to the next slide. And the backlight's back on.
This is actually really interesting
9:52,
to me.
So that's roughly how long?
He seems so
Is that
competent, so
8
calm.
minutes? I don't know if I'm
learning
gonna
about
make you do
all
math, but.
Yeah, about that, yes.
And so the screen's off for that 8 minutes, correct?
That's correct.
And so, would you agree with me, it does seem likely someone's handling that phone Maggie's phone between 8:53 and 8:55, correct?
Yes.
All right, we see orientation changes, we see the potential button being pushed. Someone's got that phone in their hand, correct?
That's correct.
You can't tell us who, correct?
No, I can't.
All right. And then, at 8:55:32, we see kind of an 8-minute gap in activity, correct? Between
Yes.
8:55 and 9:03, correct?
Yes.
Almost as if somebody put that phone down.
Or in their pocket.
Whoever had it, correct?
Correct.
And you can't tell us where they put that phone down, right?
No, sir, I can't.
Could they put it in a vehicle,
That's very possible. I don't know.
a golf cart?
I don't know.
All this uncertainty.
Now we have golf carts. I don't know what's happening. I don't know what the state's doing at this point.
They're creating reasonable doubt.
Okay, let's go to 9:04:23. Yep. All right. And we see this incoming call from Alex. You
Yes.
said the screen turns off almost immediately, correct?
That's correct, yes.
In your opinion, you think somebody actually hit the button to turn the
Somebody
screen
shut
off?
the screen
correct?
off, yes.
Okay. But the screen comes back on at 9:05:44, if we can go to that slide. Correct?
Yes.
And then 9:06:12, we see an orientation change, correct?
That's correct, yes.
And 2 seconds later, we see what? Next slide, please. What is this? What is
That's
this
an
indicate?
incoming call from Alex.
Okay. 2 seconds after the orientation change starts, correct?
That's correct, yes.
Okay. And then go to 9:07. Okay. And the screen goes off at 9:07, correct?
That's correct.
All right. And stays off for, what, roughly 23 minutes?
Yes.
And you just testified with Mr. Barber that Alex's car was sitting just outside his house, correct?
That's according to the documents that I reviewed. yes.
And I don't know if you have this information in front of you, but did you determine when that GPS data shows his vehicle start to move?
Yes,
After 9:07.
Oh, after 9:07?
Well,
The-
first of all, is his vehicle stationary at 9:07?
No, it's in the driveway at 9:07, but it starts at the house at 9:06 and 52 seconds PM.
When do you start to see motion, or do you?
9:06 and 52 seconds is where I start to see the motion there.
Okay. And 8 seconds later is when Maggie's screen turns off?
Yes.
For 23 minutes?
Yes.
And you agree that a iPhone, at least with version 14.6, when the screen's off, it will not record an orientation change, correct?
That's correct.
And you agree with me that you don't know what version of iOS that Mr. Barber had on his phone that you just did that demonstration?
That's correct.
Did you conduct any tests with the phone with 14.6 to see what movement can cause it to, or what can cause that phone to the screen to come on?
I don't have any 14.6 phones.
Okay. All right. Take a look at it.
Wow.
Wow.
Unscathed.
That was ineffectual.
Thank you, Mr. Conley.
Yeah.
Completely unscathed.
Yep.
Redirect.
This is just going to be gravy.
Mr. Sturgis, you were asked about
Yeah, exactly.
iOS
Doesn't
version
need to say
15
anything.
and a change in orientation behavior. Is the raise to wake feature something distinct from orientation behavior?
No, the raised to wake is a separate from orientation behavior. Raised to wake's a separate application within.
Is
function
raise to
within.
wake the feature that causes the phone to come on with slight movement?
Yes.
Do you have any reason to believe that the raise to wake feature that you've already testified was active on Maggie Murdaugh's phone works any different than any iPhone today?
I have no evidence to prove that, no.
And again, you can refer to your notes, when Alec Murdaugh's SUV passed the location where Maggie Murdaugh's phone was recovered, the side of the road, was the screen off?
The screen was off, yes.
It was off as he approached it?
Yes.
And again, how much movement does it take to turn the screen on?
Very little movement.
And this is a separate issue from orientation changes.
That's correct.
But we're talking about, are we talking about movement activating the screen?
That's correct, yes.
Are we talking about the screen being sideways or up?
No, we're not talking about the orientation. We're talking about the actual raised awake function on the phone.
The camera usage, in fact, no picture was taken that you're aware of.
Right, that's correct. I didn't see any photographs there for that
But,
time.
but is it your opinion, what is your opinion about whether someone deliberately activated that camera?
I mean, they could have, could have been an accident. I don't know. I don't know what the person could have been doing, but it was a user interaction with the device.
And there was talk about phones falling to change orientation. Can a phone change orientation without actually falling?
No, I mean, there has to be some type of movement for the phone from portrait to landscape.
Right, but you don't have to drop the phone?
No.
So
if it's sitting upright, I mean, if it's sitting on its side, I can flip it this way and the orientation changes.
if somebody's running with a phone, can it change orientation?
Yes. Those are user events that can cause that.
Can we pull up what's been previously admitted as Defense Exhibit 45? This is, as I just said, previously admitted. Do you recognize this as GPS data in a cache database?
This looks like a yes, cache for the ZRT cell location database. Yes.
And what's the timestamp for the first entry?
It's 6/9/21 at 2:51 and 21 seconds p.m.
In your opinion, would it be fair to say that if this phone had been extracted or put in a Faraday bag a couple of days earlier, we would have GPS data from 6/7?
In my opinion, it's likely that we could.
So lost
Let's call it the
exculpatory
step data
evidence.
exhibit. The Apple step data exhibit.
This is why he didn't dive into it on direct, but he put it into evidence on direct so he can talk about it on redirect.
Okay, we previously talked about this.
State didn't
Alex
touch on
Murdaugh's
it. Just missed it.
Between
Now we get to the
entries
4 minutes.
27 and 28, you see those
It's
time
beyond the
periods?
scope.
Just want to remember that and go to the next page.
I'll allow it.
Here's the
Here
Maggie
we have
ones.
Maggie steps.
He didn't mention
Are there any
Maggie
steps,
on direct.
periods of steps that correspond between Maggie Murdaugh and Alec Murdaugh?
No, I don't see any.
So there's no period where both phones are stepping in the same period?
No.
Boy, that is it.
And if we stay on this one, if we look at entries 5 and 6, the distance is almost identical, 31 meters.
Yes, it is.
Are the steps different?
The steps are different.
Is that a significant difference?
Not a significant difference for the 5 and 6, no.
So 59 versus 43, so is that 16? It took 16 more steps to go the same distance?
Yes.
So does that indicate shorter steps?
Shorter steps, yes.
She's running. Not fast enough. Not as fast as the 300 blackout round.
That's outside the time frame. That's at 8:30 something, so that doesn't matter.
Oh, yeah,
So
okay.
The final question is to, emphasize here. You can't tell us what a phone would do tossed out a window. That's not your expertise.
No, I can't.
But you can tell us how much motion it takes to turn on the screen.
Yes, very little motion.
And you've
to turn the screen
demonstrated
on.
that.
Several times, yes.
And that feature of the iPhone was active on her phone.
Yes.
And it is totally separate from orientation behavior.
That's correct, it is.
No further questions.
Killer.
Anything further?
We're done, Your Honor.
You said you
Oh,
reviewed
no.
Paul's phone. Did you review the video that's been called the Kindle video in this case?
Yes, I have seen it.
recognize his
And
voice?
did you have any information that would lead you to disagree that that video was recorded at 8:44, about 55 seconds on the night of June 7th?
No, I don't have anything.
And the location data, would you agree the location data for that video was recorded at the kennels on the Murdaugh property at Moselle?
Yes.
Okay. All right. Mr. Barber was talking to you about steps data. And just so it's clear to the jury, and I'm going to speak in hypotheticals here for a second, but if you see the iPhone record steps over an interval of about 5 minutes, for example, it records a certain number of steps over that 5 minutes. Does that mean, is that phone trying to tell you that someone's uniformly walking at an exact pace that keeps them moving over that entire 5 minutes?
No, not necessarily.
Okay. They could stop at some point in the middle of that, correct?
That's correct, yes.
All right. And so they could stop and pick something up in the middle of a period showing steps, correct?
That's correct. It's just the steps between those two times.
All right. So you can't testify, you can't tell us if between, pull up the steps exhibit real quick. Next slide. All right. And looking at entry 28 on Alex's phone.
Entry what, I'm sorry? Couldn't hear you.
28.
28?
Yep. And between 902 and
It's about 240
906, we see,
seconds.
what, 283 steps, is that correct?
That's correct, yes.
All right. And
It's not 240 seconds. It's 240.
you can't tell us if his phone
69
stopped at any
seconds.
point between those,
No.
what's
no,
that,
it's just
roughly 4 minutes or a little over 4 minutes?
It's a
there's
state with all the data that
283
doesn't
steps
tell us
between
anything.
Those two times.
It's
So he
bad
could've walked
data. How do they
200
get
of
the
those
wrong
steps in the
time?
first
902,
2 minutes and then only walk
27.
slow down for the rest of
It's
the
4.5
Right.
minutes,
correct?
which is
Or it could have been vice versa. Or
240
it could have
is
stopped
only
for an
4
entire
minutes.
minute somewhere in there. You can't tell us any different, correct?
It'd be unlikely to stop for an entire minute. I think if you stop for that long of a period of time, a new entry would be made, but.
Do you know, is there a cutoff for iOS
No,
that would?
I think that, just based off of what I'm seeing here, I mean, for instance, entry 29 and 30, you have about a 3-minute gap there. And,
Okay.
yeah,
So maybe if he stopped for a minute, it would have started a new entry? is what
could
you're
have.
saying?
It
All right.
could
But if he
have.
had stopped for a shorter period of time, wouldn't necessarily have, correct?
right.
Okay.
maybe he was like he became Usain Bolt. He stopped for 3
And
minutes.
finally,
then went
Mr. Barber was
280
asking
steps
about distance.
in 1 minute.
And I
He was
think
cutting
I wanna
left.
Make sure I understood you correctly. I think you testified that you would consider the actual steps count to be more accurate than the distance. Is that
I
correct?
would, yes.
Have you found any research or studies that has measured or the accuracy of steps or distance in iOS devices?
I have, yeah, and for instance, I've had cases where the step count and the GPS data is different sometimes.
Okay. And in your opinion, the steps count is probably more the most accurate?
In my opinion, yeah, the steps count is more accurate.
Okay.
Okay. Okay.
Okay, then the step count, the steps,
Step down.
the steps account, the Alex phone steps account for 0.15 miles. The distance from the kennels to the house.
Ladies and gentlemen, that
Is
is
point
it
two.
for today. We
Hey.
resume at 9:30 tomorrow. Please
All
do not,
right.
please do not discuss the case.
Let's see if there's anything final from the court after the jury leaves.
I'll put it in the chat here.
Oh, are they done? Are they done? Are they really done?
It's that time, 5:15 p.m. New Jersey
right.
time.
I
Joe.
want, so first, before you leave, hit like and subscribe kindly, and make sure you pay some love to my guests here. I also want to remind you that tomorrow morning I am not going to start till 11 o'clock. I know that legal. Hold on a second. Let me make sure nothing's happening here.
Anything further on this day?
You'd like an
Yeah,
ambulance.
they're gonna, yeah, they're important.
We'll resume at 9:30. That's my rule.
All right. So I will not be resuming at 9:30 tomorrow because I am going to my son's bris is tomorrow morning.
Joe, Mazel Tov.
Thank you very much. And it is taking place. It's starting like at 8:15 in the morning, but it's an hour away, and there's going to be like a breakfast afterwards. So I'm planning on getting back here roughly at 11 o'clock. I'm going to set my stream up for like 10:30, but I'll as soon as I get back here, I will start up. My plan is assuming Alex Murdaugh is not the first witness tomorrow, which I would be shocked if he is. Assuming he's not, I'm just going to roll right in with wherever we're at. If in fact he is the first witness starting at 9:30, I'm going to start from the beginning of his testimony, and I'm going to end up playing from behind. So that's
You should do that anyway, because you
What do
can
you mean?
catch up through lunch and stuff like that. You know what I mean?
So you think I should just roll? I should just start from the beginning?
I would just start at the beginning, whatever time of day you actually start, and just do it on a 1.25 or 1.5. Get cut through the breaks. You'll catch up quick.
You think so? I'm going to do a quick poll on that. Should we watch everything? And
Because these
that's not-
defense witnesses are great. So they're going to have the
Yeah.
memory expert, I would expect. They're going to have some kind of medical examiner of their own, I would expect.
Yeah. You know what? I'm gonna make a quick poll on that, which will be a serious poll as opposed to the joke polls that I tend to.
Yeah, I
do.
can't do it, folks. I'm unavailable tomorrow. So sorry about that.
Yeah.
Otherwise, I'd be happy to start the stream in the morning. But
So I'm going to set up a quick poll on that. But so I just want to let you know I'm not going to be here at 9:30, and I'll take a poll as to whether I should just start from where we're up to or start from the beginning at when I open up tomorrow. Meanwhile, I was wondering if Steve.
Yes.
You're a lawyer, right?
They keep telling me they don't turn down my paperwork.
Can you tell the folks where they can find you and what you do?
Well, yes, I'm an assistant public defender in Florida. I do criminal appeals, although I'm board certified in criminal trial law. I do also help strategy with our trial teams. I train our trial teams. I train our appellate teams. I write books. So if you want to go to stevegosney.com, you can find all of my linkages. I just updated my locals channel to stevegosney.locals.com in compliance with Joe's strict mandate. And I have a Rumble channel, and I'm going to be on tonight going through. It's going to be my first solo effort on Rumble. So I'm just going to fly and try to do it all by my wee little self. And I'm going to demonstrate some geometry with my AR, which is right over here. And I have a ruler right over here. It's on Rumble only, so I'm not going to get kicked off of any YouTubes. But I'll demonstrate what they're talking about, the geometry with that. I'm also going to talk about a lot of the issues that I see in the Alex case that I can't get to on these streams. And we're also going to celebrate 3,000 subscribers on Rumble. Thank you. So go to my Rumble channel and subscribe. Boy, I got a new book coming out, which is called Prepare, the Handbook for Individual Freedom, which is in pre-publishing. Author Nick Rekieta is going to do the forward. And I have a book already called Ideas and Answers in Law with this guy right here. Andrew Branca did my forward. And I'm very happy that all the people that bought that book have allowed me to write my second book, which is very important for the world. And so I got more, but let's stick it there, and I'll hand it off up to the guy, the man above, the dean of the American Law Courses School, Andrew Branca.
And I put the poll up there. So, yeah, would the dean like to say a few words before I get into super chats?
Yeah, American Law Courses. I don't have a slide ready for American Law Courses. I don't think. Hold on. Maybe I do. Maybe I do. Maybe I have a nice little cartoon. No, I don't. Sorry. We're going to start promoting the summer semester pretty quick now. So keep your eyes out. You can learn more about it, though, of course, by going to AmericanLawCourses.com. We talk about all the courses currently running that we ran in the fall, that we're running in the summer and in the fall of this year. These are law school level classes for the layperson. So you can gain a law school level understanding, expertise in the law. This is not an accredited academic institution. If you want accreditation and a Juris Doctor degree, go to law school. But if you don't want to incur
and pay $60,000 a year for that,
and time and commitment of enrolling in law school, you just want a solid mastery of the law at an expert level, American Law Courses are a great opportunity. And by the way, if you take our courses and then decide you like it so much you go to law school, you will kill law school. Every other student there will have been getting these topics, criminal law, property, evidence for the first time when they sit in that room, in that auditorium, in the law school. You'll be taking it for the second time. You will crush it compared to your peers. Learn more.
And that's all that matters. You just have to crush it compared to them. You can be an idiot as long as you're slightly less of an idiot than the people in the room taking the test with you. So.
But you won't be an idiot because you'll have graduated American Law Courses at AmericanLawCourses.com. Learn more, sign up, make yourself smarter. Make yourself the American citizen the founders wanted you to be.
Indeed. All right. Sean, you got any thoughts here? Oh, yeah, I was going to say. Oh, well, all right.
All right.
So we'll give him a chance, assuming that the cloud of cancer hasn't gotten him yet, hopefully. So I'll give him a chance to weigh in. If you guys want to stick around, you're free to stick around. I'm going to start going through super chats. You can bolt if you want to. It's up to you.
I just got here, man. This is fun.
I would never throw you out.
8
I'm
p.m.
not throwing anyone out.
Hey, before everyone
8 p.m.
leaves, Steve, did you have a couple theories you wanted to share?
I got so much. What theories?
I'm just wondering if you want to do that before you hit the super chats.
Yeah,
well-
yeah, I appreciate that. That's probably a better way to approach this.
Well, the one thing, there's so much. In fact, I have a document on my locals channel, and I've updated my locals to stevegosney.locals.com. But on my locals, I've posted, number one, the timeline that we've been working off of that was created by one of my fans and that we've spread around to Nick and everybody else. So I've posted the timeline. I've also posted a summary of questions that I have on the Murdaugh trial, reasonable doubts that I've created. I've also posted a qualification, which I need to update now, on the steps, as well as an excellent, and I see he's in the Rumble chant, Snorkel Boop, he's an expert on Facebook and iPhones and things, and he has some very interesting insights saying that that Maggie was on the Facebook iPhone up until like as late as 8:54, which greatly widens the timeline by 10 minutes from the point which Murdaugh was at the kennels. So that is again consistent with the Bronca theory. So I'm going to go through all of that very carefully solo on my Rumble channel.
But I think
at
the phone expert from today kind of refuted that, right? I mean, he basically, when he was giving his second by second breakdown of the usage of Maggie's phone, there was no indication of Facebook usage at 8:54.
I know that, but I have an expert on my locals channel, which we'll see how this all gets tied together. Yes, I agree, but I don't think that it's necessarily true. Well, one of the flaws in the state's theory is that they're saying once the iPhone stops communicating, that must be when they're killed, and that is not a reasonable assumption.
I do think that this last witness here, I mean, that's a digital alibi.
Yes.
That is a digital alibi. That is far more compelling evidence than any physical evidence presented by the state. It's not even close.
Not even close. And I would say, number one, in fact, I almost want to re-listen to it. But then also the geometry, which I'm going to demonstrate with my AR and my ruler to show why it had to be a shorter person who made that shot against Maggie into the thing with the trajectory. Brilliant.
11-year-olds?
No, it was not. There was no testimony as 11-year-old. It was testimony was between 5'2" and 5'4". And there's also we're also going to address the thing about people kneeling and people lying prone. We'll talk through all of that tonight at 8 p.m. at Rumble. Rumble only.
Yeah, and links to his Rumble are down below. Links to everyone is down below, except for the American law courses that he just dropped on me out of the blue. I can't keep up with you. You're too busy. You work too hard. Yeah, but any other thoughts about the testimony we heard this afternoon, gentlemen?
I thought the defense did a great job today. The prosecution looked like it was flailing and raising reasonable doubt if it was accomplishing anything at all. I'm sorry that I won't be able to hear the defense directly tomorrow.
Yeah.
But that's because of this crazy judge, making this a lifetime trial opportunity.
I know you and Nick, you guys have sat through this for weeks and weeks, and you're probably going to miss Alex testifying, and you're going to miss closing arguments, and get back just in time to have the waiting game on jury deliberation.
Yeah.
So,
well, while we're waiting, I guess we can listen to closing on replay.
Right.
But we'll have to see how that goes. But in any case, I am going to take off, folks.
I thank you for joining me all these different days. I want you to know you're a great lawyer, you're a phenomenal personality, and a really good friend. So I just want to say thank you, and please, you guys, make sure you check out his work. I'm sure you're going to be more than satisfied. It's one thing to have a gun to protect yourself and your family and others. It's another. It's another thing understanding what steps you need to take before you use that in self-defense, so you don't spend the rest of your life behind bars. So I highly, everyone I've ever heard of who's ever taken his course on self-defense or his American law courses has had nothing but rave reviews, and I'm sure you will too. So I urge you to check him out as well, Steve and all my other guests.
Yeah,
So
I'm happy
thank
to be
you
on
so
any
much,
time. I mean, I've got a YouTube channel, but I don't really consider myself a YouTuber, so I'm not particularly trying to grow my channel. So if I can do this stuff on other people's channels, that's I'm more than happy to do that.
All right, my
Steve,
brother.
nice talking with you, man. Joe, I'll see you on Sunday, at least, Steve, in Vegas.
Yep.
If not before. Joe, talk to you soon. Have a good night, everybody. Bye-bye.
So is there anything else we should cover before I get to whatchamacallit? You're muted. Still muted.
This is my Rumble channel. It's 8 p.m. Eastern Standard Time. It's going to be me flying solo for the first time, celebrating 3,000 subscribers. I know I'm not near, and I know that you're at like, what, 90+ thousand. That's pretty impressive.
Thank God. I've been doing this a little while longer than you, so, but I'm sure you're gonna zip right past me pretty soon.
Well, I just got this little corner of the world, my little Rumble domain,
You're great at this. A-Train says, if he loses this trial but wins the appeal, because the judge was too permissive with evidence, couldn't the state just wait to retry until after judgment on the financial crimes so the same evidence would be permissible?
Okay. Yes, with a qualifier, because your question contains a contradiction. The question says if he wins the appeal because the judge was too permissive with evidence, I'm assuming the financial crimes evidence, in which case the appellate court would say you shouldn't have allowed that in, and then the retrial would not allow the evidence in the retrial because of the earlier appellate ruling. So that's a lot of ifs and a long way away.
It's also the point that I think you're trying to make is the fact that he would get convicted doesn't make it more relevant to this murder trial. Just because case in point, many of us, including myself and most of the people who came on this panel, think he's likely guilty of the financial crimes. Even if he was convicted of it, that doesn't mean that it's relevant to did he kill his wife and son. And if it gets overturned on appeal because of too much permissiveness, it likely would be because of a lack of relevance. So at least in part. So in that sense, if it gets overturned, even if he gets convicted in between the retrial, now in the retrial, that likely would not be a basis for the second trial of double murder to incorporate the financial crimes. Knickers says, if the defense doesn't ask any questions about the financial stuff with their own witnesses, could the state still question about that? I think you're talking about if Alex testifies, and frankly, we saw today that they did. It seems as if the judge is certainly going to be permissive in that. So I would expect yes, because they're basically trying to say, certainly if there's character witness evidence that comes in, if there's character testimony, they weren't able to ask the experts because it's not relevant to ask them about the financial stuff with respect to talking to experts. When you're talking to
this judge would have allowed it though. Could you imagine like the guy is on the cell phone? It's like, would it affect your analysis if you knew that he stole all this money? Well, no,
would it affect your analysis on Maggie's phone usage if you knew he stole his money?
Yeah, they could. I mean, why not? Oh, objection, Your Honor.
No, it would not. Overruled. I'll allow it. Jay Thomas, Joe, that message about Miami bringing the heat sounds like a hit warning. Alec knew it was coming at some point. Telling you.
I'm not bought into the hitman theory. I was listening to you in the background, and I gotta say, I'm not on.
You're shaking your head at that one.
I'm shaking the head. I think it's a Paul boat accident related. Vindictive, angry hit. But we all have our theories. It ultimately doesn't matter what we think. What matters is the jury finding reasonable doubt or not. That's the standard. But
Kelly 2 on Rumble says potentially criminal Sean wins streaming guest award for attending while inflicted with the world's worst virus pandemic in world history. The man. Indeed. Oh, I forgot to tell what's his face. It's cold and rainy in Vegas, snowing on or near the mountains.
The wife will be happy. I'll be in Vegas.
I'll share that with you. Yeah.
Yeah. We're gonna look it up before we leave. No problem.
Well, I gotta get rid of my Facebook because I hit the 8-hour mark and it doesn't. I gotta take this off of my.
I updated my little context for the downward thing because everybody's asking, "What's your locals? What's your Rumble? What's your everything's accessible through SteveGosney.com," but everybody's asking that, so make sure we got it.
They used Hitler's pet dogs to test the poison he would use to kill himself. This was when I was basically saying that it's hard to understand how he can kill his own wife and son when this guy couldn't even put down a dog. I had all these people telling me Hitler loved dogs. Hitler loved dogs. And I'm
no. Well, okay. How much do we know?
Hitler didn't kill his family either.
Well, no. He killed himself with a revolver. He killed himself actually with a what is it? The same gun that James Bond used. And he killed himself with a revolver, and his dog's name was Blondie. And he did love dogs, and he was a vegetarian at the end of his life. So who knew?
Right. More random facts. Thank you, brother. Knickers says, what if he was speeding back because Maggie wasn't answering and he knew there was money owed to bad people and there was something to be worried about? Maybe. Possibly. Who knows? Oh, Snap It Steve says, if you knew you're effed on the money crimes, drop dimes when you're on direct, or am I wrong? Oh, and Joe, the VA will be paying for my law school at Syracuse. Oh, because I think this is the guy who was asking me about law school the other night, and I was like, dude, you're building $180,000 worth of debt. Well, instead of earning, like, let's say $300,000 during that time, and over 3 years, that's a $480,000 loss. So you're saying you're not building that debt. Okay. So instead of it taking you 9 years to catch up, it'll take you 6. Okay.
Yes.
I mean,
Hitler killed himself with the Walther PPK. That's what it was. Sorry.
It was either him or Bond. Slick says, are you going to cover the trial of the Uber driver in Austin who shot the BLM guy who was carrying an AK? There's a hearing listed on the docket for tomorrow. Daniel Perry, Garrett Foster. I am not familiar with this case, but now I am curious about it. You piqued my interest, Slick556. Right now I'm in Alex Murdaugh mode. If it's starting tomorrow, there's a hearing. I don't know. A hearing doesn't mean necessarily there's trial coming anytime soon. That could be many moons away. Many moons. That's a F Troop reference right there. Jana, are you familiar with F Troop?
Nope.
All right. Jana Bell says, could Maggie have had AM recorded on his phone calling Bubba? Okay. I use recording of chickens on my phone to get my dog's attention when not listening. Oh, so you think that, okay, in other words, it wasn't really him live. He wasn't there, but it was a recording of him being played. It's hard to understand for people who likely had no reason to think they're about to die in 5 minutes, why it is that they would be trying to frame Alex for being there with him not actually being there. So is it possible it was someone playing a recording of him calling Bubba, saying, here, Bubba? And that's what they heard? Yes? Does it seem likely? I think that's I think that if that's what you're down to, you're already beyond reasonable doubt. Because I think, it's not Martians, but it's like, why would that be happening at that moment that she would be playing that when she doesn't have no reason to think she's about to die? It's just an innocent Snapchat, recording, whatever. Viola Pride gives you an update. Vegas weather update. It's now snowing in town. Bring your coat. Bring your coat, brother. When are you flying in there?
Tomorrow, Saturday.
Oh, so hopefully it could be much warmer by then. Yeah.
No problem.
No problem. Brian Miller says, did you see that Kyle Rittenhouse has another lawsuit? This one is from Gage Grosskreutz. Yeah, that one made me laugh. And laugh and laugh and laugh and laugh. The guy who admitted under oath that Kyle did not shoot at him until he trained his own gun at Kyle's head thinks that he's going to win a lawsuit. Okay. Good luck with that.
Take your shot. Take your shot. Take your swing.
Take your swing. Take your swing. I'll tell you this much. I thought he had a lawsuit at the time, and then it got dropped. So I'm not sure what's happening there, but whatever. I did hear about that. Thank you, Brian. Flux, my dog destroyed a painting I did. Can I admit that for evidence too? Because I didn't see my dog do it, and the prosecution says he's a bad man, so why not? Gorn Pop, buffering, lasers. This is balloon. Are those balloons? I think that might be Chinese balloons. I don't know. Chris B. Joe, explain how you were convinced Alex supposedly witnessed brutal murders, then visited mom immediately after, calm and normal around caretaker.
Joe, explain that.
Okay, so I will admit that I did not watch much of the early witnesses, and so I did not know about that when I was speculating about this whole thing. I don't know how much that caretaker saw of him. I don't know how much interaction they had, whether he was able to keep himself composed for the 30 seconds that he's passing her. It doesn't. We don't know how much interaction there was there. Was there testimony about how much interaction there was? Was he sitting there having coffee with her for like 10 minutes, talking about his mom and dad? Did you watch it?
I've watched so much of this trial; it's unbelievable.
Did you see the caretaker testimony?
Yes, I did.
So, did the caretaker express how much time she spent interacting with him during his visit there?
There's been zero evidence of any kind of disruption or attitude change on the part of Alex during that visit.
Okay, but my question is, maybe there wasn't that much interaction. Did she talk about how long she was talking with him?
I can't remember specifically. Okay, so maybe
my point is, if he just spent like 5 seconds, saying, hey, Nana, whatever her name was, Roxy, and she didn't really interact with him much, that she might not have had much of an opportunity to observe his deep consternation over the fact that he just saw his son's brain hit the ceiling of the kennel.
One of the things that one of the reasons I'm doing Rumble only for now, if YouTube wants to pay me, nobody's paying me except you guys. And I'm too complicated. I got a real job, but I'm going to be demonstrating some stuff with my AR tonight to show what the geometry is and what the things is. And YouTube would get me demonetized and banned. So screw them.
Indeed. Resist Impulse. He was charged because perjury by lead investigator. Yeah, that was part of the reason he was charged as well. Yeah. Tom R. Is the "I wasn't at the kennels" a false exculpatory statement? Yes, I guess. Could you meaning when he says "I wasn't at the kennels," so I couldn't, i.e., I couldn't have been the murderer, that was false, and he was trying to exculpate himself in theory. Could you explain weighing that against other exculpatory evidence such as Maggie's phone and the shot angles? And what I would tell you is we can have a logical explanation that is very easy to understand, that we're trying to peer into why did he make this statement? Did he really know he was lying, or was it possible that, like any other human who learned that his wife and son were brutally murdered and discovered their bodies, that maybe he blocked out of his brain that the last time he saw them happy and healthy was at that same location an hour earlier? Is that so shocking? What would be shocking to me was if all of a sudden he had like a better javelin throw than anyone else while holding a phone, and could manage to throw her phone from his driveway to the side of the side of the road. I don't know what, half a mile away, and without it changing anything, and staying in its still silent mode while it's, without the backlight coming on, and for one reason or another that he was able to do that for half a mile away, because that digital evidence is the best alibi in the world for him, that he could not possibly be the one who was holding her phone.
The thing that the state is really hanging their hat on, and a lot of pro-guilt people are saying, is that this is a lie. I think that's going way too far and reading way too much in that statement. I think you're putting way too much credibility on somebody's memory and recollection. My understanding of memory and the way people react to things is very different than they're putting so much weight on this as a lie. It could be misstatement of a false memory that he created. It could be a misunderstanding of what the question was. It could be, and he repeated it multiple times. But those repeating, once you hardwire a memory, even if it's false, you believe that's what it was, and you're putting it in the context of this very traumatic event. I really do not. I think they're putting way too much emphasis and saying this is a lie.
But you know why they're putting this emphasis on? You want to know why?
Because they got nothing better.
And it's also, that's why South Carolinians, to a man, practically believe he's the murderer. They walked into this trial knowing that their potential jurors all thought he was the killer because everyone knows he lied about not being at the kennels and because they know he's a terrible human being. So he's a terrible human being. He lied about being at the place where they were murdered, moments before they were murdered. Obviously, he's the killer. So that's why they're so married to this as being sufficient. You see what I'm saying? Like, it's not that they just decide they went with this in part, I'd bet anything, because they know, they read the tea leaves as far as what the locals are all saying. You know what I'm saying?
Right. And people want to solve the crime. And think about, you're interrogating this guy right after this insane event that's really a traumatic event from hell, and you're interrogating him, and then you're expecting his memory to be perfect. And by asking the questions, you're going to find something that's inconsistent. That is an unreasonable expectation to place on any human being in that event. And then the thing is, by generating the question and the person thinking and generating the answer, you can create a memory. And then you're like, yes, this is what happened. Now you've told the story and you've bought into it. And you've created the memory of the narrative and you repeat it. I don't remember. That's what happened. That's what happened. Even if it's falsified by later evidence, this is the way memory works. This is fact. I'm not like speculating. This isn't like making up excuses for Alec. I don't know him from anybody.
Right.
I'm just saying that's the way memory works. And by expecting perfection from somebody and to say, well, if he lied, he did it, that is a big mistake.
Yeah. Okay. If Cousin Eddie had been successful at the roadside, would the state have dropped the murder investigation? Yeah, he'd be dead. You know, at least against him, they would have. Kyle Cowan says, I've been to so many shotgun massive head traumas. Occasional agonal respirations, pouring blood, pulse gets checked for a layperson, maybe reflex. I hope you're okay. Tyler M. says, as if we really needed any more evidence of the complete and utter incompetence of the SLED team in this case. But my word, we know Alex stole, but I don't believe for a second he's a murderer, and I agree with this totally. Yeah. Suzanne, thank you so much for the thoughtful super chat. Much obliged. God, I hate to stay in the judge. Joshua Nofsky, there's a reason for the phrase good enough for government work. Nancy, with a double homicide, all entrances should have been locked down. What a mess. If I was an innocent Alex, I would say to my friends, stay away from my property. Not sure where this killer might be.
I don't, this is, again, how do you
I
know
don't think
how you
he's-
would react? How do you know how you
in the
react
moment that's what he'd be saying to them?
We
we
know
leave me alone with the killer here.
Every human being on earth reacts the exact same way to a double homicide of their loved wife and son. Is that true or false?
Probably, almost definitely true beyond a reasonable doubt.
No, that's false. You didn't listen to my question.
I did. I was making a joke.
Answer the question, Joe.
It's not, obviously everyone reacts differently. Lancelot says, oh no, the poor cop's getting second guessed and criticized Crimea River. Yeah, that's what he was saying. You're questioning the effectiveness of SLED. He's like,
yeah, that was absurd. That cross was terrible.
He was awful.
That
He was awful.
Awful.
Yeah, the state did way worse in the second half of the day compared to this morning. I mean, I thought this morning, I didn't like the tactics that Creighton Waters used, but I had to recognize its effectiveness. I don't like it, but I have to recognize that a lot of people probably has some sort of weight. But the afternoon, they were just useless. Vince Clortho says, how's Alex paying for his defense? So someone else asked that later on also. And I saw someone comment that, you see, he asked it twice, actually. I saw someone comment that he had $600,000 that was left to him by the state for his defense of this case and another $600,000 for his defense of the fraud case. So that's where I understand that they didn't disgorge all his assets, but that they left him with that much to defend himself in these lawsuits. So I don't know if that's accurate. That was just like some user in the chat said earlier. IWD, new member. This is not your first time. But, you know, once you go Logic, you can't go back. Lancelot, oh no, we got this one. Does Sledge show up in the short buses? That's not nice. Professor of Logic, they said automated. That's the key. Alex attaches a rifle to a Roomba. Since they suck at directions, took out Paul accidentally. Wife was the target. That's pretty funny. Christopher Violante. Prosecutors show just how far a criminal side of our system has strayed from a goal of justice. To them, dollars spent need a guilty verdict, not justice.
No, I agree with that.
They're seeking scalps, not justice.
And this is a big problem with the criminal justice system across the board, and
Preach
that is
it.
that prosecutors have to be seekers of upholding the law and finding the truth. That is the job of the prosecutor. Uphold the law, find the truth, and uphold the law by playing fair and asking fair questions. The job is not to advocate for guilt. That is not the job of the prosecutor. If they present a fair case and protect the defendant's rights, they are protecting the laws for all of us, just like if the person's found not guilty or guilty, they really shouldn't have a dog in that fight. It's not an ego contest. It's not about the prosecutors getting their way and getting a win and getting a scalp. The job of the prosecutor, let's be clear, is to uphold the law in all ways, in all parts of the thing, being fair, being trying. The advocate is the defense attorney. That person is to hold the prosecutor to their standard and to make sure the defendant's rights are protected. But the prosecutor also has to protect the rights of the defendant because the defendant's also a citizen. So this whole cheating game has got to go. Rant over.
Did you write an article on that?
I did. It's in my first book, Ideas and Answers in Law. It's all about the prosecutorial function. And in fact, I'm not against prosecutors. I add the first part of that article is how to conduct an effective prosecution, a fair and ethical prosecution. That is the first part of the article.
Indeed. Matthew Self says, yo, I made you a cage overlay you can use. Check out Locals. I think you'll need the original file for it to be transparent background. Thank you.
Oh, by the way, can I add one little addendum to that? This isn't Gosney preaching. All right. I know people think I'm preaching. And okay, in some ways I am. This is the U.S.
American law. That was American law preaching.
It's like the U.S. Supreme Court and the American Prosecutorial Association, all of the prosecutor organizations, that is what they say.
It wasn't him screaming. That was your great-grandparents on the battlefields of Gettysburg there screaming. That was your great-great-grandparents fighting at Concord and Lexington who was screaming at you. That's what that was. That's not Steve Gosney. He didn't invent that. He created it. He's just reminding you of what your grandparents, great-grandparents, and great-grandparents all knew, and somewhere along the way, our American education system decided to stop teaching you.
God bless America. All right. Fire it up.
Gates of Above says, is this prosecutor also getting paid 15% less than the men too? Do you think we're witnessing the South Carolina gossip culture in this court? I think the fact that we have a trial is the South Carolina gossip in this court. That's why we're here. Tish Tennessee, Joe, you know I adore you, but your Southern accent needs work.
I know you guys shouldn't be. I'm the Southerner here. You guys are abusing us Southerners. I told
on Civil Law 3 weeks ago that his hook into this trial is to spend the entire time talking like a Southerner. That would have been his hook, but no one takes my advice seriously, except you, who changed to SteveGosney.locals.com.
How about one day, man? I was effective.
That was great. Great job, you.
Thank you.
It's good you grabbed it before anyone else did. That was good.
Yeah. Here it is. The National District Attorneys Association Rule 6.1 or 4.2. Look at that. I mean, see, I'm citing prosecutorial professional organizations when I'm preaching. I'm not preaching, like, this isn't just Gosney. This is the authority. This is the Supreme Court. This is the Association of Prosecutors that says this is how they should obey. And they all disobey it. Ugh. Sorry.
I knew it was going to be gold. That's why I let you fill the screen. Slick says, suing railroads is easy in South Carolina low country. That's what built the Murdaugh film. Oh, I didn't know that. Delisandro, when you welcome James from court, I'm out. Reasons. Really? He's too young, no experience, young and biased. Then you call him your brother with respect. Ew. Okay, so I want to be clear. I use the term my brother loosely because I have respect for human beings. It's really that simple. And I feel like if you trace back far enough, we're all brothers. So I think that it's a level of display of respect when I do that. And that's why, unless the person is completely, slimy, scummy, I'm going to refer to the person as my brother. And that's, technically, I guess that slimy, scummy person is also a brother, but I'm not looking to afford that respect. So yeah, I'm going to refer to anyone that way. And I don't know if you would have stayed and paid attention to the nature of the questions that I was asking James from court when he's here by lunch. And there was zero jury analysis. I was simply having a conversation with him about the buzz around the courtroom and the nature of what people are taking away from this trial, what the overall flavor is. And I do think that adds perspective that you and I cannot have. And he's sitting there as a layperson. I wonder, when he sees testimony, does it strike him as helping the defense or helping the state? And sometimes he's told me it's helped the state, and sometimes he's told me he thought it helped the defense. And I think that's sitting in the courtroom. I know how it feels to me when I'm watching on a video. I'm not saying that he has particular training or experience or unique insight, other than the fact that he puts himself in a place where he's able to have a perspective that you and I do not have. So I think that has value. So it's not. I don't tend to give him like 45 minutes. I'll usually spend like 10, 15 minutes with him maximum, and then I'll send him on his way. And I appreciate the input because I think it does give us some insight. But I understand it's not for everyone. DCV Titan, prosecution, you were like family. Yes. So how much did Alex steal from you? Which is all true. And I think that was biting. I think that was a good line of attack. You were like family. So how much did Alex steal from you? Meaning and I think that part of the reason that was effective and so biting for the defense is it shows he's willing to snap at his own family. I mean, because this lawyer who got up and testified this morning, and he's like, saying that he thought of Alex like being like family, and Alex is stealing from him. So you see that he can turn on his own family. Now, does that mean he would kill? No, but it does display a certain level of self-interest and lack of respect for people who are close to you that benefits the state to display to the jury. So, again, obviously, I think that I don't think he killed him, and I don't think the state proved anything. But as far as them scoring points, you have to recognize where they do that. Grimwolf, I still think the housekeeper did it. The way she said the family made comments about other races. How tall is she? It was the 81-year-old housekeeper. DCB Time, they're going to attack her memory over that date. No, they didn't. Jonathan Riggins, she seems like a sweet woman. I know she will connect with a lot of the jury after going to the trial. I would guess she is Gullah. What's Gullah? I don't know. MS Krim, defense couldn't fix line 28 in seconds, and apparently they couldn't. It really bothers me that they say 4 minutes, that he went 280 steps, and the time is like 9:06 and 12 to 9:02 and 12 seconds to 9:06 and 49 seconds. And I'm like, that's 4.5 minutes. That's not 4 minutes. And nobody, not once. And then they say that's 240 seconds. And you're like, how do you come up? 240 seconds is exactly 4 minutes. How do you come up with 240 seconds? Like, where's your calculation here? On like the most critical one, and he even zeroed in on it. And not once did they correct and say, hey, why is the state trying to shorten the amount of time here in order to jack up the rate? And they never once pointed out how shady the state was being. It really bugs me. It was really bugging me. Not once did the defense bring this up. Congrats again, Grandpa Joe. Thank you, Melissa. Enjoy your time tomorrow unbreaded. Chris,
Unbreaded. That's great.
thank you so much for the.
Don't we
the
all miss?
super chat.
Don't we kind of miss Nick though? I mean, Nick and his
Who?
unbreaded and all.
Oh,
Listen, Joe. Yeah, you're not missing him. You're like cashing in. But no, I mean, we're going to be out in Vegas. I'm going to see you in Vegas. Anybody who wants to come meet?
I can't tell you how badly how I really am. I'm very bummed about not being able to go to Vegas, but it's. I wish I could have.
Somebody's got to hold up the grifting end, and you're hitting. You just got a gold, man. You just got the beautiful trial handed right in your lap in the best part of the trial, man.
That's true.
How lucky are you, though?
That's true. That's true. You know, I'm going to tell you something. So, a large part of the reason that I'm not going to Vegas is it would really bother the wife. She's like, she hates Vegas. She thinks it's slimy, it's scuzzy, and she's like, I just don't like the whole thing. And in general, she doesn't like the idea of so much about this whole thing. And so when I was trying to pitch it to her, I was like, you know, this is something that's developing my business. I have to recognize this is like I'm going to be in and out of there, and I'm just going to be hanging out with, you know, Nick and Steve and Andrew and, you know, assorted folks like that. And, you know, and I was trying to sell her on the financial benefits of it. And the thing is, to be fair, on Monday alone, which I would not be able to stream if I went to Vegas, I'll probably make more than I would have if I went to Vegas. It stinks when she's right. It really stinks.
Right. Well, my wife's coming with me. So she'll be with me, and
I would have happily taken her, but she couldn't come. She didn't have time. I've taken her
Vegas is not I'm not a gambler at all. I mean, we when my honeymoon, I went to Sedona, Arizona, which is beautiful, but we flew into Vegas because they subsidize their airport, so you get cheap flights. And so we flew into Vegas, and I remember to this day, I still remember losing change on I said, well, I got some change. I'll put it in there, and I put it in, and it bothers me that I lost that quarter, right? I mean, it's ridiculous, but so that's how bad I'm such a bad gambler, because I was like, I know I'm going to lose. And it bothers me when I lose money on something stupid that's a statistic. Like, you know what the funny...
You want to talk about statistics? Statistics. Yes. My statistics in Vegas. I was in Vegas this summer on the way back from L.A. We stopped overnight, and we had a layover in Vegas for 12 hours. I said, you know what we're going to do? We're going to rent a car, because it's cheaper than taking Uber from one spot to another. And we'll rent a car and for like, you know, a day, and it'll pay like $80 for that. And then just basically go down to the Strip and hang out there and do some gambling or whatever. And she's like, so she looks at me and she's like, all right, so what's your gambling budget? I was like, I don't know. I'm not going to spend a lot, but a few $100, $300-$400, like, no, you know, nothing. And she's like, okay, fine. I said, it's the entertainment, you know, it's like nothing. She's like, okay, fine. We go into a casino, okay, blackjack table. So I buy myself like 300 in chips, and boom, 25, lose. 25, lose. 25, lose. 25, lose. Every time I'm getting 13, 14, and I'm like, what are you kidding me? And if I stand, it's like I'm facing every time a face card or an ace, and I'm like, this is the stupidest thing. I literally played 16 hands and went 0 for 16. It's not possible. And like the dealers even look at me like, I'm sorry. And I'm like, what are you kidding me? This is ridiculous. Like I changed to a different table, and then when I went to a different one and went for like 0 for 6, and I was like,
dark cloud follows you around.
I was like, this is insanity. Yeah, so I was like, forget it. I was all right.
Here's an interesting little thing. Did you know that the worst convention that Las Vegas has ever seen for money, bringing in money on the gambling casinos, was the Mathematicians Association? Because none of them, I'm not playing those odds. Forget it.
Yeah, whatever. You know what? I looked at it. It's entertainment budget, and it is what it is. This way I could say I gambled in Vegas, and oh my God, I literally to not win one hand? It's not possible. It's impossible. I tried like upping it to like, you know, like $40 this one. I was like trying like, and 15 bet, nothing. It was just unbelievable. I literally lost every single hand. Chris Timberlake says the witness is wrong. GPS icon isn't displayed with GPS is written. It's displayed when an application requests GPS. It can display with signal. I don't think he was wrong.
It's so confused. This is the problem with this testimony. The state said that we're going to be convinced that he did it based on the phone. Remember, that was the opening?
Mm-hmm.
That they're putting everything on this phone data. Well, it ain't there, buddy.
All right. I'm at the court eating mac and cheese from food trucks. Cool. Cool. Woody says, damn, when they said, "Hi, hey, Siri," I was hoping a bunch of phones in the courtroom woke up. Would have been funny. Slick says, wasn't Mixon the same one Alec bought drugs from? What, the woman? Alec bought drugs? No, that was Smith. That was cousin Eddie Smith. I'm not sure what that's about. Joe, please explain what happens at Brisk for the chat. Miles is popping his own.
No, we don't need to do that. But Mazel Tov anyway.
It's a circumcision. That's what it is. But thank you.
But yeah. it's a mark. It's a mark of manhood for your boyhood, I should say. A mark of bringing him into the faith. Are you Orthodox or are you?
Yeah,
okay.
I'm an Orthodox Jew. Yeah. So no, it's a privilege. That's what it is. Gage filed a suit against Kyle. Also, the Huber family filed a suit as well. I'll tell you this: the Gage suit, I think, is a joke. I think the Huber suit is not as big a joke. Because Anthony Huber is dead and didn't get on the stand and admit that he was pulling the gun away. But I don't know. Anthony Huber is the skateboarder who hit him over the back of the head with a skateboard and tried cracking him over the head, knocking him to the ground. And then when he was on the ground, tried grabbing the gun from Rittenhouse. And Rittenhouse fired, and the shot went into his chest, and he died before he hit the ground. So, I think that's a loser too. And the reason I think that's a loser is because if you're grabbing someone's gun, that's as if you have a gun in your hand. So he's got self-defense. Am I correct about that? That's what I recall from the Rittenhouse trial. I think it's one of the first conversations I ever had with Andrew Branca. He's like, if you and someone else are both grabbing a gun, it's as if you're both holding that gun, and each one has a defensive right, has a right to kill the other in self-defense.
Well, you got to be very careful. It's facts, all right. But I will say that it's very fact dependent. It's like, when can I kill you? But one thing that a lot of prosecutors fail to understand is that when a gun is involved and the attacker understands that both parties are basically deemed, are de facto armed. So, this is a lot of people say, well, anytime you shoot an unarmed person, you're guilty. You can't raise self-defense because you're using deadly force against a non-deadly threat. But if you are armed and the other person is aware that you are armed, they can disarm you and use your own. Cops know this because cops, are oftentimes disarmed and killed with their own guns, and they're taught about why, use of force law. So you got to be very careful with that. But prosecutors, they don't care. It's like, you shot an unarmed man, and they can get up there and play their theatrical game.
Yeah.
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 Although they should be enforcing the law, as we talked about earlier.
Hashtag in my pants says 1.25 speed Carolina equals 0.5 New Jersey. Happy birthday, subscribe. Thank you very much. Speaking of the 1 1/4 speed that I was talking about, where's my poll at? Yeah, okay. The poll is saying beginning play at 1 1/4 6139 over instead of starting wherever trial is up to. So I'm going to do that.
Yeah, I've been listening at 2 times speed, and I find that the southern drawl is greatly alleviated by the quicker speed.
Yeah, I actually liked listening to it at 1 1/4, especially when the expert was giving his creds. I was like, oh my God, this is 1 1/4 is way better.
Yeah, that's whenever the experts get up there and they start talking. So you got this, that's the time to go to the restroom.
Yeah. Yeah, it really is. Cards96 says, answer your mob hit theory, Joe. Paul and Maggie could have been held hostage at 8:49. I'm not sure what happened.
See, I'm not bought into the mob hit theory, but I recognize it doesn't matter. If you think that that's reasonable, if that's a reasonable explanation, then he's not guilty.
Yeah, indeed. Launder Clips, how are you, brother? Steve, thoughts on the judge not ruling before Alex decides to take the stand because the scope of cross-examination. Joe shared the Snake box Branca comparison, please. Did you hear about Branca saying that?
I don't know about the snake box, but the earlier point I'm going to get into in depth. That's a very complex question involving multi-layers of theory that I will talk about tonight at 8 p.m. on Eastern Standard Time on my Rumble channel.
Right, and I'm not sure if you were there when I was talking about this with Andrew and Nick, but we were talking about the idea as to whether or not the testimony that cross-examined, he can be cross-examined, because this morning, those of you who haven't been here for the last 8.5 hours missed in the beginning, and shame on you. You missed in the day opened with an application made by the defense, and Jim Griffin made the application, and he said, we need to provide guidance to our client as to whether or not we think he should waive his Fifth Amendment right and take the stand. And part of what we're trying to calculate with respect to providing proper guidance is that we like to get a ruling that if the state were to try to cross-examine with respect to the financial crimes, that the court will not allow that because it's not something that's been established as a crime, and that it should not be something that should be admissible. So we're looking to the court to get a ruling on that. The judge turned back to Creighton Waters and said, how do you respond? And he was so ready for this question. He knew this question was coming from the day that this evidence was admitted. He knew that this issue would come up. He was citing statutes and case law and going on with like 2 or 3 different strong arguments. They're not weak arguments at all. Like legitimate arguments as to why it is that the financial that he should be entitled to cross-examine Alex Murdaugh. If Alex Murdaugh waives his right to plead the Fifth on this murder charge and takes the stand to defend the murder charge, that he should have the right to question him about the pending claims and the issues related to the financial. And he basically said it goes to motive. This court has already ruled it goes to motive, and shows a propensity for lying, so it's not unrelated crimes, and on and on. And he basically was, when he was citing, I think 609, like and different statutes and case law to go on and on to basically say they have a right to do this. Now, the reason that Creighton Waters wants to have that in there is because he doesn't want Alex to testify and build some sympathy for himself. B, he would love it if he testifies and he has a chance to pin him down on these financial things. Picture yourself if you're Alex Murdaugh. Picture yourself in this position. It's like you get up there and take the stand. You're asked about these financial crimes, which everybody on the planet who spent 30 seconds watching this trial is convinced you're totally guilty of. Are you going to deny it? In which case, why are you even taking the stand at all if you're denying it? Because you just shot all your credibility. Or, and arguably, you can get charged with perjury also. There's all sorts of potential problems. Are you going to admit to it? And then basically, you have no defense left. And when you get charged with these financial crimes, you're shot in the head this way or shot in the head that way. You're really completely screwed. So that's why he's like, I shouldn't be, because, and here's the thing. Normally, you can't just raise criminal charges against a defendant. So this is why everyone saw this coming, and the judge's response was, "Well, I'm not going to predetermine this. So we have to see what the questions are, and and then I'll give my answer then." And what Branca said is, he said, "What a son of a gun this judge is being. What a jerk he's being. This is what he's basically doing is he's like, I'm not going to tell you what's inside the box. There might be a snake in the box. There might not be a snake in the box. Stick your hand inside and then we'll find out."
I have a homework assignment for anybody who wants to hear about this more in my Rumble. Look up this and study it. It's called Hobson's Choice. Hobson's Choice.
That rings a bell.
Yes.
That rings a bell.
It's Hobson. Hobson's Choice. That's your homework. See you tonight at 8. Class.
Yeah, and I highly recommend you guys check out his stream tonight, because it sounds like it's going to be a really interesting It's gonna be a really interesting stream. It's gonna make you think and understand philosophy behind the law and what and how it applies to this trial. So, and I hold him with the deepest respect. So I can't recommend enough. Let's try to wrap this up here. Chris Clements, the brutality of it makes me think hit, not revenge. Fuzzy Sock says in body cam, he says he was at the kennels earlier. Yeah, but I don't know when he says that. I think when he said it, he was implying that he was at the kennels, went back to the house to get a gun, and then came back to the kennels. And then for the next 2 to 3 months, he says that the last time he saw them was when he was dozing off in his watching TV, and they went down to the kennels, which is not true. That's just an inaccurate statement. Carpe Deacon says, did his right to a speedy trial eliminate opportunity for change of venue? No, that wouldn't affect
well, when
that.
you say speedy trial, you say you're ready to go right now. So any motions that you have outstanding would have been resolved. So they basically are, if they hadn't had that resolved, did they file a motion for change of venue? I thought they did not.
I was not aware of whether or not such a file was motioned.
Yeah.
Such a motion was ever filed. Igor Slagathor says, did you all think that if he's found not guilty, the crime scene photos of his family might get leaked out of petty retaliation? I don't think so.
I don't know. Maybe. Why not?
I don't know. Who knows? It's not easy to leak that. I mean, who has access to it? Catherine, thank you so much for the super chat. Why? To punish him? So they're going to punish him by leaking pic photos of Paul's head vaporized?
Why not?
Why? What's the upside there? Like, I think they want scalps, not vengeance.
No,
like that's.
I'm not convinced.
She trusts you or not, you need to go. It's not a matter of trusting me. She does trust me. It's simply a matter of that she just feels. Well, first of all, I'm dealing with a ton of stuff and a family thing in general, but it's just like she's like the whole thing is just like it's gross. It's almost like I'm trying to figure out how to express this. I'm trying to figure out how to express this in a way that, if from outside my culture, you can understand it. Okay. I can't. NW Food Factory. You live in New York City. What could possibly be dirtier than that? Than that crap hole, seriously. Okay, I'm going to tell you what happened when we were in Vegas, besides losing 16 in a row. Okay? I'm going to share with you all what happened in Vegas. I know they say what happens in Vegas stays in Vegas. I'm going to share with you. We're sitting on a park bench. It was 103 degrees at 2 o'clock in the morning. It was so incredibly hot. It was summer. It was like the end of June, and it was incredibly hot. Every person who was walking by, every woman who was walking by, seriously looked like they were desperately hungry for attention by wearing nothing. Just strips of clothing, literally like strands of material that and it's falling off, and it's and looking drunk while you see all these pretty lights and these beautiful fountains, and she's like, there's so much beauty here and so much disgustingness. And right after she said that, we're sitting at this bench, we're outside this beautiful fountain, and literally a rat, there was bushes behind us, a rat ran out from the bushes, ran over our feet, and then ran back in. We were both like, oh my God, what the hell is that? And she's like, that's Vegas. That's Vegas. Everything's all beautiful around, and there's just like a rat running across your feet. That's Vegas. People vomit. People sleeping in their vomit. People sleeping in their vomit right next to these gorgeous fountains. It's like, she's like, it's like gross. She's like, I don't like the idea of you being in a place that's just gross. It's not a matter of oh, she thinks, oh, he's going to go there and he's going to do something with some woman. No, it's a matter of it's if you told me that, if she told me that she's going to go down to the trash and starts digging through piles of feces, I'd be like, ew, that's gross. I really don't want you doing that. That's to her what this is.
Well, so, I have the similar experience because when we went to, like I said, we've been to Vegas once in my honeymoon just to pass through. And we walk down the strip and it's like, whoa, look at that building. Isn't that amazing? And you go in what's in there? And you go in, it's like casino. And they're like, oh, look at this. Oh, it's a great building. Let's go there. Oh, it's a casino. And I was like, it's the promise and the facade is really pretty amazing. But if you don't gamble and you go inside, you're like,
it's
like, I'm not interested.
Oh my gosh. And I do gamble sometimes. Like I don't have a problem with gambling. I've been going down to AC a few times. It's not like that in AC. It's like they have their hotels, but it's not. I don't know why. It's like it was really beautiful and really gross. I've never seen anything like that. It was so weird. And I know that that's not a reflection of the residents of Vegas. That's the part that they want the tourists to go to. The residents of Vegas, I'm sure, are great people, phenomenal people.
We have,
you know what I'm saying?
Yes, actually, that's very true. A lot of the people that I had a friend I went to law school with, and
Yeah.
he was from Vegas, and he's like, we don't go to the Strip.
Yeah.
That's like, that's that thing. And then we have our own little town over here that does its thing and serves its people well. It's the Strip that we're talking about, the touristy part that we're talking about.
Yeah. Andrick says, after this trial research, Mark Middleton's death. 20,000 subs, easy. Mark Middleton's death. All right, let me look into Mark Middleton. Let me put a little thing here. I never even heard him.
Yeah, you get curious. That was the way to lure you in. 20,000 subs. So.
20,000 subs.
See, well, you know what I see? I see that, and I'm like, oh, more work. I got another case I got to look at.
Death of Clinton aide tied to Jeffrey Epstein ruled suicide. That happened today? Oh my gosh. Yeah, that happened today.
Okay.
Oh, I'm definitely going to be looking. No, wait, that's in. Mark Middleton 5. Sorry, no. Today, the mysterious death. Today was ruled a suicide. That's what it was. Okay. All right. Yeah, one of those. In my pants says, can't woke ortho Jewish women have a bris? Yeah, I guess. I sure, do it. You just, whatever it is that you think you're doing, have fun with it. It'll be just as meaningful as anything else you'll do. It's as meaningful as anything else you'll do that day.
Right.
CPT useless TV. Can't piss off the wife. Someone's got to drive you around. Thank you. That's true. I don't even remember what trial that came from, but I have faith you'll get it. I don't think it was a trial. It was just a stream that I guessed, and I admitted what I, to this day, think is one of the most base things I ever said. I was speaking truth. You know what? I'll bet you that Elon Musk never drives himself anywhere either. Driving is like what little kids think is cool, but after you've done it for more than 100,000 miles, you're like, I don't need to be the one doing this.
Yeah, my philosophy.
I'd rather be like streaming or like hanging out or watching videos while someone else is driving. I don't need to prove I can parallel park. I'm good.
I like driving, but my philosophy of driving is the objective of driving is to get from point A to point B as efficiently, as safely as possible. Everything else is just
right.
Fluff.
So it's like, you can enjoy doing the dishes too, I guess. You can enjoy mowing the lawn like a man. Like, oh, it's like is that like a sign? Like I'll tell you right now, she never has. I'm the only one who's ever mowed the lawn. But like, if I could have gotten her to mow the lawn, I mean, like, hell yeah. Why not? Why wouldn't I want to get? It's like, it's like I have to do this work in order to. Otherwise, no one's going to believe that I have testosterone. I think people will believe it. I think people believe it, even if I don't actually do the physical labor associated with it. I don't know. It's just me. Wow. If I take out the garbage, now people know I'm a man. Stogies and boomsticks. To the chatter that had issue with James McCord, how is he supposed to get experience if he won't listen because he doesn't have any? Yeah, I agree with you. I think people are they're unfairly harsh. And Sarah Lay says she's right. I think referring to the wife. Professor Logic, watching The Housekeeper now on catch up. Is it possible the judge doesn't like Alex because he owned his family until the night of the murders? Oh my God. No. Slick556 video played on February 16th. Alex said he got pills on occasion from Barbara Mixon. Why didn't prosecution use this on cross? I don't know. Did he really say that? I didn't remember that he said that. That she's a dealer? Really? That old lady is a dealer?
I don't remember that.
Yeah. I don't know. Legal name, Mr. Gosney. In Texas, a man named Tanner Horner is looking at the death penalty. Care to look into this for your own homework? I'm curious.
No, I'm not interested. I don't want to look at other stuff. I have a real job, and I don't like my real job involves looking at death penalty cases and taking cases and actually dealing. On my time off, I don't really want to look at some of the other cases. I'm doing this because I have my books that I want you to buy and support, and that's why I got involved in all this whole thing. That's the only grift that I have is my books, and I don't want more homework. But thank you. But no, these guys here, they'll take all the subscriptions and all that. But anyways, I actually am enjoying that. I like the social aspect. It's neat, like meeting you and meeting Nick and meeting.
Yeah, it's
Andrew.
fun. It's cool.
I mean, it is fun. It's like a hobby, and I'm meeting some farmhand Tom is like a new good friend of mine.
The first time I met Viva Fry, like I started my channel because I was inspired by his channel, and I'm like, holy cow, I'm on a stream with freaking Viva Fry. That's so freaking cool.
I think Viva Fry should have me on. Hey, that's one of my goals. I haven't seen I sent an email one time a long ago, but he should have me on to talk about my book or something, don't you think?
Well, you see, you have to know, you don't pitch. That's not how you pitch it. Your marketing stinks.
I know it does.
Your marketing is so bad.
It is. I know.
Your product is so great, and your marketing is so terrible.
I know it's terrible.
Viva, have me on so I could pitch my grift. No, that's not how you sell it to anyone. That's not how you sell it. No one says, "Oh, yay, I'm going to be able to let someone sling their hash." No, that's not how you. No.
Well,
you
I don't know. I'm just being honest with you. I'm just talking between me and you.
If no one else is listening.
Nobody else is just me and you.
Right. Okay. So basically, what you need to do is you need to scout out exactly what it is that he's where he's headed, and then get ahead of him so that you can provide useful content for him.
I'm not going to do that. That's too much work. I got too much other stuff to do.
I'm telling you.
I know, but I don't really care. I mean,
you have to, if you can predict where they're going and get there before them, then you'd be like, hey, let me help you get here.
I'll just hang here with my buddies.
All right.
All my buddies in chat.
Well, we appreciate you. Catherine Whalen says, watching from Ireland brought Steve's book before Christmas and said in an email that I'd love to see him on one of your streams, Joe, and hear wishes come true.
There we go.
So there you go. $20, I'll teach you to win at craps. See, no, I don't buy it. And here's why. Because if you're good at craps, why would you need my $20? You don't need my $20. You just win it at craps. So I see through you. So, anyway, I think that covers it. I think we are good.
That's it, really? This was fun, man. You got the meat and potatoes of this trial, baby.
I have a great audience, a great trial. Again, those of you who join late, I'm going to be starting tomorrow, probably around 10:30, 11 o'clock. If you want to start on time, you can watch with Legal Vices. He's going to be streaming. And I'm going to be streaming at 1 1/4 speed starting at like 10:30, 11. As soon as I get back here from my little celebration there, I'm going to be jumping in here and running through the trial. And I expect to catch up before the day ends. So, because I'll skip through some of the lunch breaks and, and move things along. I don't know if I'm going to be by myself. I'm likely going to be streaming by myself. I'll send links out to other people, but it'll be so it might be a little bit different tomorrow. But one of the things I find when I stream on my own is that I actually talk a lot more than I do if I'm sitting even on this stream here, my own channel with like one or two other people. I'm way more quiet, and there's a lot of things that are going through my head, which are why that is. And I think it's mostly that I feel like if I start making like a whole conversational type of thing, I'm encouraging the other person to do that. And then we're not going to hear the trial, and then we'll start having a dialogue and people are going to be upset and whatever. Whereas I can like sort of interject and overtalk slightly the testimony without worrying that I'm going to get annoyed by a guest doing something similar. So I sort of feel freer, because I'm not worried about that I'm encouraging something I feel is going to be damaging the product. So I'll probably be more talkative and by myself much of the day tomorrow. So, but I will send you an invite, because I definitely welcome your perspective and you're a smart guy. So
thank you. And I really loved it. You got a great. This This is a lot of fun. It's an interesting trial, and you guys don't want to miss the next couple days because this is the
amen. This is the cream. We're getting the center of the donut. That's where we're getting. Now we're reaching the center of the donut. Oh, so one more thing. Excuse me. Please hit like and subscribe. Follow him as well. I usually stream at 10 o'clock Eastern. I do not expect to stream tonight. I'm not going to be streaming tonight.
I will.
So, yeah,
Rumble. 8 p.m.
Go check him out at 8 p.m. Head on over there. I thank you all for joining me. Take care of yourselves, and I'll see you tomorrow morning somewhere between 10:30 and 11 a.m. Till then, take care of yourselves, and as always, Godspeed.